मैं तो सोच रहा जैसे एक झोली लेके बैठो उसमें सेकंड डालो मेरे को 2-2 लाख रुपए रिकवरी हो जाएगी।
Members are requested to take their seats. A very good morning to all of you. Friends, ladies and gentlemen, today is a great day in the history of our group. Our group is going to organize second GST Moot Tribunal. After the success of first one, it's a great day for all of us. As you know, this Moot Tribunal is live on YouTube. The world is watching you. So, we are fortunate to be part of this. We have some prominent personalities among us, and I will request Shri Praveen Khandelwal ji to come on the dais, and I request SV sir to escort him. I request CK Gupta ji to escort Shri Prakash Kumar ji on the dais. I request Rajmani Jindal ji to escort Bhatia ji on the dais. CK Gupta ji, please join on the dais. Rajmani ji, आप भी join कीजिए, please.
ये जी 2 नए कन्वीनर बनाए गए हैं, इसको जल्दी बुढ़ा ना हो जाए काम करने।
Friends, before we start our Moot Tribunal, it's time to welcome our guest. So, I don't know what is in store in the sleeves of SV sir. So, without wasting my time, I request SV sir.
The first hour is very emotional. There is no legal discussion here. It may be the first time in the history of this country. What you're going to witness today, you may have never ever witnessed in your life. Maybe you will never witness again. As I rise today to speak, my legs are shaking. My language may falter. I'm short of words. Because a person I'm going to describe you today, he cannot be described in words. We call him a living legend, Mr. S.C. Bhatia. It's not a show of business, nor he requires any marketing. But as a group, as per our reports, as per advice of our chairman, we want younger generation to have a sense of gratitude to people who have mentored them, who have taught them, who have, imprisoned us in their love, in their honor, and they have seen us grow. Many of us have lived under his umbrella, which is very big heart he has. Therefore, let's stand up and welcome Shri S.C. Bhatia sir. Yes, friends, today I speak about Shri S.C. Bhatia sir, who has been a teacher, guru, mentor for all of us for the last 5 decades. he's a student in a college. At that time, we were students, we didn't care much. But when I also happened to join this practice accidentally, I never wanted to be a lawyer. And then I realized what I am up to. I may not have expressed my feelings to whomever out of egos or out of ignorance. But today when I look back and see what this man has done for this tax community, for all of us, is something I will tell you, it is beyond imagination. This group is his creation. Along with his friend, my best friend, his best buddy, Raj Batra, we created this group. And Mr. Bhatia's mandate to all of us was to continue the education spread and train youngsters without any discrimination. That is, without discriminating between advocates, chartered accountants, company secretaries, or other professionals. And we tell you, sir, we have continued. I'm sorry. As a person, as a group, there is no prize or award or praise that we can give him to resonate with his contribution in our lives. Still, the core team of this group, headed by Shri Praveen Khandelwal, under his guidance, have risked our choice to celebrate your personal, professional, and social life. I know, we all know endless cases in our bar for last 5 decades where your efforts helped save lives of people. If you come to know that somebody has a cancer or a kidney failure, he took the lead, collected lakhs of rupees, ensured the person was saved. Whether he was to go to Bombay or Calcutta for anywhere for treatment, we were directed to help them. And we all together in Sales Tax Bar helped his efforts. And our kids, at least my kids, they have grown with his name. My daughter Sheetal was mentored by him for last 10, 11 years in the beginning, where he gave, without ever meeting her, on every Diwali, some gold piece of gift that she still has intact. And that is the life which he has created. That's what we all should learn. After 20 years, people should talk about us like this. Okay, yes, we are Mr. S.C. Bhatia's legacy, and we shall continue it with more vigor and more effort. As professionals, we learn the legal principles which English people gave us, common law jurisprudence. But in S.C. Bhatia, we learned life's jurisprudence. What is life about? He is not a man who is like us, who shows off, who drives fancy cars or wear designer clothes, watches, or shows off his money or shows off his knowledge. His humility, his humbleness, his kindness is par excellence. I have not experienced a person in my whole life, including my own family, who has been so kind and lovable, even to people who in politics were his opposition. He has never discriminated. The second person I know in this is Mr. Praveen Khandelwal, who comes here and guides us every time out of whatever time he can take off for us. You know, even for this Moot Tribunal, I'm sharing something very personal. He goes to Chitrakoot. He's a very avid worshipper of Lord Ram. He told me, send me files. I would like to spend time reading files in Chitrakoot so that we can guide people. That is the passion this man has for all of us. Such passion, zeal, and perseverance is the rarest of rare that he is teaching all of us. Sir, a very big salute to you. For teaching us commitment and passion and profession in law. His integrity, I have lived with. That's why I tell with pride, I don't bribe people ever. This I've learned from him. Life doesn't give you guarantees. Don't expect. You cannot stop a flow of the river. That will be unnatural. But what life teaches you is get ready for the storms which you can't see. Subtle love, passion. He taught us work hard, you can do it. And here I am in front of you, I have done it. I feel very proud of you, sir. We were under your mentorship. You know, we have Mr. Praveen Khandelwal, our chairman. I spoke to him early morning around 6 o'clock, around a week ago, we want to do this. He also choked. This is one of the best ideas you're going to circulate in the country. Our seniors we must feel grateful to them. And he told me that you do it so very well that people cherish this memory forever. And sir, I think we are doing that way. And to celebrate this day, our team has constructed some utility backpacks. Can you show this bag on screen, please? When you carry this bag, see the message in the front. The same message which you have here. You know, when you carry Hanuman Chalisa, Ramchari Chalisa in your pocket, so when you carry this bag, this man's blessings shall be with you forever. Never ever lose this bag. This is not a money question. It carries emotions of hundreds of professionals who designed it. And together we all of us, we are going to give CGST Bhatia a Lifetime Achievement Award from, and he deserves a standing ovation. The clap should deafen his ears. Let's continue to clap for him. And this is the message I would like to give to all the youngsters. Try to follow this part. Hard work is difficult. It will last very long till end. I am 69. He is approaching 80. Our hard work has not let us down. We have made more money than most of the people who bribe. At least I have made much more money. And that's hard work. And that's what we want to teach from this group. The ethos, passion, and knowledge. This group will continue, and we have a clear direction from our chairman, Mr. Khandelwal, that this tribunals or this work must never stop, come what may. That's the message Mr. Khandelwal has given us. So, S.C. Bhatia, sir, we all bow down before you today for all, and we love you. Thank you.
What an emotional speech this was.
Okay, thank you.
Mentor Shri S.C. Bhatia ji. C. Rajesh Jain ji and C. Rashmi Jain ji to present a Tulsi plant to our own Chief Patron-in-Chief, Shri Praveen Khandelwal.
नेट रुकाता है ना कई बार नेट की स्पीड जाती है ना अभी गया था एक बार फिर आया था अभी नहीं उठेगा
I request Dr. Rahul Kakad and C. Renu Sharma ji to present a Tulsi plant to Vikas ji. Before I request Rajmani Jindal ji to speak few words, I request SV sir, Rajmani Jindal ji and Dr. Rakesh Kumar ji to present a short to SV Patil ji.
Friends, I know I have hijacked the podium from our convener, Narender. So I'll take 20 seconds only. Well, I think we all know who's being presented with the achievement today, a lifetime achievement, a living legend, which is written in the front of you in the screens. Well, friends, with all due respect, I know what I exactly know you have got the message. So just to do a pratha, just to say thank you. तुझे देखकर मुझे वो इंसान नजर आता है, मुझको तो एक आदमी में भगवान नजर आता है। तेरा नूर इतना खास है, तेरा नूर इतना खास है कि होके मजबूर तू एक सच्चा इंसानियत का मजदूर नजर आता है। Thank you, sir, for being a part of our life.
So I request Rajmani Jindal ji to say few words.
Respected Rakesh Kumar ji, respected my Guru S.C. Bhaji ji, and respected my mentor and Guru as well, S.V. sir. It's absolute honor and privilege to stand before you today to speak about someone who has not only shaped my professional journey, but also deeply impacted my personal growth, my Guru, my mentor, and a distinguished advocate and a tax professional, an exceptional human being, Shri S.C. Bhatia sir. Or SCB, as SCB sir says, you all know, SCB. In every field, we come across experts, but it's rare to meet someone who combines professional excellence with a kind of humility, apathy, and commitment to others that he demonstrates in everyday life. He is just highly respected, not only a respected name in law and taxation, but a dedicated mentor who has consistently invested his time and energy in nurturing the next generation. Through the initiative Grooming the Young, he has gone far beyond his professional duties. He has helped to create a space where young minds can learn, grow, and find their footing in the often daunting world of law and advocacy. Sir, his guidance in this group has benefited who does not just lead the way, but walks with us patiently, purposefully, and passionately. As an advocate, SV sir brings to the table a brilliance that is unmatched. His knowledge of law is profound, but it is with compassion and integrity that truly sets him apart. He reminds us the intellect behind humility without humility is hollow, and that justice without humanity is incomplete. He teaches us not just by words, but by example. In his presence, we are inspired to aim higher, think deeper, and serve better. His vision has never been about creating followers, it's about creating leaders. And today, many of us stand as better professionals and better people because of him, only because of him. SB sir, you are not just the founder of this group, you are our foundation. Your legacy is not only in the group you established, but in the lives you have touched, the values you have instilled, and the dreams you have helped us believe in. Thank you very much, sir, for our mentor, our guru, our guide, and most of us, our inspiration. With deepest respect and heartfelt gratitude, I bow down, sir. I bow down.
Thank you, thank you, thank you. हाँ जी, आज इमोशंस की बरसात ज़्यादा हो रही है. Someone has car number 6879. कार नंबर 6879 उनके गेट के आगे खड़ी है, जरा प्लीज हटा लीजिएगा. नाउ आई रिक्वेस्ट बीवी दीवान सर टू से फ्यू वर्ड्स अबाउट आवर मेंटर श्री एस.सी. भाटिया जी. आइए सर, आज इमोशंस आने दीजिए.
सही बात. Honorable Shri Praveen Khandelwal ji, our Patron-in-Chief and Member Parliament, श्री प्रकाश कुमार जी, हमारे पूर्व कमिश्नर, हमारे बैठ के जब हमारे थे, आज अपने परिवार के बीच में हैं, और आदरणीय श्री एस.वी. सर जी, श्री आदरणीय श्री हरीशचंद भाटिया जी, हमारे प्रेरणा स्रोत, और हमारे दिल्ली से बाहर से आए हुए हमारे सारे डेलीगेट्स, पंजाब, हरियाणा और फरीदाबाद, यूपी, सबसे हमारे बाहर से आए हुए डेलीगेट्स, और हमारे रिस्पेक्टेड जीएसटी प्रोफेशनल ग्रुप के सब मेंबर्स. साथियों, आज जीएसटी दिल्ली जीएसटी प्रोफेशनल ग्रुप का ये 65 हमारा ये सेमिनार है, और जो सेकंड जीएसटी मूट ट्रिब्यूनल का जो हमारी ये प्रेरणा हमारी हमको यहाँ से मिली है, ये सेकंड मूट ट्रिब्यूनल का आज एक स्वागत है. और आज हम दिल्ली जीएसटी प्रोफेशनल ग्रुप्स के द्वारा यही डिसाइड किया गया कि जो हमारे प्रेरणा स्रोत माननीय श्री हरीशचंद भाटिया जी हैं, उनको एक लाइफ टाइम अचीवमेंट से हम सब सम्मानित करें. इससे पहले हमारे एसपी सर ने, राजमणि जिंदल ने भाटिया साहब के बारे में बहुत कुछ बोला. उसमें कोई शक नहीं कि उसके अंदर अभी भी कुछ ना कुछ कमी रह गई होंगी, लेकिन उनके लिए हम जो भी बोले कम है. और साथियों, आज हम सब यहाँ एक ऐसे महान व्यक्ति को सम्मानित करने के लिए एकत्रित हुए जिन्होंने अपने ज्ञान और योगदान से हमेशा टैक्स प्रोफेशनल को हमेशा एक समृद्ध बनाया है. किसी की भी कोई शिकायत हो, किसी का कोई भी काम अटका हो, और उस काम को इन्होंने पूरा करके दिखाया है. आज यही महीना है, हमारे राज के बत्रा जी हमें छोड़कर चले गए थे. राज के बत्रा जी, हरीशचंद भाटिया जी और सुशील वर्मा सर हमारे, ये उन्हीं की प्रेरणा स्रोत है कि आज हम ये 66 ये सेमिनार जो ये अपने जो ये ग्रुप का ये सेमिनार हर महीने कर रहे हैं. ये उन्हीं का ही आशीर्वाद है कि हम इसको और डे बाय डे आगे ही बढ़ा रहे हैं, और ये आगे बढ़ता रहेगा. ऐसा हमारे एसपी सर और बाकी सब हमारे उनका ये एक पूरा एक ठाना हुआ है कि हमने इसको और आगे लेके जाना है. साथियों, कि जैसे कि हम जब बता रहे हैं कि हम आदरणीय हरीशचंद भाटिया जी, उनकी विद्वानता और निष्ठा हमें यह सिखाती है कि सच्ची सहायता ही समर्पण में है। हमें गर्व है कि आज हमारे बीच में एक ऐसे प्रतिभाशाली और निष्ठावान व्यक्ति हैं। आइए आज हम सब मिलकर आदरणीय श्री हरीशचंद्र भाटिया जी का कि उनके योगदान के लिए धन्यवाद दें और उनके एक उज्जवल भविष्य की कामना करें, और हमारी जो नई पीढ़ी है उनसे यही सीखें और आगे मेहनत की ओर बढ़े और आगे कामयाबियों की तरह बढ़े। इन्हीं दो शब्दों के साथ मैं आपका धन्यवाद करता हूं और आगे की कार्रवाई के लिए आहूजा जी को आमंत्रित करता हूं। धन्यवाद।
थैंक यू धवन सर। थैंक यू सर। प्रवीण जी ने जाना है इसलिए मैं सीधा प्रवीण जी को ही आमंत्रित करता हूँ। तो इसने सर आप इधर आएंगे वहीं से। तो इससे पहले कि मैं प्रवीण जी को आमंत्रित करूं, इट्स टाइम टू इन प्रेजेंट लाइफ टाइम अचीवमेंट अवार्ड टू आवर भाटिया जी। तो मैं सीधा रिक्वेस्ट करूंगा प्रवीण खंडेलवाल जी से पहले उन्हें एक मोमेंटो से सम्मानित करें। इसमें है और मुझे तो ना पता नहीं है, मुझे नहीं पता। मैंने सारी फोटो भेज दी। नहीं है, नहीं है मेरे पास। अभी एक गिफ्ट भाटिया जी के लिए वेट कर रहा है। तो तनिष्क आइए जरा।
जा रहे हो ये आप एसपी से एक्सपेक्ट कभी नहीं कर सकते। जो आप देखने जा रहे हो ये आप
पहले वो हाँ आगे ले आओ
आपको ऐसा गिफ्ट दे सकता है। मैं मतलब हमारा ग्रुप
हटा लो ना, कपड़ा हटा लो।
नहीं कपड़ा उठाएंगे कैसे? अनाउंसमेंट करो सब
हमारे ग्रुप से एक्सपेक्ट नहीं कर सकते।
Members are requested to be seated.
You can sit down, please. चार बंदे चाहिए भाई। Who is being facilitated like this and being given a constitution of India for the two stalwarts of this country.
आप भी आ जाओ सर।
She is the mother. She is proud. Sunita Ahuja.
आइए सर, आप आ जाओ, आ जाओ।
अहुजा जी आप भी आइए।
जल्दी आइए सर।
जल्दी आइए, विकास पड़ गई।
पलक तुसी इधर आ जाओ अहुजा जी।
Well, let's continue to clap for these two people. Well, take a photo like this and keep in your table always. And he gets a memento from Mr. Khandelwal as a remembrance of his first memento. Tiger!
When you are in court, roar like a tiger.
This is the bag which is being given to all the participants who have come here. And we have written, we all salute you SCB sir, an alchemist lawyer. The meaning of alchemist is, you give him a dust, he will convert dust into gold. Wow! That is the meaning of alchemist. And this he has proved over the years. I am an eyewitness to it, including me. So whenever you carry this backpack, it is not a backpack. We are all carrying his blessings with us. is the importance of this fact. Please never ever lose this fact. And tell your children they have to come to this stage where their name is written like this tomorrow. This you can do with integrity, honesty, hard work, and with care about people. Otherwise, nobody in the world writes like this about anybody nowadays. We're all very selfish people. So, Mr. Bhatia, sir, we are very grateful to you. May we touch your feet and seek your blessings forever. And may you bless us all. And now, आपको प्रेम खंडेलवाल जी को बनाना ना? ओके, आप अभी नहीं आपको बोले भाई आगे से आना मानना नहीं, नेताओं को हाथ नहीं बनाया। उनको आंसर देना है, मैं तो ना आंसर देना। हमारी ताकत ज्यादा में रोकी। धमकी दे रहे थे मैं 10 बजे चला जाऊंगा, मैं क्या होने को चाहिए।
फ्रेंड्स, हमारे बीच में काइंड अटेंशन प्लीज, हमारे बीच में एसोसिएशन ऑफ टैक्स लॉयर के सेक्रेटरी रजनीकांत वर्मा जी जो आगरा से चलकर आए हैं, प्रवीण खंडेलवाल जी को एक शॉल से सम्मानित करना चाहते हैं। आइए सर।
यूपी में सबसे कम सीटें आपकी आई थी, इसलिए हम आपका बेस बढ़ा रहे हैं अब यूपी में।
Sir, they have come from Agra.
Let's continue to clap for them. आपके क्या वो पल की माला
आ रही गाड़ी में रखी हुई पीछे सीट।
In the meantime, I request Praveen ji to say a few words.
आइए सर
before he goes.
आइए सर।
आज के इस बहुत ही शिष्ट और विशिष्ट कार्यक्रम में
सर ये भी वैसे चल गया।
सर यहाँ आ गए जी, जहाँ हमने भारतीय परंपरा को जीवित होते देखा है। हमारे परिवार के मुखिया आदरणीय श्री एच.सी. भाटिया जी का सम्मान हुआ। वो परिवार हमेशा समृद्ध होता है जो अपने बड़ों का आदर करता है, और ये हमारी संस्कृति और हमारी सभ्यता भी है। जब भाटिया जी का सम्मान हो रहा था, भाटिया जी बार बार रोक रहे थे, बहुत हो गया यार, कितना करोगे। भाटिया जी, एक पिता बहुत प्रसन्न होता है जब उसके पुत्र से उसको जाना जाता है। मुझे याद है पहले जब लोग मुझे जानते थे तो वो कहते थे ये प्रवीण खंडेलवाल विजय खंडेलवाल जी के सुपुत्र हैं। और एक मौका जीवन में ऐसा आया जब मेरे पिता ने मेरी पीठ थपथपाई और ये कहा कि आज मैं धन्य हो गया, आज मुझे एक व्यक्ति मिला और उसने कहा कि आप प्रवीण जी के पिता हैं। तो आज ये वही क्षण है कि ये पूरा ग्रुप आज राज बत्रा जी होते तो इस कार्यक्रम की बात ही कुछ और होती है, लेकिन राज बत्रा जहाँ भी हैं वो निश्चित रूप से बहुत प्रसन्न हो रहे होंगे। और मैं ये मानता हूँ कि आपको सम्मानित करके हमने आपको ही नहीं राज बत्रा जी को भी याद किया और हमने उनको भी सम्मानित किया। और ये परंपरा इस प्रोफेशनल सिस्टम में मैं पहली बार देख रहा हूं। सुशील जी जानते हैं और प्रकाश जी यहां पर बैठे हैं कि एक लंबा अरसा हो गया इस फ्रेटर्निटी में, इस फ्रेटर्निटी से लड़ते हुए, झगड़ते हुए, इनका सहयोग लेते हुए, लेकिन ये पहली बार देख रहा हूं कि एडवोकेट या चार्टर्ड अकाउंटेंट या प्रोफेशनल्स अपने परिवार के बड़ों का सम्मान कर रहे हैं। अक्सर प्रोफेशनल में ये ऐसा होता नहीं है और इसकी इस बड़ी सोच के लिए मैं मेरे मित्र सुशील वर्मा जी को बधाई देना चाहता हूँ। सुशील जी जीवन के उन सारे मापदंडों पर खरे उतरते हैं जिन मापदंडों के आधार पर आप सम्मानपूर्वक जीवन जी सकते हैं, ऐसा मैं मानता हूँ। और मैं इसलिए मानता हूँ क्योंकि मेरा और उनका लगभग 30 साल का साथ है। और यकीन मानिए सम्मानित आप हो रहे थे और इस हॉल में बैठे सब लोग ये समझ रहे थे कि सम्मानित वो हो रहे हैं। तो जिस भाव से, देखिए दो बातें हैं, एक तो होता है कि यार भाटिया जी को सम्मानित कर रहा है, एक उनके लिए शील्ड बना दो, एक ये कर दो, वो कर दो। ऐसे सम्मान भाटिया जी को नामालूम कितने मिले होंगे। लेकिन जो मैंने यहां पर अनुभव किया, यहां पर एक एक व्यक्ति ने अपने दिल से बोला है, दिल से बोला है, और वो अनुभव किया, वो ज्ञान आपसे जो भी प्राप्त किया उस ज्ञान के आधार पर कहा है। तो मुझे पूरा विश्वास है कि आज आपका दिल बहुत प्रसन्न होगा कि जो पौधा मैंने लगाया था, चाहे वो सुशील वर्मा हो, चाहे वो राजमणि जिंदल हो, चाहे वो और कोई भी हो, कि आज वो इस काबिल बन गए कि आपकी दी हुई शिक्षा को और आपके दिए हुए मार्गदर्शन को वो सार्थक कर रहे हैं। तो एक शिक्षक के रूप में भी आप मैं मेरा मानना है कि आप निश्चित रूप से आज बहुत प्रसन्न होंगे। और प्रभु ने बड़ी कृपा की है कि आपके ज्ञान को और आपकी शिक्षा को सार्थक किया है। पढ़ाई तो बहुत लोग करते हैं और पढ़ाते भी बहुत लोग हैं, लेकिन वो शिक्षक, वो पिता उस समय प्रसन्न होता है जब उसको दिखाई देता है कि मैंने जीवन में जो कुछ दिया वो किसी के काम आया। तो मेरी शिक्षा, मेरा ज्ञान और जो प्रभु ने मेरे जिम्मे काम लगाया था, मैंने उस काम को पूरा किया है। तो मैं आपको अपनी तरफ से भी नमन करता हूँ, आपको प्रणाम करता हूँ, आपका अभिवादन करता हूँ। और सुशील जी को इसलिए धन्यवाद दे रहा हूँ कि उन्होंने इस अति विशिष्ट कार्यक्रम में मुझे शामिल होने का मौका दिया। एक बार तो सुबह मुझे आया 9 बजे कि मैं सुशील जी को कहूँ कि मैं आऊँगा दिन में ज़रूर, लेकिन कब आऊँगा मुझे पता नहीं, क्योंकि मुझे मालूम है ये मेरी पार्लियामेंट की मेंबरशिप छुड़वा करके मानेंगे। मेरी आज 10:15 बजे से एक बहुत इंपॉर्टेंट पार्लियामेंट्री मीटिंग है, पार्लियामेंट में मुझे जाना है। मैंने इनको फ़ोन किया और इनसे आग्रह किया दोबारा आप जाओगे तो वो रिजेक्ट हो जाओगे, वो अट्रैक्शन नहीं रहेगा। मैं यहाँ मेरे ख्याल से 7वीं 8वीं बार आ गया। अब मुझे समझ में आ रहा है कि ये मुझे रिजेक्ट करें या सेलेक्ट करें, मैं हर कार्यक्रम में आऊँगा, ये नहीं बुलाएंगे मैं तब भी आऊँगा। तो एक बार फिर मैं आप सभी का हृदय से आभार व्यक्त करता हूँ मुझे सम्मान देने के लिए और आज के इस बहुत ही महत्वपूर्ण कार्यक्रम का साक्षी। ये मेरे लिए भी सौभाग्य है, मैं भी ये सीख लेकर के जा रहा हूँ कि हम अपनी कन्फेडरेशन में जो भी बड़े लोग जिनसे हमने कुछ सीखा, आने वाले समय में हम उनको अपनी तरफ से कुछ ना दें तो कम से कम सम्मान के 2 शब्द तो उनको दे दें। तो एसपी सर, आपको मैं सैल्यूट करता हूँ, आपका धन्यवाद है। मैं ये सीख करके जा रहा हूँ। अच्छा, आप बुरा मत मानो, एडवोकेट तो होते ही गुंडे हैं। और अगर इस देश में व्यापारी की दुर्दशा हुई है तो मैं अभी प्रकाश कुमार जी को बता रहा था, वो टैक्स एडवोकेट और चार्टर्ड अकाउंटेंट की वजह से गुंडा करते।
एक बार केजरीवाल ने बोला था, उसको हमने दोबारा बुलाया नहीं था।
नहीं, it is boss, it is all joke, not to be taken very seriously.
You know, let me close before Praveen ji goes. ये मैंने कहीं पढ़ा था, आई एम नॉट ए वेरी रिलीजियस पर्सन, आई डोंट गो टू टेम्पल्स। किसी बहुत बड़े महर्षि ने कोई प्रवचन कर रहे थे, वो बोले आप भगवान से हेल्प क्यों मांगते हो, भगवान नीचे आपकी आके डपी डालता है क्या आपको? हैव यू एवर सीन हिम फिजिकली? ही सेड नो। देन व्हाई द हेल यू टेल अस टू गो टू गॉड? ही सेज बिकॉज गॉड नोज व्हाट इज योर रिक्वायरमेंट, he guides you to a person, go and he will help you. So people like S.C. Bhatia are God's messengers for us.
Absolutely.
And this is where we are honoring him. This honor is not free. He earned it. Not because I am a student, I want to honor my teacher. I have many more teachers. He deserved this. Therefore, before Mr. Khandelwal goes, let's thank you very much. And I will always love you.
Thank you,
I wish
sir.
you are not my girlfriend. I would have left my wife for you.
I don't know whether it is my good luck or bad luck.
भाटिया जी की फोटो लगा।
होने दो, अब क्या है?
तेरे पास मूट ट्रिब्यूनल की फोटो है?
एक गाने का शेर
मैं पिछली बार थी। ढूंढनी पड़ी। बोलो मैं देता हूँ वीडियो।
भाटिया साहब के लिए, तुम्हें पाके हमने जहां पा लिया है, जमीन तो जमीन आसमां पा लिया है। Clap for him, a lifetime achievement award winner from all of us, not this group, from the entire tech community. We are honoring him today. God bless us. Thank you, sir. आपको कुछ जानना है? लंच के लिए लंच पे आ जाएंगे? आपको बोलना है, कुछ तो बोलना ही आपका। आपके बाद शुरू करें।
Just 2 minutes. मैं 5 मिनट।
2 मिनट नाटक तो आपसे भी करेंगे जी। आपने नाटक छोड़ देंगे, उनको जाना है जो मैं भेज दिया।
हाँ।
So I request।
माइक बंद हो गया।
तार निकल गया लगता है।
नहीं नहीं ये चल रहा है. ये दे दो.
अच्छा, हो गया. Hello. Now I request Shri S.C. Bhatia ji to come on the podium and say a few words. I request Prakash Kumar ji to come.
Thank you very much, DGST team, to invite me, especially Mr. Verma. When he told me that it is to facilitate Mr. H.C. Bhatia, I couldn't stop myself. The way lots of people came and told about that he was their teacher or mentor, I recall my days 31 years ago when I was posted as Additional Commissioner Sales Tax before VAT. And that's what many of you may not be knowing, because my association after 98 was not there with the department. So I was in GST, and from that is much, much later. When I joined, I didn't know much about tax. And I had to dispose of appeals, first appeal, which was at that time 5 lakhs and above. And I was the only appellate authority. Though I had a very good person to assist me, but there were few people whom I used to lean on, especially to understand the nuances of law. Especially how do you distinguish what the honorable judges of High Court or Supreme Court has said. And it was Mr. Bhatia and also Mr. Batra, late Mr. Batra, who used to help me personally. So in that respect, ये हमारे भी गुरु हुए. और आपका बहुत बहुत धन्यवाद. Not only that, in fact, our late Mr. BP Misra, he was commissioner at that time. Whenever he had to discuss some important case filed against the department, though he was not our lawyer, he was not our counsel, the only person he used to rely on was Mr. Bhatia. So thank you, Mr. Bhatia, for helping us, especially me when I was a completely newbie to tax. And thanks to that 4 years there, most of my orders were upheld by tribunal at that time. So thanks again, Mr. Bhatia. आपका बहुत बहुत शुक्र.
अब बिना किसी टाइम वेस्ट किए मैं सीधा भाटिया जी को आमंत्रित करना चाहूँगा, वो आएँ और 2 शब्द कहें.
I am overwhelmed and words fail me. I have no words to express my gratitude and thanks to all of you for your kind words, which I think I hardly deserve. वर्मा जी ने कहा मेरी टांगें कांप रही हैं, मेरे तो पूरा शरीर कांप रहा है. Friends, on 5th of May, we saw a magic. The magician was behind the curtain, and his team, they were performing and creating the magic. It was a mesmerizing event. Magician was Mr. Shushil Verma ji. He was behind the curtain. I have known Mr. Verma for the last about 30 years, 32, 35 years. Sometimes our relationship was love-hate like that of a husband and wife. But after he has embarked on this journey, it is less of love, most of awe and respect. Although he calls me his guru, I will not hesitate to touch his feet for what he is doing and he has been doing. It is because of the love and affection of all of you that a volcano which he was has turned into an iceberg. He has the depth of a sea and has attained the height of Himalaya. It is for you people to delve deep into the sea and rise as high as you can holding his hand, and you will touch the sky, and maybe that you cross the sky also. You go above the sky also. I am reminded of just 2 lines of Dushyant Kumar. कौन कहता है आसमान में सुराख हो नहीं सकता? कौन कहता है आसमान में सुराख हो नहीं सकता? तुम तबीयत से एक पत्थर तो उछालो यारो. और this is what he is doing and he has been doing. What he is doing is unparalleled in the history of legal education and legal profession. Whatever appreciation, whether I deserve it or not, I have received today from all of you, probably he deserves 10 times more than that for himself. I have few suggestions to make to you because today we are all going to see this second Moot Tribunal. Firstly, honesty, sincerity and hard work are the paths to success. When you are preparing a case, master the facts, go to the bare provisions of law and refer to the bare act, and then go to the judgments. If you find that the court is with you, then you need not argue further. Let the other side receive all what the court has to say. Don't interrupt in between. But if you find that the court is not with you, then seek more time from the court, seek an adjournment. Say that I need some more time to prepare the matter further. And if the court is not prepared to give you time, even then try for a remand. At least the order would be set aside. There would be no demand against your client. At the same time, when you find that even if there is a judgment, particularly of the Supreme Court against you, don't try to hide that judgment from the court, because the judges must be and would be knowing about that judgment, or the counsel from the other side, he would be telling the court that this is the judgment of the Supreme Court. Try to distinguish that judgment. I remember, ये कहानी फिर सही, in some of the cases, when I was representing the department, at least 3-4 I recall, there were Supreme Court judgments against us. I tried to distinguish those Supreme Court judgments. One was L&T, where turnover of the subcontractor, the Supreme Court had said that you cannot tax it, it has to be deducted. And it is only the turnover of the main contractor which is liable to tax. It was Supreme Court judgment, L&T's case. We distinguished that judgment saying that we are under the VAT is a state subject, and the court decided in our favor. And probably Delhi was the only state where it was decided in favor of the department. All other states had followed the Supreme Court judgment. There was another case, in the case of JK Synthetics Constitutional Bench judgment on interest, that if tax due according to the return has been paid, then you cannot ask, and subsequently some demand is created, no interest is payable on that. That also judgment we distinguished in one of the cases, and the court decided, because in that case I recall the moment I stood, it was Justice Shakhtar who said, Mr. Bhatia, only 15 days back we have decided against you. I said, my lords, may kindly hear me. And I just read one para, and from the other side it was senior advocate, very famous senior advocate. I read just only one para from the Supreme Court judgment, and Justice Shakhtar wrote a judgment running into about 30 to 35 pages and decided in favor of the department. So if there is a judgment of the Supreme, there was similarly another case where the Chief Justice at that time had instructed the counsel for the department that on next date, give a statement that you will follow the Supreme Court judgment. And thereafter the case was assigned to me. I appeared, I said, no, my lord, that is a judgment under the Customs Act. I will distinguish that judgment. That judgment is not applicable to that. And that case also was decided in favor. So if there is a Supreme Court judgment against you, even then, try to distinguish it on facts, on law. And many a times you will find that if you have really worked hard, the court will be with you. If you want to improve your language, read as many judgments as you can, and your language will automatically improve. There will be certain words and phrases which would get ingrained into your mind, and it will be very easier for you even to draft your appeals or to argue the matters before the court. The word today, or from the beginning, bows to the powerful. And today, it is knowledge which makes you powerful. Knowledge leads to power, power leads to wealth. And this is what some of the verses of Durga Saptashati say. Ya Devi Sarva Bhuteshu Buddhi Rupena Sansthita Namastasyai 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 Namo Namah. Ya Devi Sarva Bhuteshu Shakti Rupena Sansthita. Buddhi is intellect, Shakti is power. Ya Devi Sarva Bhuteshu Shakti Rupena Sansthita Namastasyai 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 Namo Namah. That knowledge leads to power. Ya Devi Sarva Bhuteshu Lakshmi Rupena Sansthita Namastasyai 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 Namo Namah. Knowledge leads to power, power leads to wealth. Lastly, I would like to say one thing. Mr. Verma had talked about this grooming the young. Grooming the young was just a nursery class. But now you are all doing your graduation. And therefore, I think it's right time, and you are the right people, particularly Rajmani, Rashmi Jain.
नीचे नहीं आ रही है वाली, यहाँ कॉलर।
Members are requested to take their seats so that we could start our proceedings. Members who are outside the gate, please come inside so that we can start the proceedings.
सारे निकाल के यहाँ रख दो। मेरा नीचे
ये मेरी अपील है ना।
Mr. Vikas, please take your seat.
ये तो उसने दिया ना जी।
So it's time for the Moot Tribunal. Please keep your phone on silent mode.
Ahuja sir, Narender, you have to escort all the judges. Be quick.
I request Rajiv ji and Rashmi ji, please escort all three judges on the dais. Chairman Sahab, R.K. Khurana ji, please first come. Rajiv sir, आइए.
हाई कोर्ट के दरवाजा
ये गवर्नमेंट कौन सा क्या भाई?
नहीं मैं क्या कर रहा हूँ.
I request Dr. Rakesh Kumar ji.
Court is setting up. When the bench is setting up, you shall give the proper order.
Yes.
I request Rajiv ji to escort Dr. Rakesh Kumar ji. Dr. Rakesh Kumar ji. CA KP Singh ji. Please welcome our guests, our chairman of the tribunal and other judges. Please sit down. Please sit down.
Well, friends, we have 12 appeals coming up. Law, if the application is filed based on a commissioner instructions who has reviewed the order, this is taken to be an appeal before the Honorable Tribunal and is to be disposed of in terms of provisions of Section 107. Your Honor, the limited question before Tribunal is only this, only a limitation. We are not going into merits because the limitation merits are irrelevant. Section 1074 says, the appellate authority may, if is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be, allow it to be presented within a further period of 1 month. Now the question is this: the appeal is to be filed within 3 months from date of uploading of order on the portal or physical service or whatever as per Section 169. 3 months were over. The appellant didn't bother. He still had 1 month. Appellant didn't bother. He delayed the. Now, whatever may be the hardship or in terms of equity, it has no consideration of a limitation. The cause of sufficiency shall arise if this delay was condonable. So this Honorable Tribunal has to consider 2 issues. First, if the delay could be condoned. The second issue is consequential, whether the reason given for delay are sufficient for appeal to be heard. The revenue feels the first appellate authority, being a creation of a statute, is bound by the provisions, this not being a constitutional court to interpret law. Most of the judgments we may have for or against without Supreme Court. Delhi High Court is against it. Calcutta High Court have passed some judgments where delay was condoned. but they were under Article 2 to 6. Article 2 to 6 has no relevance to this Act. They being a constitutional court, they can do anything. But I have placed in your hands 3 Supreme Court rulings under value-added tax regime, the VAT law, GST is also a value-added tax, where the Supreme Court said, no, there is no power to condone delay. So based on this question, I will be briefing this Honorable Tribunal on very limited issues. First, we should keep in mind the judgments given by Supreme Court, which are directly on the issue, are binding on the tribunal under Article 141 until the same can be distinguished in law, not on facts. Your Honor, if you read the order of the appellate authority, it clearly says that because of certain judgments, I find justification for condoning the delay. I will not take you to the facts of the case because the issue is limited and this is undisputed. I'll be taking straight to the Supreme Court judgment, which is already in your hands, in the case of Mr. Patel brothers versus State of Assam. This is exactly same provision of Section 81 on Assam VAT Act, which had a similar provision, statutory limitation and maximum period of condonation of delay, which Supreme Court examined. Supreme Court examined all the earlier judgments of Supreme Court in excise law and service tax law, like Singh brothers, Hongo International. Those judgments were referred to in this judgment, where I will not take time on the Honorable Tribunal to be reading that, because this is well settled law. I would like to pick up one paragraph which is relevant for this case, that is para 35 of this judgment. We start with para 34, section 29(2) of Limitation Act. Because the judgments quoted by friend are perhaps majority or based on this issue. Now the law of limitation under 29(2) says, my lord, is para 34 of the copy we gave you yesterday. Did you get it, sir? Patel brothers.
Patel brothers is at the top. It doesn't
Yes.
have a paging. It doesn't have paragraph number also.
No, sir, I have paging with me. It's the same copy given to you, I am told. Rishmi?
It has no paging, no paragraph.
Not paging, I'm talking para.
Para is also not, okay. Para 17.
Para 34 is there, sir.
ये देखो इस पैरा 34 कहाँ है? ये कोई और
No,
different document.
my lord, can I see?
या दिखा दो सर को दिखा दो. आप मिल गए.
Para is here. दिखा. रजिस्ट्रार साहब, ठीक वाली कॉपी दी आपने?
पटेल ब्रदर्स. हाँ.
एक है मेरे पास, उनको खुद दे दूंगा. एक ही कॉपी.
सर यू कैन रीड एंड दे कैन वी कैन लिसन टू इट. वो शायद कोई कॉपी यहाँ से मिसप्लेस हो गई है. आपके पास है.
You got it, sir? So, Your Honor, the section 29(2) of Limitation Act says, if the applicability of Section 5 Limitation Act has not been expressly excluded from a particular provision of a special statute, from a particular provision, it has to be mentioned in that provision, then Section 5 will be applicable. So the only question to be argued from revenue is whether the language couched under Section 1074, does it expressly exclude Section 5 of Limitation Act when it says delay of not more than 1 month can be condoned. So in Patel Brothers, this issue was taken by Supreme Court, para 34. Though an argument was raised based on Section 29 of Limitation Act, even assuming that Section 29(2) would be attracted, what we have to determine is whether the provisions of this section are expressly excluded in the case of reference to the High Court. So Supreme Court says even if assuming 29(2) can be invoked here, but in view of the provision of the Act, can we say this is expressly excluded? So the Section 5 application will not lie. It was contended before that the words expressly excluded would mean that there must be an express reference made in the special or local law to the specific provision of Limitation Act of which the operation is to be excluded in this regard. We have to see the scheme of special law, which here in this case is the Central Excise Law. The nature and remedy provided therein such that the legislature intended it to be a complete code by itself. So GST law, being a special statute, is a complete code by itself. And Section 5 has not been invoked in any of the 174 provisions of the Act. There is no provision to condone delay in any part of the law except this. The nature of the remedy provided therein is such that the legislature intended to be a complete code by itself, which alone should govern the several matters provided by it. If on an examination of the relevant provisions, it is clear that the provisions of Limitation Act are necessarily excluded, then the benefits conferred therein cannot be called in aid to supplement the provisions of the Act. In our considered view, that even in case where the special law does not exclude the provisions of Section 4 to 24, which include Section 5 of the Limitation Act, by an express reference, it would nonetheless be open to the court to examine whether and to what extent the nature of those provisions or the nature of subject matter and scheme of the special law exclude their operation. In other words, the applicability of the provisions of Limitation Act, therefore, is to be judged not from the terms of the Limitation Act, this is very important, but by the provisions of the Central Excise Act relating to filing of reference application to the High Court. The aforesaid judgment is a complete answer to the arguments on the above. Your Honor, I will not take much of time. We will go to the last two paragraphs of the judgment. This is after they have quoted para 17 of Hukam Dev Narayan judgment. Judgment in the case of Manguram would not come in the aid of the appellant, as the court found there was no provision under CRPC from which the legislative intent to exclude Section 5 Limitation Act could be discerned, and therefore Section 29(2) of Limitation Act was taken aid of. In other words, the judgments quoted by the appellant in this case, the Supreme Court found a similar provision like we have in 1074 or as per Section 35 of Central Excise Act did not exist. Therefore, those judgments were called in aid, and rightly so, because there was no restriction for applicability of Section 5 of Limitation Act. And was taken aid of. Similar situation prevailed in Anshuman Shukla's case. On the contrary, in the instant case, a scrutiny of the scheme of VAT Act goes to show that it is a complete court not only by laying down the forum, but also the time limit within which each forum would be competent to entertain the appeal or revision. Say for example, 107, 3 months, 1 month, go to tribunal 3 months plus 3 months. So both being appellate authorities created by the statute to implement statutory provisions, but for High Court this limitation could not be prevailed. 117 doesn't have these kind of provisions, only 2. To show that is complete court not only by laying down the forum but also time limit within which each forum would be competent to entertain the appeal or revision. The underlying objective of the Act appears to be not only to shorten the length of the proceedings initiated under the different provisions continued therein, but also to ensure finality of decisions made thereunder. The fact that the period of limitation described there has been equally made applicable to the assessee as well as revenue. Section 107 is equally applicable to revenue, though for extended limitation. Revenue being the government department, so there's some kind of leverage given to them. Lends ample to such a conclusion. We therefore unhesitantly hold that the application of Section 5 of Limitation Act to a proceeding under Section 81(1), I've quoted this section, I will read this section also, stands excluded by necessary implication by virtue of the language implied in Section 84. The High Court has rightly pointed out the well-settled principle of law that the court cannot interpret the statute by which they have developed the common law, which in a constitutional sense means judicially developed equity. In abrogating or modifying a rule of the common law, the court exercises the same power of creation that built up the common law through its existence by the judges of the past. The court can exercise no such power in respect of statute. Therefore, in the task of interpreting and applying a statute, judges have to be conscious that in the end, the statute is the master, not the servant of the judgment. And no judge has a choice between implementing it and disobeying it. What therefore follow is that the court cannot interpret the law in such a manner so as to read into the act an inherent power of condoning delay by invoking. Satisfied that the appellant was prevented by sufficient cause from presenting the appeal within of 60 days, it may, the same language is 1074, it may admit an appeal after the expiry of the said period, provided it is presented within a period of 120 days. So this is the interpretation of identical parameteria provision in a value-added tax regime itself. We are not quoting a different law here. This is the first judgment revenue will rely upon. The second is more serious. It's latest 2020. Here, like we are in appeal against the order of the First Appellate Authority. Here also the revenue went in appeal. High Court had condoned the delay. They went to Supreme Court. Supreme Court ruled in favor of the revenue that High Court could not have condoned delay because there is it's a complete court by itself. Delay condonation is not possible for whatever reasons. I'll pick up the relevant paragraphs. Your Honor, I will pick up para 19 onwards, where Supreme Court lays down the crux law after debating 17 Supreme Court judgments on this issue, for or against the taxpayer. Arguendo, reverting the factual matrix of the present case, it is noticed that the respondent had asserted that it was not aware about passing of assessment order dated 21/6/17, although it is admitted the same was served on an authorized representative of the respondent on 22/6/17. So plea was taken, it was not served on me. So revenue proved it was served on your authorized representative who had the power of attorney on you. The date on which the respondent became aware about the order is not expressly stated either in the application for condonation of delay filed before the appellate authority, the affidavit filed in support of the said application, or for that matter, we also have to learn how to file affidavit for condonations. What I am reading is a guidance to all of us that when you file affidavit for condonation, these mistakes are not to happen. Whether if you confront a government counsel like me or the tribunal like our judges, they will tear you apart, your affidavit is faulty, file again. When you file again, you are bound to commit mistakes again. So when you draft original one, be careful. So that's why I am reading this paragraph for all of us. The date on which the respondent became aware
about the order is not expressly stated either in the application for condonation of delay filed before the appellate authority, the affidavit filed in support of the said application, or for that matter in the memo of writ petition. On the other hand, it is seen that the amount equivalent to 12.5% of the tax amount came to be deposited. This is the case also here also. The appellant says I have deposited 10% in time. Court says it has no relevance. Of the tax amount to be deposited on 12 or 17 for and on behalf of the respondent, without filing an appeal and without any demur about the expiry of statutory period of maximum 60 days prescribed under section 31 2005. Not only that, the respondent filed a formal application of rule 60 so and so and pursued the same in appeal, which was rejected on 17/8/18. Furthermore, the appeal in question against the assessment order came to be filed only on 24/9/18 without disclosing the date on which the respondent in fact became aware about the existence of the assessment order dated so and so. On the other hand, in the affidavit of Mr. Sridhar Raut, the state director of respondent company, it is stated that the company became aware about the irregularities committed by the erring official in the month of July 2000, which presupposes that the respondent must have become aware about the assessment order at least in July 2018. Now, that is when you file affidavit on facts. You are mentioning dates. Be careful to reconcile the dates with other applications, because courts will take your skin apart and say, well, this is Supreme Court questioning dates. और नीचे तो वाले dates ही देखते हैं हम लोग. So when you file these kind of applications in whatever court, whatever reason, be sure about your dates. In the same affidavit, it is asserted that the respondent company was not aware about the assessment order, as it was not brought to the notice by employee concerned due to his negligence. The respondent in the writ petition has argued that the appeal was rejected by appellate authority on the ground that it had no power to condone delay beyond 30 days. Exactly same provision must we go through. When in fact the order examines the cause settled by respondent and concludes that the same was unsubstantiated by the respondent. That finding has not been examined by High Court in the impugn judgment and order at all, but the High Court was more impressed by the fact that the respondent was in a position to offer some explanation about the discrepancies in respect of volume. Like here, respondent offered 25,000 rupees cost, appellate authority says fine, thank you so much. You deposit 10%, appellate authority says thank you so much. Same Supreme Court says here, had already deposited 12.5% of additional amount in terms of previous order passed by it. The reason can have no bearing on the justification for non-filing of the appeal within the statutory period. Notably, the respondent had relied on the affidavit of the state director and no affidavit of the concerned employee, so and so, who was associated with the erring employee during the relevant period, has been filed in support of the stand taken in application for condonation of delay. Pertinently, no finding has been recorded by the High Court that it was a case of violation of principles of natural justice or non-compliance of statutory requirements in any case. Article 2 to 6 you can approach straightly, only basically 3 grounds: natural justice, lack of jurisdiction, or non-following of a jurisdiction High Court or Supreme Court ruling. There this deposit of 10% may be waived by High Courts, but generally they don't nowadays. No affidavit of the concerned employee who was associated with the erring employee during the relevant period has been filed. Pertinently, no finding has been recorded by High Court that it was a case of violation of principle of natural justice or non-compliance of statutory requirements in any manner. Be that is as it may, since the statutory period for filing of the appeal had expired long back in August 2017 itself, and appeal came to be filed in respondent only on 24/9/2018 without substantiating the plea about the liability of the inability to file appeal within prescribed time, no indulgence could be shown to the respondent at all. Reverting to the contention that the respondent, having failed to assail the order passed by appellate authority dated 25/18 rejecting the application of condemnation, the assessment order passed by Assistant Commissioner so and so stood merged, need not detain as in view of exposition with court in so and so. It is well settled that the rejection of delay application by application form does not entail in merger of the assessment order, that order. So if your appeal is dismissed in limine, that is you don't deposit, dismissed as time barred, you do not enter into appellate jurisprudence, though the original order stands, right? But you are barred from entering into the appellate jurisprudence. So this is what the court is saying here.
Taking any view in the matter, therefore, the High Court ought not to have entered in the subjected petition filed by respondent. The same deserved to be rejected at the threshold. This is another case they interpreted. And the last one is the latest by NCLT. It's the very latest on March 24. I'll pick up again the relevant paragraph, Your Honor. We can pick up the conclusion without reading judgment. There's a heading called conclusion in this judgment. Yeah, judgment ऊपर से conclusion लिखा है. So this gives the summary of the, we can avoid wasting time. The present impugned order was pronounced on 22/11/23. Most of us go through the high courts or tribunals where they say, okay, deposit 10%. We don't deposit. When I have done this cases many times in tribunal in all parts of the country, sir, order नहीं आया तो हमने तो appeal करना था. So if order is pronounced in the open court, this is an order. It is your duty to take a certified copy immediately or do whatever. The order may be passed after 1 month or 2 months, may never be passed. It doesn't mean there was no order. This is what Supreme Court said in this judgment referred in this case. Okay, order was pronounced, you were there. You want to appeal further, take a certified copy, do it. But comply with the order. Thus limitation for filing the appeal from 22/11/13 and does not depend upon when the appellant becomes aware of the order. Order was pronounced in the open court, therefore limitation starts. The date which the order is pronounced is to be excluded from the calculation of limitation in terms of Section 12(1) of Limitation Act. The 30 days period comes to an end on 22/12/13 and a further period of 15 days comes to an end on 7/1/24. The appeal having been filed on 1/2/24. The appeal has clearly been filed with a delay of more than 15 days from the expiry of limitation. Our jurisdiction, this is a full bench NCLT tribunal based on Supreme Court judgment. Our jurisdiction to condone delay is limited to only 15 days under section so and so. Hence, the delay condonation application cannot be entertained. In view of the foregoing discussions, we are of the view that the delay condonation application deserves to be dismissed. In the result, the delay condonation application is gone. All three judgments are on a paramaterial provision and for appeals. Now, you know, many people sometimes, like this appellant also has taken a view, it will cause me undue hardship. मैंने 10% जमा कराया, मेरा ये टैक्स लग गया, ये गलत है, गलत है. Supreme Court said this is no consideration in tax law. There is no tax equity in jurisdiction of limitations. I will take another 5 minutes of your honorable to read a few things. These notes I can give you, but the judgments, if you want, will give you full judgments also. Supreme Court in V. Nagarajan case, Apex Court set out the appeal is a creature of statute and must have the clear authority of law. You know, it's not with you. I'm just reading it. It's not with you. These are my notes. Appeal is a creature of statute and must have the clear authority of law. Secondly, it is settled law, this is my interpretation, the CGST Act is a complete cone itself, and it is overriding effect on provisions contained in Limitation Act. So once the applicability of Limitation Act has been restricted to 1 month, other Limitation Act has no value for the purpose of this law. Therefore, the special statute which contains a limitation provision including the condonation part, it will override the Central Act, Limitation Act. This is what Supreme Court says. An appeal must be filed within 30-day period from the date of so and so. In a judgment, the Supreme Court underscored the necessity of strictly adhering to statutory limits, rejecting a liberal interpretation of sufficient cause. The Supreme Court judgment is a what sufficient cause? What liberation? If sufficient reason is if you are within the condonable arena. Once you go beyond a condonation arena, this has no meaning for any court. It's all out. The court emphasized that discretion in condoning delay must be exercised judicially, particularly in cases marked by negligence or lack of bona fides. It's reaffirmed its stance against leniency in the application of limitation laws, asserting that courts should apply statutory provision rigidly and not condone delay on equitable grounds. Ex parte केस 10 करोड़ रुपया टैक्स लग गया उसको, वो सो गया, 6 महीने बाद आ गया, सर मैं मर जाऊंगा, मेरा फैमिली खत्म हो जाएगी, मेरा मकान बिक जाएगा,
Well, this looks for the court, he can go to parliament and seek grievance. Court has to say what does the law say. That's full stop. That's what Supreme Court is saying. The court clarified the term sufficient cause as defined in section 5 cannot be interpreted liberally when negligence or inaction is evident, thereby reinforcing the principle that legal provisions must be enforced with full rigor, regardless of any hardship they may impose on a party. In the latest judgment of Pathapati Subbareddy, it was stated that a liberal interpretation while considering sufficiency of cause for delay should not be allowed to override substantial law of limitation. Limitation for filing appeal is not a law of procedure. It is the foundation of appellate jurisprudence. It was observed that concepts such as liberal approach, justice approach, and substantial justice cannot be applied to jettison the substantial law of limitation. Courts have thus repeatedly emphasized that the multiple interpretations of procedural rules must not be used to challenge and defeat the intention behind the legislation, which was greater implication of economic goals and health of the nation. The apex court in Dhrain so and so laid down that the condonation of delay in filing the appeal rests on the facts of each case, and thus no inflexible rule can be laid down only for condonation of delay, if delay could be condoned. But if you have crossed that line, then there is no condonation. In one case, Supreme Court, you understand, the Rava Caulfield is a very famous judgment on limitation. The Supreme Court emphasized that even if a party demonstrates sufficient cause for failing to file an appeal within the prescribed time, condoning the delay is not assured. Especially the statutory authorities have no such lineage available with him. There are a number of judgments of Gujarat High Court, Delhi High Court, which I will not take you through, where they say under 1074 delay cannot be condoned. Your Honor, therefore, review says, first point, we seek advice of the tribunal whether the order of the first appellate was right, condoning delay. Second is 25,000 rupees cost. I do not see any provision where the first appellate authority has been empowered to impose cost to condone delay. This is not a case of plea bargain. कि 1 लाख रुपए दे दो आपको delay condone कर देंगे. No. The phrase any other order it may pass by the principle of existem juris must relate to the earlier facts. It cannot expand the scope of his power where he accepts some fee and condone delay, and therefore the rights accrued in favor of the revenue wither away. Therefore, Your Honor, my submission is the order of the first appellate authority should be quashed, and accordingly the tribunal should answer both the questions against the first appellate authority. Thank you.
Your Lordship, I am before the court to seek justice regarding the petition filed by the revenue. The learned counsel for the revenue has brought forward various Supreme Court judgments, but I would like to bring before the court that we need to first read the law, because the judgments as has been read by the learned counsel relate to a period when the law did not exist. And as far as GST is concerned, we do not have any announcement, any pronouncement regarding this aspect by the Supreme Court. So first of all, we must understand and appreciate that what is GST. If we begin with, it is the combination of 17 indirect taxes that subsumed and created, and GST was created. तो उसका जो different जो elements थे उन acts के that came into GST. तो कौन सा provision कहाँ से वो लेके GST बना है, we don't know. And to read a law which is something related to VAT regime or NCLT regime, perhaps to my mind absolutely don't relate to GST. जो उन्होंने पढ़ा, with all due respect, वो मेरे हिसाब से यहाँ applicable नहीं होता. If there is something related to GST, we can accept. क्योंकि जहाँ तक VAT का सवाल है, it was a state matter. ठीक है, as CGST वो CST अगर मैं ठीक उसको प्रोनाउंस कर रहा हूँ, वो एक सेंट्रल एक मैटर होता था, but as far as VAT governing it was the state act. और वो स्टेट एक्ट के बेसिस पे हम जो नेशनल लेवल का एक एक्ट है उसको इंटरप्रिटेशन लें, वो मुझे लगता है कि
My lord, my friend has not even understood the argument. Section 5 is a Central Act Limitation Act we are interpreting.
Now please let him
Yeah,
speak.
okay.
Your turn will come.
Okay.
He was not interfering when you were speaking.
Right, sir. Right.
So first of all, in order to appreciate the applicability of those high Supreme Court judgments, we need to appreciate the law and what all aspects are involved in the law. So I would begin with, it is an interplay between Section 104 of CGST Act, maybe DGST Act, and Section 5, read with Section 29(2) of Limitation Act. It is an interplay of these two acts, and to understand the implication, we need to have a perusal what these sections say. So first of all, we would like to have a perusal what Section 1074 says. My lord, I would just read the pertinent words so as to appreciate what actually it intends. The words is allows it to be presented within a further period of 1 month. Further period of 1 month may kindly be noted. This para may kindly be noted. This phrase rather may kindly be noted. And now we will come across what Section 29(2) says. My lord, it says, first of all we will say what does Section 5 says. It says any appeal. My lord, may kindly note, any appeal. It speaks of any appeal. It does not demarcate this appeal will apply to X appeal or not apply to Y appeal. It does not speak anything about it. It says any appeal. May kindly lordship may be noted this. May be admitted after the prescribed period if the applicant satisfies the court he had a sufficient reason. So there is any appeal word that has to be catch here. Now we are coming to Section 29(2) of Limitation Act. What does it say? It says in case there is a special statute and that special statute defines the limitation period which is different from the limitation period as has been specified in the Limitation Act. In that case, the limitation period as defined in the special statute will substitute the Limitation Act. But there is a pertinent phrase again to be gone through. It says, unless they are expressly excluded by such special or local law. So there is a need to make a comparison between two phrases. First, we have to make what has been written in Section 29(2) and Section 5 of Limitation Act. Section 5 speaks of any appeal and Section 29 speaks of exclusion and that exclusion need to be done by the special statute. So it is a responsibility conferred by the Limitation Act to do the needful. It has conferred a responsibility. It has said, it has laid down that the specific exclusion clause should be included in such statutes so as to ensure that the Limitation Act is actually not applicable. And if we make a perusal of two phrases, that specific exclusion word is missing. Now, moot question before us is whether this word of express exclusion has been mentioned therein or not. Herein, I would like to first bring before the court, there is no specific exclusion. There are certain phrases, there are certain words as has been specified in various acts such as Limitation Act. They use the words not thereafter or no longer thereafter or such phrases as would indicate and specify that there is a specific intent of the specific law that limitation period does not apply to that specific law. But herein no such phrase has been put to use. So it must be appreciated when there is a special enactment, there is a special responsibility laid on the special enactment to ensure that there is specific exclusion using specific words so that there is no room for ambiguity or confusion on the part of that section. That section should be explicit, not implicit. It should explicitly lay down it has been excluded. Nothing should be inferred, because inferred means a difference of interpretation, because that would lay down, Mr. X would say, yaar ye picture bahut achhi hai, sorry. Y may have a different opinion and Z maybe have a different opinion on the same subject, and same lies to the law. जब हम एक law को पढ़ रहे हैं तो different person may have different opinions. That is why there is a difference of judgment given by different courts. एक ही law को different high courts पढ़ रहे हैं और उसकी judgment different आ रही है. तो there should be a explicit, not implicit. One more important aspect arises. If something has been missing in something, if something is missing in the statute, now we have to paint a canvas, and that canvas revenue will paint in its own fancy, and the taxpayer would be frame in his own fancy. So it is the responsibility of that special statute to take care that special care need to be taken by this special statute, that all such aspects which may result in the ambiguity should not exist therein. And the law is to be read as it has been written, and no new meaning should be given by insertion of word missing therein. Herein, my lord, I would like to mention that specific words of exclusion have not been mentioned there, and silence of those words would not mean that I can insert my words so as to give it a meaning in my favor. If there has to be such intent, that has to be there, and that has to be there specifically. And my lord, I would like to bring one more aspect. Besides the High Court judgments which are in this favor, that the law has to be read, I would like to read a line. In case of Supreme Court Jayaram Education Trust, statute should be read as it is, in a natural manner, plain and straight, without, my lord may kindly note, without adding, substituting, or omitting any words. My lord, the phrase without adding may kindly be noted. We cannot add any word to the words which are not mentioned in the statute. And sir, one more thing is there. One more thing, we should learn lessons from the old laws. And the all old laws had an ambiguous meaning entailed therein. The sections were not clear, and it resulted in a number of litigations wherein the matter has to be reached to Supreme Courts for adjudgments. So that experience should have been taken while drafting the GST Act, and the recommendation relating thereto should have been moved by the department to the council, and such ambiguity should have been removed so that a taxpayer has a clear vision what actually his rights are. My lord, I would also like to bring before the court the provisions of Arbitration Act. It has been observed in Union of India Popular Construction Company. My lord, the words used therein are within a further period of 30 days, but not thereafter. But not thereafter means there is a specific intent of the legislature that it does not want the limitation period to be intervened by the courts. But such specific words are not mentioned in the Act. My Lord, I have been given an opportunity. I have been, the application of condonation was accepted by the first appellate authority. I would ask the council, what have I received by virtue of that acceptance? Have I received any relief? The answer is big no. The acceptance of condonation application does not give me any relief regarding the demand that has been raised. Rather,
बाटी साहब के आगे लेके बाटी साहब पीछे खड़े आगे लेके आना उनको नहीं आगे
rather, Your Honor, it gives me an opportunity of being heard. And I would like to draw your attention to Article 1421, which specifically stipulates nobody can be condemned unheard, which being against the fundamental principle of natural justice. I have to be given a right to be heard, and that is what the first appellate authority did. Moreover, Your Honor, I would also like to draw your attention to Article 265, which stipulates that tax are not to be imposed save by the authority of law, meaning thereby the tax has to be imposed by valid law, and no tax can be levied or collected without authority of law. Herein, Your Lordship, we have a meritorious case. I will not discuss that in detail. And that fate of that case will actually determine my legitimate liability to pay tax. And I am not refraining or running from that amount. I had to pay, and I will pay what becomes due after the disposal of said appeal. Your Lordship, I would also bring your attention to a fundamental right of access to justice as laid by the Constitution of India, wherein the Article 14 and Article 21, Article 14 right to equality and 21 right to life and personal liberty, which says that I should be given a chance, an opportunity of fair trial and fair hearing, personal hearing, right to represent my case, right to be heard, right to present evidence in my defense. If my application of condonation is rejected, Your Lordship, it would lead to contravention of my statutory fundamental right to access to justice. Moreover, I would also bring before the court the judgment put forward by Mukhri Gopalan, wherein a distinction was made between persona designata versus judicial function. Your Lordship, the Supreme Court wherein held the appellate authority were not persona designata, having limited power, so they have a greater power in making fair decision rather than being bound by the rigid timelines. They function as a court, and they are not individuals appointed for a limited purpose. So herein, Your Lordship, the first appellate authority understood the concept, followed the concept, and accordingly granted me the relief. Your Lordship, the section of Section 5 of Limitation Act says that I could file the application or appeal beyond the prescribed time, provided I have a sufficient cause. And Your Lordship, n number of judgments has laid down that a liberal view regarding this casual condonation of delay should be taken. And moreover, your lordship, the sufficient cause, the various judgments regarding to sufficient cause has been mentioned in the...
But here you have to be quick. We can't take 1 hour for this case,
Sir,
sorry.
1 minute.
No, you have to be finished immediately now. We can't take 1 hour for one case, yeah? It's a moot tribunal.
Herein, your lordship, we have given an annexure of various high court judgment in a summarized manner, and the entire judgment, relevant judgment, have already been placed on record. It is just for having a perusal. Your lordship, one important aspect I would like to bring before is, till today we are having n number of judgments given by different high courts. Now we are in the GST regime, so we have to ignore all the judgments given in the old regimes, and we have to come into the era of GST regime. Your lordship, I have given the copies of various high court judgments, and the name and the judgment given by them has been given by virtue of an annexure therein. Your lordship, different high courts made a different judgment. Why? Why is the mute question that should be understood and need to be answered. That difference of opinion was due to the ambiguity in section 1074 in the framing of language therein. And since we are in the GST regime, we have to appreciate the opinions and the decisions made by various high courts of various states. And your honor, you may kindly appreciate, there are 2 judgments. There are n number of judgments in favor of the respondent. At the same time, there are m number of judgments in against the respondent. Why is such a confusion there? Is a moot question. There is a confusion, and that confusion need to be answered and looked into. It is due to those missing words, that specific exclusion which is missing in section 1074. Had there been such words, there had been no such cases. And your lordship, now I would like to draw your attention to a case of S.K. Chakravarti given by Calcutta High Court. This is to conclude my submission. Though I have taken a long time.
A lot of time, not to be a loud person in moot tribunal in future. You have to stick to timing.
Your lordship,
we have 12 cases to go, we can't take 1 hour in one case.
Your lordship, here the condonation of delay was granted to the appellant.
But it was stayed.
But that matter had been stayed by the Supreme Court and has been fixed in for July. So, sir, there could be a request, let this appeal see the day जब हमारी सुप्रीम कोर्ट इसके ऊपर जजमेंट देगी सर. And moreover, your lordship, till then, since I have complied with all the statutory provisions of 107, so the demand standing against me must be stayed, because still there is no order pending against me. There is, my appeal has been accepted by virtue of condonation of delay. So there is an accepted appeal, and the matter regarding disposal या regarding dispute of that appeal is sub judice. तो जो demand है that may be kept.
Anything, Mr.
You know, in all the 3 judgments which I have given, there were exactly same provisions which are 1074. In GST regime, Delhi High Court, Gujarat High Court, Patna High Court have already dismissed the petitions. There is no power to condone delay. If you want, we can file a list which way I'm sure you are on. Now, the basic question raised is S.K. Chakrabarti. It has no relevance to the case.
Why?
This is an interim order. It's not an Article 141
Yeah, it
order.
is an
Interim order. And where they have stayed the order condoning delay, it's against him, not against revenue.
That's what I was also going to tell you.
Sir.
That this stay goes against you, not in your favor.
So I can withdraw this.
So in any case, so this appeal has to be dismissed. If at all there is a, yeah.
You want to say something? Thank you very much. We have heard the learned counsel from both the sides, and issue before us is whether the learned first appellate authority was right in condoning the delay in admitting the first level appeal. Second question which arises is whether the learned first appellate authority was right in accepting an additional amount as a consideration for acceptance of the appeal. So arguments on both the sides are, even though they are quite powerful and at the face of it sometimes emotionally they may appear to be convincing, but we would like to deal with these arguments maybe one by one, or at least some important of these. The argument leveled by my dear friend respondent is that as per section 5 of the Limitation Act, he was entitled to condonation of delay because the reason given are very convincing and they are just and reasonable cause for the delay. But in his own mind, in his own statement, he has said that this Limitation Act will be applicable unless the provisions of the Limitation Act have been specifically excluded. On the other side, we also hear that, and this is a fact also, that section 104 of the 10774 of the CGST Act specifically provide that wherever the appeal is not filed within a period of 3 months, the first 3 months, first appellate authority has a power to condone the delay and allow it to be filed within the next period of 1 month. Now he has a power to extend only up to 1 month. Whether you want to read that whether the application of the CGST Act is or is not excluded. Here our view is when a particular law provides for a particular limitation period, all other interpretation, other inclusion in your own word, they are specifically excluded. A particular manner provided for provided for condonation is that period of 1 month. You cannot say that a period of 3 months is not excluded or additional period is not excluded. So to that extent, we
Your Lordship.
To that extent, we admit the particular appeal and allow the revenue appeal to that extent.
Thank you, Rajiv Jain. You argued the lost case in the best possible manner. That's the beauty of a winner.
Rashmi Jain and Government Counsel is Advocate Shushil Verma, and the matter to be discussed is rejecting of input tax credit on gift items, referring the section 17 subsection 1 clause H. C.A. Rashmi Jain ji.
Rashmi, before you start, this is a appeal which is very important for all of us in next round of litigation done by department. It's on valuation section 15 read with rule 43. So what kind of discounts or compensations or damages or whatever name you call are allowed or not allowed, and what are the requirements which are preconditions before you file appeal or before you file reply to show cause notices. The teaching done to you by various experts in this field how to reply show cause notices, they do not guide you what is the value of documents you filed. Indirect taxes are 90% documents, 5% law, 5% your court craft. So if you do not have documentation, no court will interfere with your cases. So Rashmi Jain has come out with beautiful explanations. I have read her appeal, that's why I am arguing. So be very attentive to hear to her okay, what is the interpretation of section 15(1), 2, 3 and to what extent requirements are allowed. Generally say gift दे दिया तो allow नहीं होगा, ऐसी कोई syndrome law में नहीं है. So this issue is in this appeal. I'm sorry Rashmi took your time.
My lord, I am honored to appear before this bench. May I proceed? Honor. My lord, this appeal arises from the order passed by the First Appellate Authority, where First Appellate Authority upheld the order passed by the Adjudicating Authority. In this case, Adjudicating Officer is also the Audit Officer, who has headed the audit team under Section 65 of DGST Act. The same officer has signed the audit report also, ADT 2. For your reference, I have annexed all the annexures. Shall I refer those, sir?
It's okay.
Thank you. My lord, this appeal relates to the denial of input tax credit of rupees 1.36 crores. The demand in dispute is 1.36 crore tax, rupees 32 lakhs of interest and penalty to be calculated separately as per section 73 of DGST Act. My lord, the cause of demand is the allegation that the input tax credit claimed on various items is wrongfully availed in violation of section 16 subsection 1 and section 16 subsection 2, read with section 17 subsection 5 of the DGST Act. My lord, the appellant has been registered with the GST department for the last many years and deals in consumer durable electrical and electronic goods as a distributor for leading companies. My lord, this appeal is delayed by 9 days and the appellant has separately moved an application for condonation of delay in terms of section 112 subsection 6 of DGST Act read with rule 29 and 49 of DGST procedure rules 2025.
Accepted.
Thank you, sir. Further, my lord, the appellant has also filed an application for additional evidence in compliance of rule 112 of DGST rules. We have also attached an affidavit of the partner as annexure ADT 3 page 6, sir.
Could you read what additional evidence you want to add here?
Sure, sir.
Very briefly, just
sure, sir.
One line.
Give me a second, sir.
The page where you have
sir, it's
page number.
Sir, page number I am telling, sir.
Page number
It's
30.
Pink color.
Page number 30.
Yes.
Sir, affidavit is page number 683. Sir, pink color like this flap.
Yeah.
Then after
It's okay. Just tell us the documents you want to add. That's all. Evidence or additional documents you want to add.
Sir, there are 33 tax invoices which were missing at the time of audit and also at the time of adjudication order. Then we have attached our schemes that are in question, mobile phones purchases. After that, we have added a bill of car purchase and rental bills. And there is also, sir, opinion by a legal lawyer.
Okay, that's also accepted now.
Thank you, sir.
You have to ask us.
I think
Sorry.
Any
Now,
objections
see,
to it?
regarding condonation, normally when courts have an inclination to condone, Revenue Council should not object until it's very clear negligence on their part. So 9 days, though this explanation is not sufficient, the directors are out. So it was their problem. They were going for fair for 3 months and without bothering about law. But 9 days, I fully agree with the tribunal, we should condone. Regarding the additional evidence, it's an afterthought.
It's an afterthought.
It's an afterthought. To bring on the agreement on record, that these agreements were there and this discount was there, this Ferrari car rental bills were there, etc., etc. I think this is an afterthought. And I would say that such evidence should be disallowed, because if we allow this kind of evidence to come into indirect tax laws, then any story can be made out. People can move application for additional evidence and say, please consider. If it has to be considered, this has to be considered with a heavy cost.
Your argument, please.
Sir, my argument is that we are always having this document except the 33 tax invoices in question which were misplaced, and after we find that. And others, sir, there is a not, these documents are not demanded by us, but we always have this. During the audit also we have this. All these entries are within our books, and we have shown all these items in our returns also, GSTR 1, GSTR 3B. Nothing is after. Sir, nothing is afterthought. Sir, nothing is afterthought. All things are available with us except the 33 tax invoices which were misplaced, and we have always admitted that. In all our replies, we have shown that we are getting those, but by God grace, we have got our original invoices only.
Your books were audited?
Yes, sir.
And during the course of audit, whether deficiency regarding these 33 invoices?
Yes, sir, there was. Yes, sir.
So during the course of audit, also auditors were also not shown these invoices?
Yes, sir.
Your Honor, my question is that it's not a question that the government has to collect what it tax due to the, but the taxpayer should not take the courts for granted. They were audited, rightly or wrongly. They were put questions, there were queries in audit. Then show cause notice are applied to them, adjudication order, they never produce this agreement. Now suddenly they became wiser. Oh, had we had this agreement and at the time of our place of supply, where these discounts or these gifts from mobile phones are possible. So this is an afterthought. If at all this has to be admitted, the Honorable Tribunal cannot appreciate this evidence. It has to go back. The Appellate Tribunal is the second appellate authority, but with a heavy cost.
While we appreciate the arguments on both the sides, but we are also concerned that simply because some of the officials in the company could not produce the documents, or some of the documents were not available at that time but subsequently became available, maybe some of the agreements were not shown. Because of these procedural things, the appellant should also not suffer. But at the same time, we are equally concerned with the revenue that these documents are not cooked up and later on produced as an agreement, and those kind of things can also happen. So we have to take a balance on this. While you may proceed with the presentation of the case, but we will keep your argument in mind, that while passing an order, we will keep your concern also in mind. Right.
Grateful, my lord. Your lordship, I pray you to have your attention on some of the basic questions of law that were noticed in the audit proceeding and the adjudication order. So the whole audit was conducted without following the due procedure mentioned in section 65 subsection 1 of DGST Act. Section 65 subsection 1 of DGST Act mandates that audit officer could not assume jurisdiction unless the commissioner or any of other officer so appointed by him by way of a journal or specific order authorized the proper officer to undertake the audit of the appellant. The same authorization was missing in our case, sir. Considering non-fulfillment of the requirement of section 65 subsection 1, the audit conducted by office is void ab initio. Audit report is also annexed, sir. You can check. So the proper officer who has issued the show cause notice and passed the adjudication order under section 73 of the DGST Act was the same officer who has conducted the audit and signed the audit report, ADT 02. My lord, we have attached all the SCNs audit reports as annexures. Now, my question is that it's a settled law. No man can be a judge in his own cause. My lord, my question to this bench is, can such a procedure adopted by any officer in the common law prudence? May I repeat, sir? Can such a procedure adopted by any officer is in the common law jurisprudence? Sir, to substantiate my questions, I would like to have your attention on the case law I have shared with you, Muhammad Yunus Khan versus State of UP and others. Sir, it's page number 3. I would like to read para 24. Should I read, sir?
Yeah.
Thank you. The legal, sir.
Madam Rashmi Jain, when you give judgment, it has to be full before the court. You can't skip out 20 pages and read para 24.
My apologies, sir.
Yes,
I will
judgment has
correct
to be
it.
full always in future.
I will correct it. So the legal maximum, nemo debt es judice in properia causa, no man shall be a judge in his own cause, is required to be observed by all judicial and quasi-judicial authorities, as non-observance thereof is treated as a violation of the principle of natural justice. Sir, White Secretary to Government Transport Department versus Munisfe, Murlidhar and others, AR and further judgments are referred on. Sir, on para 25, this court in AU Qureshi versus High Court of Gujarat and Andhra Pradesh 2009-11 SCC 84 placed reliance upon the judgment in Ashok Kumar Yadav and others versus State of Haryana and others 1985 4 SCC 417 and held that no person should educate a dispute which he or she has dealt with in any capacity. Sir, in our case, the same officer is the audit officer. The same officer is the officer who has given the SCN. He has done the order under section 73. So, sir, the case applies to this equally. The failure to observe this principle creates an apprehension of bias on the part of the said person. Therefore, law requires that a person should not decide a case wherein he is interested. The question is not whether the person is actually biased, but whether the circumstances are such as to create a reasonable apprehension in the minds of others that there is a likelihood of bias affecting the decision.
That's all?
Yes, sir.
Mr. Verma,
she has raised two issues. One is on the validity of the audit. This we do not accept because she had a chance of questioning the validity of the audit in her appearance before the adjudicating authority. Please read the proceedings of the adjudicating authority, also of the appellate authority. Did you question, raise this preliminary issue before the adjudicating authority?
No, my lord.
Why not? Then
Sir, it's my mistake.
After the train has passed off, you can't get us back to the original station. In case you had any reservation on validity of the audit or some procedural defect in the audit, you should have raised it at that point itself, or at least before the appellate authority. Since you have not raised it at that time, we are sorry, we will not allow it at this.
I accept, sir.
That's one. Second is, you ask about the adjudicating authority being a judge of his own cause.
Yeah.
Did you raise this?
No, sir. First time I am raising this question, sir.
Then what do we do now? We would like to hear learned counsel
I
this
will
side.
speak from her side first. We are there to assist the court. We are there to assist the court. Now, friend, these are the questions you have to raise before the authorities. All these fellows, they accept your returns, they issue ASMT 10, 11, 12 to you. They do audit on their own without any specific order, commissioner or general. They submit the audit report to them on, and based on the same audit report, they give you a show cause notice, they accept your reply, adjudicate. And question of jurisdiction can be raised at any form, even before Supreme Court for the first time, if it is a valid jurisdiction. That I will say whether it's valid or not.
Okay.
But she has a point that the jurisdiction issue can be raised even before submit, like limitation.
That's why while we have not admitted her point on the validity of the audit, even though my friend felt that even we could have accepted the validity of the audit at this stage.
That's what I am telling him.
But we still feel that regularity of the audit, because these are the things many times the business people take it for granted. Audit wale aaye hain, baith gaye hain, chale gaye. They just take it for granted.
And
So,
do you have anything else to say on this issue?
Okay.
You want me to argue this first?
I think that we have already decided. Validity of the audit we are not questioning.
Okay.
But only thing is, this issue is really serious, that audit is done by the same person, SCN is also given by the same person, the same person stands.
We'll answer this. Let her complete her appeal.
Stands as a.
Revenue has his own viewpoint. We'll argue.
This issue also arise in a couple of more cases, and more elaborately, and where the appellant has taken a stronger ground on the preliminary aspect itself.
Then, if you want, we can spend 5 minutes on this issue.
We can spend 5 minutes, even longer on this.
Now, Your Honor,
Yeah.
we are on a special statute. It's passed by Parliament. It's not passed by state assemblies. Parliament in its own wisdom, they defined proper officer. Section 2, subsection 93. When we come to audit report per se has no consequence. He can write whatever he wants to write in the audit report, because demand is not created through an audit report. Demand is created through under 65(6) when he issues a notice under section 73 or 74. So notwithstanding her valid point Okay, 3 months plus 6 months should have been adhered to. But that, in my view, will be a highly technical part of procedure. Okay, did he take extension or not? A action can lie against the officer. Why did you do it? Allegation of bias can be proved against him. But does it ab initio invalidate the proceedings under 73? That's a question the Honorable Tribunal has to answer. They are not denying that 73 notice was not issued. Now supposing audit report is not even referred in section 73. Is there any minor action? Because 73, 74 have no interplay with section 65. 65, 6 has an interplay with 70, 74. 73, 74 don't even refer anything. There's a tax short paid, not paid, wrongful ITC or erroneous refund. 73, 74. Therefore, the first point raised by my learned friend is that this audit, there were irregular timings. But there is no default consequence like in 1074. There is no default consequence given. But yes, on the issue of the officers being judges in their own cause, now here also the revenue issue will be that they have been made proper officer by the parliament. Will the tribunal have authority to question the wisdom of parliament under Constitution of India? That's number one. Number two, however, if the honorable tribunal has to go on the principles of natural justice, well, tribunal has to take a call. Even I will agree with you that if same body does this all cases on his own, so whatever apply a taxpayer may file, it will have no sense. He is not going to budge from his issue. उसने ऑडिट रिपोर्ट बनाया है, उसने ऑडिट रिपोर्ट अपने बॉस को दी है, कमिश्नर को दी है, इसमें 500 करोड़ का इवेजन है. You know, if we see today's paper, Infosys demand of 12,000 crore has been deleted by the same authority who issued the show cause notice. So here this tribunal should give a finding, should guide the commissioner that this kind of procedure is avoidable procedure, because in the center this procedure is not adopted.
Sir, I would also like to draw your attention on the two circulars.
Yes, Your Honor.
Where they have specifically mentioned that the audit officer or investigation officer has to be different and he cannot make the adjudication. The circular numbers are...
Yes, Your Honor, though the circular is issued under central. In central they are following it. But the same law they are implementing. So that's why I am saying the tribunal, they should follow the circular and guide the commissioner, DGST.
Because the law cannot be different.
Law can be different, but there were not to the three circulars. Yeah. Both are under central right from 17 to 22.
Yes.
On this jurisdictional issue.
Yes, on jurisdictional
So that's why I'm myself requesting the tribunal to take a call on this and guide the commissioner that this kind of procedure is against principles of natural justice. But can this itself lead to questioning of the order?
Yes, sir, if the proceedings are wide definition, if they are out of jurisdiction, they are against the circulars, then definitely the orders have to be...
No, but this is against natural justice. So at best the tribunal can do remand the matter.
No, remand for what purpose? Then the audit...
No, then you tell commissioner it should be put up to some other officer. That's it. That direction can tribunal give.
What we... No, why sir, in this particular case, we are of the opinion that it has to be quashed because the proceedings are wide ab initio, and it's not only interpretation of law. There was a clear circular issued there.
Yes, but it is binding on...
the commissioner has made defense. There are two different commissionerates. One is commissioner audit, one is commissioner central tax. Right? So the intent of the legislature, intent of the parliament is also same, that the audit wing should be a different wing and assessment wing should be a different wing.
My lord, I fully endorse your view. But my question is,
since they have not followed the procedure and laws, so any procedure...
Even if you quash the order, if the limitation permits, they will do it.
Yeah, if the limitation, definitely, we are not against that.
I agree.
Limitation permits, then
I'll be with the court. I'll be with the court.
I think on limitation, can I conclude?
Yeah, please.
On the limitation, we also are struck by a basic principle of natural justice, that is nemo judex in causa sua, and this is very well enshrined in the Constitution of India. And we also have our own limitation that we are not a constitutional authority. We are only a creation of law, and we cannot go beyond what is prescribed in the law through the notification, rule, regulation, and all that. And in that, we come across two circulars, as my dear friend has said, where in relation to audit and in relation to GST intelligence, there is a very clear order that anybody who conducts the investigation or the order, he should not be adjudicating it. He can at best issue the SCN, and adjudication should be done by the jurisdictional authority. To that extent, this constitutional principle is followed. But there is another circular by the same central government where powers under section 65 and under 73 and 74 are vested in the same authorities. There is the original circular.
But sir, that is of 2017, and these two new circulars will override.
No, they are not. They do not. There is no mention about the override.
No, my lords, my lords, the jurisdiction under 65 and 73 are totally different.
I know, but in the circular it says additional.
No, my lords, it's okay, circle with the same officer, I appreciate.
Yeah.
Right? Yeah. When you go to the assessment chapter, 61, 2, 3, 4, 65, the chapter is for assessment of tax.
Yeah.
65 does not override 73. Because the 65 proceedings also culminate in 73 proceedings only.
Yeah.
The only question raised by my friend and valid is, he does everything on his own.
Yes.
Now supposing he did not do the audit, he issued notice under section 73, who can say it's invalid? There is not acting as dual capital. Both are conditional jurisdictions. 65 is also a conditional jurisdiction. 65 one conditions have to be satisfied, otherwise audit is also bad ab initio.
Yes.
I will agree even to that extent that one law says to be done, something to be done in a particular matter, it has to be done in that matter or not done. So both 65 and 73 are conditional jurisdiction, but 73, 74 are a part of demand and recovery chapter. So there the scope is totally different, only 3 issues. There is no 4th issue can be raised in 70, 74. So I think to that extent, my submission would be that 73, 74 proceedings stand on a different footing than section assessment procedure.
Then in compliance with this.
So friend, the issue raised by Rashmi Jan in this case was, which you must raise in all your appeals whether somebody accepts or not. Okay, the adjudicating officer cannot be himself an auditor. एनफोर्समेंट वाले केस करते हैं, वही बंदे आकर शोकॉज नोटिस देते हैं, वो आपको झमेला करते हैं सारा. सो दिस अपील इज राइट ऑन आवर वेबसाइट, फुल अपील विद जजमेंट्स ड्राफ्टेड बाय रश्मि जैन, and it's available to you wherever you are come from. Just pick up this appeal, keep raising this issue, and don't go further. Tell them first decide this issue. You can move an application before the first level authority that this is an issue that goes to your jurisdiction. Decide this.
It has to be also. No remand.
This will be a question.
Circular number 169 dated 12th March 22 and circular number 239 dated 4th December 2024.
Then
once repeat please. I'll repeat. Circular number 169 dated 12th March 2022 and second is circular number 239 dated 4th December 2024.
Then we quash the present order and remand it back to the desk of the adjudicating
No, sir,
officer.
I think we should simply quash. This for the authority to decide. If there are limitations, they can still do it.
With the freedom to the department.
You can say with freedom, yes.
Proceed
as per law. As per law.
Proceed with the case as per the law by following the due procedure.
Bhatia Sahab, is it a good order? Is it a good order? हम क्वैश ही कर रहे हैं सर.
हमारी कल से ही बात चल रही है.
Well, I think Rashmi Jain deserves a beautiful round of applause for this. And you argued like a pro. I love you.
मैं बीच में इंटरप्ट कर रहा हूँ. एक केस के अंदर ऐसा करना चाहिए कि एक तरफ रश्मि और एक तरफ जो है
राजीव.
वो आपकी मेरी बात हो जाएगी. एक बारी भाटिया साहब गवर्नमेंट काउंसिल थे. वी हैड ए वेरी लॉन्ग मैटर इन द 30 ट्रिब्यूनल. तो भारत भूषण जी ने बोला मेरे को, गुरु द्रोण, आर यू अर्जुन?
मैं कहा नहीं जी, मैं तो पाँव पकड़ के, हम तो मर्सी वाले लोग हैं, पाँव पकड़ के जीत लेंगे। यू रिमेंबर दैट? हाँ जी, नहीं बट वेरी लिटिल, अदरवाइज नॉट मच।
जैसे कहा कि इनका जुडिशियल नहीं है, प्रॉपर ऑफिसर जो है ऑडिटर प्रॉपर ऑफिसर की तरह नहीं है। हम लोग क्या चाहते हैं कि ये गलती करें, आगे चल के उस गलती को हम फायदा उठाएं इसका। बिल्कुल। तो कहा जैसे कि शुरू में आपने इसको ऑब्जेक्ट किया कि सारी प्रॉपर ऑफिसर नहीं है, और
आपको करना चाहिए। दैट इश्यू ऑफ jurisdiction should be raised at the very first opportunity.
मेरा कहना कुछ और ही है सर, मैं तो कह रहा हूँ, मैं बता दूंगा दूसरा प्रॉपर ऑफिसर ले आएंगे, दूसरा ऑडिटर अपॉइंट कर,
कोई बात नहीं, we are discussing law sir,
लेकिन उनकी गलती से
we are not discussing lawyers business strategy there. चलो next. Well done Rashmi, God bless you.
Next item is item number 3, KM Trading Company, represented by CK Gupta and Government Counsel Advocate Shushil Verma ji. The matter to be discussed is role of credit note, section 34. CK Gupta ji.
In this matter, you have 4 issues relating to 34 read with Rule 43 and read with 15(3)(b). Most of us know what is credit note, debit note, but very few of us have ever read section 34 as a whole. I guarantee you this, none of us would have read section 34 carefully. Debit note, credit note होते हैं. The debit section 34 does not give you a power to reduce your output tax liability. This power, this right is available in section 15. It deals with valuation. And Rule 43 tells you what is the consequence of issuing a credit note. So this case will have interplay of all the 3 provisions so that we all understand what exactly this business of credit note is.
My lord, the appellant is a private limited company, bona fide person, engaged in the business of trading of paints. The appeal has been filed within the limitation period. Total demand raised is tax 10 crore rupees and interest 6.2 crore rupees. There is no admitted tax liability. All the above demands are disputed by the registered person. The company has deposited 1 crore rupees, being 10% of the disputed tax demand. My lord, we are filing here with additional evidence in the case. The first appellate authority has passed ex parte order on the ground of non-attendance and confirmed the order of the proper officer. Opportunity of being heard was not provided. We have already moved an application for additional evidence at page number 4 of the brief. Page number 4 of the brief. Application seeking leave to produce additional evidence. With due respect, it is stated before your honor that we are filing here with additional evidence in the above mentioned case in terms of Rule 112 of the CGST rules. The first appellate authority has passed ex parte order. Refer page number 18 of the paper book. Opportunity of being heard was not provided to the registered person. This is a gross violation of section 75(4) of the CGST, which mandates providing a hearing opportunity before passing an adverse order. This is contravention of principle of natural justice. As per Rule 112 of the CGST rules, applicant was prevented by sufficient cause. Your Honor, please note sufficient cause from producing evidence before the first appellate authority. Relying on the judgment, the Supreme Court in the case of Madanlal versus Shamlal, it was submitted that expression sufficient cause should be given a liberal interpretation. My Lord, liberal interpretation to ensure the substantial justice to the person. We are filing herewith following documents before this honorable court as additional evidence. A screenshot of the additional notices and orders, agreement with the geyser manufacturer before supply, claim agreement and claim document after supply, correspondence with the letter with the recipient. Prayer. It is therefore prayed to the honorable court to kindly allow the appellant to produce the additional evidence and in the interest of justice to the registered person. My Lord,
Please carry on. Carry on.
I am seeking for the additional evidence application.
He has raised two primary issues. One is the opportunity of being heard was not provided.
Yes.
Second is that he wants a permission for production of the additional
Yeah.
evidence. These are
But
the
you see,
preliminary issues we have to
there are two
before it
preliminary,
goes
before
down.
we seek DR cell, right? So, the,
14.
has vehemently argued all the discounts given by so. That's only procedure lapse. Second, page 16 as well. This is adjudication order under section 73(9) of DGST Act by the Assistant Commissioner. You know,
yes.
Here again, see para 2, page 16, para 2. Council has vehemently argued that all the discounts given by the company so and so may be after a gap are within the legal parameters and the fact they are not registered. He has therefore argued that the discounts given to them were absolutely per law. When questioned further why the credit notes not linked to invoices, stated that he is only procedural lapse. When further questioned whether these discounts were agreed with the customer at the time of supply.
My Lord, the discounts were given to the consumers. They are not.
My friend, my brother is not asking you on the merit of that.
Yes.
So he is trying to answer your question that opportunity was not heard. Every sentence of the adjudication order and appellate order says your very active participation in the adjudication and the appellate process.
And vehemently,
Vehemently you have been arguing. Vehemently you have been opposing the allegation. Then how do you say that opportunity of being heard was not granted?
We have to submit some documents. On the basis of those documents, which I have filed for the additional evidence, it will be proved.
No. First strike to one point.
Yes.
That we are trying to answer your question very reasonably, that opportunity of being heard was granted or not granted. You say it again, because in the appeal you have said it was not granted. But in the backup paper, they say that every stage you have vehemently opposed the proposed decision by the adjudicating authority, also by the appellate authority. And you just read at page 14, as my friend has said, second paragraph, which says council has vehemently argued that all the discount given by the company to the consumer, they were payable as per the trade practice and all. We have given justification for all the points given there. Now saying that the opportunity of being heard was not granted, perhaps is not right. That is contradicting your own facts of the case.
But my Lord, we have to file some documents before filing some documents.
Point number 2.
The adjudication order was passed.
We will come to point number 2 after we hear the.
Yes. My Lord, if you go through page 18, page 18 first.
Yeah.
Appellant was called for 4 dates, 4/10, 22/10, 5/11, 15/11, and finally on 25/24. The notices were duly posted on the portal of the applicant. I have personally verified the same. The appellant did not appear. So, but this first part. Now, if you see the show cause notice,
and the reply and the adjudication order, all these points were brought to his notice. That's why I'm saying when we entertain application of additional evidence, the Honorable Tribunal should be circumspect to allow this freely, because they may be making out a completely new case, which is not the below, and they cannot make out a new case in tribunal. They have to plead what is there. If out of pleading some documents were required to be produced, additional evidence gives them a leeway. But here everything was there, they had everything, they never applied anything.
Okay, anyway, now you come to point number 2. One, you are first you are convinced that proper opportunity of being heard was provided. Whether there was a merit or not, we will come later, or whether there is a merit or not, we will come now. But come to point number 2. What are your additional documents now you want to produce, which could not be produced, and why they could not be produced?
First, I would like to say that all the notices and orders of the first appellate authority were uploaded on the portal, which is wrong tab, additional notices and orders. This misstatement led to the taxpayer being unaware of the notices. In the case of Hindustan Pipes, Honorable Allahabad High Court quashed the demand order. The court directed the tax authorities to issue a fresh notice, ensuring it is uploaded correctly under the appropriate tax tab of the GST portal. We are filing herewith a screenshot of the portal, additional notices and orders for a ready reference on page number 5 of the brief. Orders and notices must be served on the portal on a correct tab, that is notices and orders, and they have posted in additional notices and orders. There are 2 tabs. So we were unaware of the notices.
What do you like to say?
And the order was passed ex parte.
Your Honor, in the appellate order, the appellate authority joint commissioner has written, I have personally verified the same. So who is right or wrong, we don't know.
No, personally verified that they were uploaded on the portal.
Yes, that's what I say.
On the additional.
The notices were duly posted on the portal of the appellant, and I have personally verified the same.
No, there are on the
I appreciate
portal,
what he says.
There are
that can also make sense.
There are 2 icons. One is the notices and order, and there is a additional notices and orders. Now, as a appellate authority, where did he verify whether they were in the additional?
We have to go by the order passed. He is verified on the portal.
No, portal has
I appreciate.
No,
That's okay. But
he is also not denying that they are not available on the portal.
Yes.
The thing he is saying is
he could not
that
see them.
They were not posted at the right place.
Your Honor, there is no affidavit filed with it. Affidavit is a precondition for rebutting these kind of evidences, and that's not a matter of procedure.
We are ready to file the affidavit, sir.
See, affidavit,
But
we have not also enclosed the grounds of appeal at the time of first appellate. That should make part of your paper book.
Every notice and order should be should be filed on the portal in an appropriate tab. This is what I am saying.
One thing is missing, that you have not appended grounds of appeal, which you have filed at the time of your first appellate authority.
Sir,
That
we
is
apologize
also
for that, and we will ready to file the affidavit.
Now my question is, Tribunal is the second appeal, right? This is not a case that he had taken this point for first appellate authority, right?
No, actually, if you see the order of the first appellate authority,
Your Honor,
that has been passed ex parte.
No, but Your Honor, that's what I'm saying. He must have filed the appeal.
Yeah. Yes.
Only then the appellate order comes into being.
Yeah.
Right? Yeah. That is there also, did not produce any evidence. My question is, taking these technicalities, though it's right, if it's not posted on the right portal, case has to go back. That's a settled law. He's not supposed to go through all the portal icons and see where this order is. But there are 5 dates sent to him. That's his conduct. Dates he is not denying, the notice is not, appellate order was not served on him. So that means his conduct itself is so horrible that this tribunal should not show any leverage to him at all. There is no mercy.
No,
5, 6 dates.
That 5 notices were also served him in which manner?
No, it's served on him. He is not denying a notice is not served.
not served means
No.
he did not.
Yeah. No, but there is no denial of him. We don't have to even ask you the question. There is no denial in the appeal. He has not served the notices. There is no affidavit filed by him.
Notices are served in the wrong portal. We have not seen. We were not aware of the notices and orders. And
my lord, he filed the appeal. He filed the appeal.
Later on, when
do you think he can file the appeal and take part? Supreme Court very clear. This is responsibility of the appellant to follow up. What happened to my case?
No, actually, it was the duty of the appellate authority also to give.
I appreciate you, Honor. I do appreciate this. Also, there are some.
To give him an opportunity of being heard before deciding the appeal. And in the process of giving of the opportunity of being heard, that person, he posted the notices on a portal which is normally not seen by the taxpayer. So if there are certain
My lord, when he filed the appeal, there was no such ground. That's why he wants to bring an additional evidence on record.
No, appeal mein to this person has not appeared at all.
No, what I'm saying is regarding the services of notices on the wrong portal, it's not a part of his appeal before tribunal. He's coming under application under Rule 145, additional evidence. So he's not sure what he wants to do.
My lord,
we are arguing with additional evidence only.
You see the order of the first appellate authority at 3 places. Dates year has been written as 2024 instead of 2025.
That's okay, that's a technical thing. We're not raising here in Moot Tribunal. Technical thing that we're not raising here. Let me told you.
The orders are issued in a casual manner. These are not technical.
Then we will hear him on merit.
Yes, I don't mind.
Proceed on merit.
Yes, ma'am. My lord, the department alleges that the company has given discounts to customers on B2C supply basis worth rupees 23 crore and issued GST credit note and passed on the credit to the customers. The appellant says and submit. The appellant says and submit that consumers are unregistered persons. Discount given to them are within the legal parameters and as per the industry norms. They have not claimed any ITC as per section 16 as they are unregistered. And they are not required to reverse the ITC in terms of section 15(3)(2) of the CGST Act. Section 16 talks about ITC and it says for the registered person only. Registered person is defined in section 294. So these provisions are not applicable in the case of B2C supply. The registered person has shown these supplies in the GST returns filed under section 39 of the as B2C supply. So all the financial receipts and payments from these customers are from the banking channel only, and their statement of account are confirmed by them. For your ready reference, we are filing here with confirmed statement of account of one customer on sample basis at page number 6 of the brief. My lord, page number 6 of the brief. We have issued an invoice. We have This is the statement of account.
Let the chairman come to that page.
We have issued an invoice for 6,40,000. We have received bank transfer of 4 lakh rupees. We have issued credit note for 64,000. And again we have received a bank RTGS 1,76,000.
Credit notes are post-sale discount.
Post-sale.
Discounts.
Yes, post-sale discounts.
And there was no agreement between you and your customers for.
So there is no need for the agreement. These are the customers.
Was it the policy of your?
This is the general trade practice in this paint industry.
Trade practice, but it is not specific because the question is specific. It is not general.
There are so many customers. There are no agreement with those customers. Whatever discounts we receive from the our supplier, that will be passed on to the customers. This is the general practice and trade practice.
Do you have any other invoices also to show?
Yes, I have given only one invoice on sample basis. There are so many invoices and statement of account, and these are confirmed by the customers.
The relevant subsection of section 15 provides two methods of giving discounts. One is discount could be given by reducing the price on the invoice itself. This is not your case.
Yes.
Otherwise, it could be given post-discount. There is a pre-sale discount and post-sale discount.
Yes.
And post-sale discount, you know, could be given only if there is an agreement to that effect with the buyer that on certain manner, the post-sale discount will be given. In your case, you don't have that kind of a sporting thing. And the second condition which you have fulfilled is that, and along with the certificate, that your buyer has reversed the case, but in your case, since the buyer was unregistered, so he doesn't have to reverse the ITC.
Yes.
Now,
Yeah.
there was no, you have not in your entire scheme, you have provided that this was the scheme which could also be interpreted as an agreement with the buyer. If the company has a scheme that anybody who buy 5 watches, he gets a 6th one free, you don't have any such scheme. You just kept on selling, and after a regular interval giving the cash discount without having any scheme to that effect, without having any agreement to that effect. So in that respect, we are sorry that this particular discount we will not allow.
My Lord, on attainment of certain milestone, I receive discount from my suppliers, and their discount is passed on to the customers.
That is a separate issue. But since we cannot go beyond what is written in section 15.4 or something, some subsection is there, which provide for 15.3b. In the B, if there were an agreement, if there was a scheme, if there were a mutual consent between you as a seller and your buyer as an unregistered person, we would definitely have agreed. But this condition of having a scheme or a pre-agreement is not there, so therefore this
It is a mutual agreement with the buyers, and they are unregistered persons.
No, not now, not now. I have read a scheme which says if you buy 2 ice cream, so you pay, you will get a 3rd free, and that is publicized and that is accepted. That also can be taken as an implied agreement. But in your case, even that kind of a thing is not there.
If I achieve a milestone, the schemes will be different from my supplier.
But the way you have given the discount,
कि 10 करोड़ की turnover पे, 20 करोड़ पे, 50 करोड़ पे, schemes are different.
Those schemes are in writing.
Those, it is in writing with the suppliers.
Agreement now.
Not from the, yes, my supplier.
So based on your suppliers'
Yes.
agreement, you were passing on the discount without any
agreement, without any understanding also.
As per our mutual consent with the, yes sir. Yes, as per our mutual consent of the
Lords, can I?
recipient.
Now friend, the question is of discounts. Most of us commit the errors which Chandresh has committed. Since this is a Moot tribunal, the appeals were given to him like this, so he had to respond to it. You have to read section 15 carefully. Yes. Section 15 does not distinguish between registered or non-registered taxpayer. Yeah. Only section 43(2) differentiates. If input tax credit has been claimed, that has to be reversed before you reduce output tax liability. Here his case is, he has given discounts to a customer who is a consumer. It's a B2C supply. Now when you read section 15, you have to read the law, raw law. No judgments. Please don't read about your arguments. It says the value of supply of goods or services both shall be the transaction value. Whatever you mention on an invoice, that's sacrosanct. If it is between unrelated parties, yes, and consideration is only cash, only then. Which is the price actually paid or payable for the said supply. That is when you enter into a supply contract, you have to decide at that time what is the price paid or payable. So if you read this line and then you go to 15(3)(b), like the Honorable Chairman said, invoice पे जो मर्जी दे दो, we don't question you.
right? But that discount is also between unrelated parties.
Yes, unrelated.
Not between related parties. So even that statement also has to be qualified. 15.3b says, 15.3 says, the value of supply shall not include any discount. The word used is only discount. After the supply has been effected, if such discount is established in terms of an agreement entered into on or before the time of such supply and specifically linked to relevant invoices. So if you don't prove, you have no case. Simply saying कि मैंने credit note दिया, उसने ये कर दिया, वो कर दिया, that doesn't cut ice. You have to establish that these discounts was agreed. Now supposing a customer doesn't pay 1 crore rupees to you, उस पे आपने 18 लाख रुपए टैक्स दिया है, तो will you issue credit note and save 18 lakh rupees from the government? Is this possible? The answer is no. Therefore, this case had to be made out by Chandresh that this was in terms of agreement established, linked with the customer. Now, what is agreement? It can be express, it can be oral, but oral you cannot prove anything. But government counsel like me will never agree that oral agreement को दुनिया में चीज है आजकल के time पर. So therefore, if you were to make out a case, there would have been a collateral agreement, evidence in terms of email or whatever you could draft, right? So here I think Honorable Tribunal has to take a call whether such credit notes can be allowed to be deducted for the purpose of output supply reduction in sales tax.
But here one question arises.
Next,
when
now
my recipient has not taken any ITC, is an unregistered person. How he can reverse the?
That is right. But Mr. Verma has said, if there is a debtor who refuses to pay you the money, why should the exchequer suffer? Because this is a very good tool to reverse the thing by issuing a credit note or debit note in your books of accounts and pass a journal entry. It should be substantiated with the written agreement.
See, the law does not distinguish.
I asked a question that whether there was an agreement between you and your supplier, you said yes. But between you and your customers, you don't have any agreement.
Milord.
I think next question we should do.
Next question is, you have given a compensation to a geyser manufacturer for a defective supply या उन्होंने आपके ऊपर को claim किया and you have given a compensation and you want to reverse ITC for that.
The department alleges that the company has given compensation worth rupees 2.5 crore to a geyser manufacturer for defective paint supplies and has claimed GST reduction. Department also alleges in the SCN, refer page number 13 of the paper book, that geyser manufacturer is a related person within the meaning of 15 be not disallowed as grossly violating the precondition of the law. The appellant says and submit that registered person has raised credit note for compensation to the geyser manufacturer for 2.5 crore and charged GST on it. The compensation is the income of the geyser manufacturer. The amount of ITC has been reversed by the geyser manufacturer and corresponding output tax liability has been reduced by the registered person. Section 15 of the CGST Act is applicable in case of discounts and not in the case of compensation. Discount is always pre-supply and compensation is always post-supply. We are filing here with agreement with the geyser manufacturer, claim agreement, claim document for your reference at page number 789 of the brief.
You see, because you have passed such a huge benefit to your geyser manufacturer. So there was any specific reason behind giving this and passing on this 2.5 crore rupees?
This is not a benefit passed on to the geyser manufacturer.
No,
it is a compensation has been passed.
Yes,
there is no benefit.
Listen, in your own words, it is the income of that geyser manufacturer.
Yes.
So you have passed on the benefit to him.
When we have sold the goods to geyser manufacturer,
okay,
it was on the particular specifications for the geyser purpose of the geyser. Sir, you please see the agreement for supply of paint at page number 7.
It is very casual. See, and if there was some defect, you had an expert team, you had a technical team.
Yes.
It could have been repaired, it could have been done to the best of the, in the interest of the revenue, in the interest of your trader and your supplier as well. So why did you not do that, Learned DR?
These are our technical matters and we cannot say anything about it because geyser is a certain item जिसमें जो भी उसकी स्पेसिफिकेशंस हैं उसके हिसाब से उसने पेंट लेना था. तो एग्रीमेंट में यही हुआ कि if there is any deficiency in the supply of the above said paint as per the specifications, Mrs. KM Trading Company will be responsible for the losses to the geyser manufacturer and indemnify the same. And the compensation, if any, as agreed between the parties to this agreement, shall be given.
एक सर हम आपसे पूछना चाह रहे हैं कि कंपनसेशन के लिए जीएसटी में कहाँ बेनिफिट लेंगे? Which section of the GST law, right from one to the end, under what section of the GST law you allow reversing of the ITC on paying somebody a compensation? कहीं भी तो GST law में कोई section बताएं जिसके अंदर आपको GST ITC रिवर्स करने की पावर हो या आपको राइट हो.
Mr. Verma, your comments about.
Yeah, Your Honor, Section 15 goes on a precondition of discount. It's a federal law, a compensation can never be discount. If compensation cannot be a discount, then the Honorable Tribunal has to say, even if his agreements and credit notes were all valid, can we say this is a discount?
No, it is not a discount.
If it's not a discount, this cannot be allowed. It cuts no ice whether a reversed or not, that is his problem. We are dealing a transaction effected by the appellant. If his transaction falls within the purview of law, it should be allowed. If it's not, because I don't see, like liquidity damages, can we say that they are discounts? No. Damages, can we say are discounts? No. And he is a trader. How did he have an agreement? I will remove your bank, give you compensation for defective paints.
Even if
so the whole contract gives rise to something fishy. He is only a trader in paints. He should have a next OEM agreement, then his OEM manufacturer was liable. Because all paints are sold to all these car manufacturers on this basis only. Therefore, in my view, discount is not a part of Section 15. A compensation is not a part of Section 15.
That's what we agree.
Do you have to say
but my lord, whatever compensation I have given to them, it is on the basis of the sub-technical reports. And this compensation, this will be borne by my supplier. I will not bear the compensation.
Let us now focus on this point. This can be your revenue loss, can be claimed in your P&L. And it is, for him, is the benefit. He can claim it as an income. So,
yes. So there is no revenue loss.
No, on GST law there is no provision of reversing any GST.
Learned counsel, if
yes.
you give somebody a compensation or if you are liable to pay somebody a liquidated damages or any other consequence, it has no GST implication. It doesn't involve supply. It does not. It is not a supply, and there is no section which allows you ITC reversal or any benefit under the GST law. It's a pure and simple legal case, financial case. It does not involve GST implications.
I think that's the right interpretation. You have to go strictly by Section 15. No words can be added or deleted.
Come to.
Let us conclude, sir.
Joanna. Come to next point, point number 4.
Sir. Answer, sir. Should we conclude it?
But we have already reversed the ITC.
You have not
then
reversed the geyser manufacturer.
What is the loss to the revenue?
That's what I am also saying, that it is a tax neutral. That's
tax
what I was
neutral
discussing
transaction,
with my
tax
chairman
revenue.
also.
No, my lords, there is no concept of GST being revenue neutral.
No, that is
No,
that is
there is no concept. This is a theory which Honorable Tribunal cannot go into to declare that GST is a revenue neutral law. It is not a revenue neutral law by any stretch of imagination. Because if you are giving a credit note to a consumer, he is not reversing. I will say if he is not reversing, how did you deduct? Then I'll go to this theory. Then in that case, is this revenue neutral?
नहीं सर ऐसा relevant कोई section है ही नहीं
ऐसा कुछ है नहीं इसमें.
But when he has not taken any ITC, how he can reverse it?
अरे ITC तो बात की बात है.
तो आपने कम कैसे कर दिया?
Compensation के
फिर तो you got enriched by law.
कैसे करेंगे?
आपने उससे 10 लाख रुपए का
मैन्युफैक्चरर ने तो टैक्स दे दिया उस पर.
I'm talking of you say revenue neutral theory.
Yes.
GST is not a revenue neutral law at all. It is revenue neutral to the extent that what inputs you have taken, you can deduct against output if it's eligible. So where your suppliers are fake, can you say they have filed 3B return, I am a revenue neutral? That theory doesn't work in law.
How the supplier is fake?
No.
In my case,
I'm raising a legal proposition. I'm raising a legal proposition.
I hope this tribunal will not give you a relief. This tribunal will not give you a relief, but definitely you can take these proceedings to the High Court and get it.
Yes.
But my submission is my case should be remanded back.
No.
I have all the evidences in my hand.
Law is not in your side.
I am telling you, you will get the relief from the High Court, not from the lower authorities. Because lower authorities will.
Don't make any such promise, please.
In my opinion, even High Court will not give you any relief.
That's why let's not
Okay,
go
next
beyond our
point.
brief.
Next point.
Come to point number 4.
The department alleges that the company has also separately charged in the bills taxes other than GST.
Yeah.
Silence, please.
Yeah.
Silence, please.
The department alleges that the company has also separately charged in the bills taxes other than GST worth rupees 54 lakh, but these have not been included in the taxable value.
The entire hall.
Please maintain the silence.
It is a related party transaction. The appellant says and submits that there are certain taxes other than GST to be paid by the company on behalf of the recipient. These taxes have been charged in the invoice on actual payment basis. The company has paid the taxes and to be recovered from the recipient on back-to-back basis.
You remember?
And there is no markup.
I think we have understood your
It
point.
is a case of pure agent, and we are filing here with documents for correspondence with the recipient at page number 10 of the brief. So on behalf of the recipient, we have paid some taxes, and that we are recovering on a back-to-back basis as a pure agent. So there is no GST on it. This is my submission.
कहाँ लिखा आपने? Where is this agency agreement, pure agency agreement?
सर मैं आपका काम मैं आसान कर देता हूँ. Pure agency concept.
No, I know. 31 I know, sir. But where is this agreement? They have an
clearly says that value shall include all taxes in whatever way you collect, except CGST, IGST, UTGST, and compensations. All other taxes which you charge, they are part of the value. And,
No.
And you have to charge tax on it. That's as simple as that. इसमें कोई ज़्यादा interpretation या ज़्यादा argument
No, sir.
भी नहीं है. It's a matter of very
Milord.
simple interpretation. मैं भी आपको पढ़ देता हूँ वो जो relevant portion है.
रिसिपिएंट के बिहाफ पर अगर हम कोई पेमेंट कर रहे हैं टैक्सेस की,
हाँ.
तो इट इज ए काइंड ऑफ रीइंबर्समेंट ऑफ एक्सपेंसेस.
It is not.
It is
the tax
and
you
it
are
is in a
paying on
pure
the
agent.
supply. It is
I am a pure agent for that.
No, you
There
are
is
not.
no GST on it.
In this case, you are not the pure agent. You are charging in the invoice certain taxes
Other than GST.
Other than GST. It could be customs, it could be toll tax,
Okay.
it could be some other kind of a tax.
Yes.
And for that, it is added in the value. It could be your professional taxes also, whatever you are charging. It could be any other expenditure. But concept of agency comes in a much different way. And here in the value, it is everything is chargeable, and you have to pay tax on all those taxes. Sir, sorry that even
You know
without
the
reading,
question is
so
the
simple.
question is
my friend has tried to make a debatable case. The reimbursements comes after the transaction is completed. Reimbursement presupposes a necessity of business where a buyer gives you an authority कि इसमें कुछ खर्चा करना आप कर लेना. Supposing you are a CST agent, आपने कस्टम ऑर्डर ले लिया, आपका प्राइस 10 लाख फिक्स हो गया, वो उसमें आपको अथॉरिटी देता है सर इसमें कुछ भी टैक्स लगे छोटा मोटा आप दे देना हम आपको दे देंगे. Right? This was not a case you made out below. Here also this is not your case. Therefore, in my view, the pure agency concept, though you have tried to make it debatable, it will not work here. And moreover, if you had charged taxes, you would have got input tax credit. There your theory of revenue neutral will apply. You didn't.
We are charging and...
now you cannot charge. Now you are paying tax. Now this is between you and your customer, whether he wants to get ITC or not. We are not concerned. So pure agency concept, strictly speaking, may not be applicable here. Though it's you have made it a very debatable issue, but not here. You have to still read the concept of pure agency. What does pure agency means? They are incidental expenses incurred after the contract is entered into. That you reimburse. But initially buyer knew that 54 lakh का tax उसका पता नहीं था हमको 54 लाख पे tax देना है. Can a buyer say that I don't know?
Sir, इतने argument की ज़रूरत ही नहीं है इसमें. Read 15(2)(a).
Because section 15(2) is not subject to the
yes. Reimbursement.
Section 15 is a standalone section. Yeah. You have to pay tax.
15(2)(a).
That is why the theory of agency is post-supply. Then you can have other agreement here. Section 15 is not subject to valuation is very critical. And valuation is a part of section 9. Friends, this is the only act in the world, I must have read around 20 acts of GST, where the charging section carries a valuation provision. You have to pay tax on supply as per value determined under section 15. There is no other law I have ever seen in sales tax or VAT where the charging section also lays down a principle of valuation. Therefore, unless section 15 is subject to some other section, which is not, section 15 is not subject to any other section. What section का reference ही नहीं है.
I give you one example. Chartered accountants, they prepare a float a company. जो ROC की फीस है वो हम जमा कराते हैं. That we reimburse from the client. तो GST is not chargeable on that ROC fees.
वो आपने बिल पे चार्ज करके देखो ना.
हाँ, वो भी
चार्ज करके देखो फिर बात करेंगे. बिल पे चार्ज करो.
अगर ROC की फीस भी
there is no markup in that.
That's okay.
Reimbursement of expenses.
The theory of reimbursement is there is no markup. But you start charging their fees on your bill, then let's debate what happens. Don't leave to DGST, they will run after you.
Sorry, learned counsel, but this is how the law is, and we have to go according to the law, and you also have to accept it. I think.
The next point, sir.
Cover हो गए सारे. और क्या रह गया?
No, एक और है जी.
एक और है.
The department alleges that regarding the credit notes received from the company's suppliers worth rupees 32 crore, copies of credit notes clearly show the companies had reduced their GST liability, but the company recipient in turn has not reversed the ITC. The appellant says it was for the supplier to ensure reversal of ITC by the recipient before reducing their output tax liability. Credit notes are dealt in section 34. Proviso to section 34(2), refer page number 7 of the brief. Proviso to section 34(2) clearly says that no reduction in the output tax liability of the supplier shall be permitted. ITC, if availed, has been reversed by the recipient. Page number 7 of the brief.
Page number 7 of the brief.
Yes.
This is
of the petition, no. जो ये appeal है, spiral bonding.
Brief की बात कर रहे
हैं. No, sir, आप paper book.
Paper book. हाँ जी.
Section 34.
Which para you are referring to?
Para 2.
Okay.
There is one proviso, provided that no reduction in the output tax liability of the supplier shall be permitted if the input tax credit as is attributable to such credit note, if availed, has not been reversed by the recipient. So there was an amendment in section 34 by the Finance Act 2025, and it is a prospective amendment. My case is for the financial year 22-23. So this amendment is not applicable in my case. So, my lord, for the fault of the supplier, the recipient cannot be penalized. The action should be taken by the department against the supplier only.
No, my lord, this is not the correct legal position, because if you go through Rule 40, Section 43(2), the claim for reduction of output tax liability by the supplier that matches with the corresponding reduction in the claim of input tax credit by the recipient shall be finally accepted and communicated if such manner as may be prescribed. So the 25 amendment only has made this more imperative. In a way, it is clarificatory. This law already existed. So I'm not raising this issue of whether it's a clarificatory or substantial amendment, but this provision already existed.
My lord, if this provision already existed, then what is the need for amendment in section 34?
I said maybe it's a clarificatory.
In 2025. And section 43(2) says, shall be finally accepted and communicated. So it is a case of communication. तो recipient जो है वो communicate करेगा supplier को कि I have reversed the ITC. Then supplier will reduce his output tax liability. So there was a need for the compulsory reduction, reversal of the ITC by the recipient. So this amendment came in section 34 in 2025. Now it is mandatory for the recipient to reverse the ITC.
My lord, the question is very simple. It was always the law. 43(2) is not a 25 amendment, it already existed. It already existed. At best, that's a clarificatory to force supplier to buyer must do it, or we will do a tax action. Now here, unless the buyer now reduces, supplier cannot reduce output tax liability. The effect of amendment is this, not the prior amendment that they will not reduce. That means if people owe me 100 crores at 28% car sale, I'll deduct in my books and say I'm not liable. So this law always existed. I don't think this case merits any attention.
Factually clarification करने to my understanding, you purchased certain goods for a higher value and subsequently you got the credit note. Is it the fact?
Yes.
And that means if I put it in a illustrative figure, you got a invoice for 100 rupees and therefore thereafter you got a credit note for 20 rupees. इसका मतलब यह है कि आपको 20 रुपये वापस मिल गए और 80 रुपये का आपने परचेज किया, लेकिन ITC तो आप 100 रुपये का ले चुके हो. Why will you not reverse it?
My lord, I am a recipient. I have received these credit notes from my supplier.
Yes.
The supplier has reduced their output tax liability.
ये कहते हैं मैं ITC रिवर्स नहीं करूंगा.
भाई 100
सर
रुपये
पहले जब 100 रुपये का लिया आपने 20 रुपये का ITC लिया, अब उसने 20 रुपये का नोट दिया, तो you want to unjustly and recheck the cost of exchequer?
Unless I reverse my ITC, the supplier cannot reduce his output tax liability.
But why should you not? If you got a invoice for 100 rupees और आपको 12 रुपए जो है ITC मिल गया,
सेक्शन 34 में अमेंडमेंट अभी आया सर.
सुन तो लो. बाद में आपने 20 रुपए का क्रेडिट नोट ले लिया, जेब से आपके 80 रुपए गया, तो टैक्स आपको क्रेडिट कितना मिलना चाहिए? 12 रुपए का या 9 रुपए 60 पैसे का? जब देखो ना, जब 100 रुपए की आपने परचेज करी तो आपको आपने 12 रुपए टैक्स दिया.
मिलॉर्ड, जो सप्लायर अपना ITC आउटपुट टैक्स लायबिलिटी रिड्यूस करेगा ऑन द बेसिस ऑफ रिवर्सल इन बाय द रिसिपिएंट, तो फर्स्ट
you will also have to reverse it.
There was no compulsion in the act.
My lord, we can take a view and proceed further.
Amendment came in the year 2025. The reversal was mandatory.
You have to reverse it. Okay, thank you. Thank you very much. Anyway, very well argued, but it was a case was of such a type to impart lessons to many other litigants.
Joanna, your order, Joanna. People have to know your order.
So we have gone through each of these points.
Excuse me.
Along with the points, we have also been stating our considered view on these. You want me to repeat those?
No. Just pronounce the last one.
ठीक है.
That means your appeal is not admitted, not allowed. Dismissed.
Appeal is dismissed.
Because all the details of each of the paragraph, each of the issues that you have raised, we have already decided. So the appeal not allowed.
Very well argued, Chandresh.
Yeah. One thing more, because we all are learning here. That is the main thing. You have attached your power of attorney. Whereas being a chartered accountant, you are required to enclose memorandum of appearance in form number 04, GST 04, which you have not done. So all the chartered accountants may kindly note that as per rule 72, you need to attach memorandum of appearance in form number GST 04.
Thank you, Lord.
Members are requested to maintain the silence, please. Before going for the lunch, we will take one more case. RK Khanna and Company, and the matter is bill to ship to, and the case is argued by CA Renu Sharma, and the government counsel is again Advocate Shushil Verma ji.
Well, friends, now we are going to argue a very technical subject where most of you commit serious mistakes. In whatever cases I have done, the transactions were not done correctly. Bill to ship to transaction is akin to E1 form under Central Sales Tax Act, where even Supreme Court was not clear what is an E1 transaction. There are 4 judgments, all 4 are different. Central Sales Tax was contractually webbed. GST law is not contractually webbed. Therefore, when you do bill to ship to transaction, your documentation has to be 100% perfect. Even 1% defect will render your ITC void. Bill to ship to transaction can be done before supply, during the supply. So it's a document driven concept. Section 10(1)(b) IGST does not give you ITC. It only explains what is bill to ship to transaction. ITC come through 16(1), 16 explanation. You still have to satisfy 16(1), 16(2), 16(3), 16(4). So simply based on bill to ship to IT is not available to you. So Ecom Coffee Guild judgment is still applicable in this case also. You still have to bring on record that the goods were physically delivered to a third party. Only after they are delivered you are entitled to claim input tax credit. So it is not a simple transaction. You do 20 transactions, your first was wrong, all 20 will be wrong. So you will be harassed to an extent you can't believe. The e-way bill aaya, e-way bills have no consequence in law. And only a proof that you entered into a transaction. E-way bill is not even a part of section 16(1), 16(2). So e-way money rule 138, which is a self-contained court. So what Renu is going to argue, a very interesting question, you would all love to hear. It's a pure question of law she is going to argue. Well, Madam Renu C.A. Sharma.
Your Honor, the appellant is before the Honorable Tribunal on question of law. The facts of the appellant are not disputed in this case, but the question here is only of law. The appellant is agreed with only one question of law before this Honorable Tribunal, and that is whether in a bill to ship to transaction, as prescribed in section 10(1) small b of the IGST Act, along with section 16 of the CGST Act, is it mandatory for the ultimate buyer to be a registered taxpayer in terms of section 25 of the CGST Act? And further, if the ultimate recipient was using the goods sent on bill to ship to basis for transactions of private property, for the construction of private property and not for his business purpose, Can it be the basis of rejecting ITC of the appellant who is registered and was supplying those goods for his business purpose? My lord, I would request to read section 10(1) small b of the IGST Act and section 16 of the CGST Act for better understanding of law here in the case of appellant. Section 10(1) small b of the IGST Act at page number 50, my lord. It talks about place of supply of goods, and clause small b says where the goods are delivered by the supplier, that is protector and company in my case, to the recipient or any other person, that is SV and company, on the direction of a third person, that is the appellant, whether acting as an agent or otherwise before or during the movement of goods, either by way of transfer of documents of title to the goods or otherwise. It shall be deemed that the said third person, that is appellant, has received the goods, and the place of supply of such goods shall be the principal place of business of such person. So only in this provision there is a concept of deemed delivery, my lord, when the third party is deemed to have received goods, when goods are delivered to the recipient and there is no restriction in law on being goods delivered to unregistered person by the supplier who is registered on the instruction of the third party that is also registered. I would like to read also section 16 for eligibility and conditions for taking input tax credit, which was rejected in my case. My lord, refer page number 54, please.
54.
Yes. Section 16(1) is a substantive provision which says every registered person, that is my appellant is a registered person, shall subject to such conditions and restrictions as may be prescribed and in the manner specified in section 49 be entitled to take credit of input tax charged on any supply of goods or services or both to him which are used or intended to be used in the course or furtherance of his business, and the said amount shall be credited to electronic credit ledger of such person. My lord, since the appellant is a registered person who is claiming the ITC and he is in the business of glassware and he sold the same to SV and company in the course of his business, so he satisfied the conditions of the main provision as is entitled to take credit of the same. Subsection 2 says, notwithstanding anything contained in this section, no registered person shall be entitled to credit or take credit of any input tax in respect of any supply of goods or services or both to him unless subclause small a says he is in a position of tax invoice or debit note issued by the supplier registered under this act. That tax invoice is issued by the supplier has been attached at page number 36, my lord. And clause B says he has received the goods or services or both. Here explanation has been given for the purpose of this clause. It shall be deemed that the registered person has received the goods or as the case may be services where the goods are delivered by the supplier, that is protector and company, to a recipient or any other person, that is SV and company, on the direction of such registered person, that is the appellant in my case, whether acting as an agent or otherwise before or during movement of goods, either by way of transfer of document of titles to goods or otherwise. My lord, there was no restriction put here also on the recipient being required to be registered for claiming ITC by the third party, and the third party is the appellant who is already registered. My lord, section 16(2) small c says subject to provisions of section 41 or 43A, the tax charged in respect of such supply has actually been paid to the government. That is, declaration has been given on page number 47 by my supplier for the discharge of my tax. My lord, section 16(2) clause small d says he has furnished the returns under section 39. So copy of the furnished returns are attached at page number 40 and 41. My lord, the appellant respectfully submits that there is no requirement in terms of section 10(1)(b) of the IGST Act
on the issue of registration of the party to whom the supplier dispatched the goods. Based on the direction of a third party, only the third party and the supplier need to be registered, and that too for the purpose of claiming of input tax rate under section 16 only. This is a short question before this honorable tribunal. So my prayer, my lord, in this case is that appellant case is on pure law, and we don't need any judgment to support this. My documents are not disputed, my facts are not disputed. Therefore, honorable tribunal should quash the order. The central issue before this honorable tribunal is only on this appeal, and that is a pure question of law. Before I close, though I am sure that honorable tribunal shall favor me in this terms of law, I must raise the issue that audit procedure was also not followed in my case. Section 65 does not give inherent power to conduct audit. It is subject to judicial conditions. I would refer section 65 here at page number 50. It says there must be a proper authorization done by the commissioner. Audit shall be completed within 3 months, and if not, then there must be extension given in a written by the commissioner. My lord, here the condition was not followed in my case, and there was no extension given to the proper officers by the commissioner. Still, audit was done, and show cause notice also issued on the basis of audit. I will also attach the letter given by the appellant for the request to get the permission given by the commissioner, but that was not provided to us.
You raised this issue
Yes.
before the commissioner also.
Yes, my lord. To the proper officer at the time of audit.
Proper officer also, and thereafter before the first appellate authority also.
Yes, my lord.
Okay.
Pursuant to the audit under section 65, the proper officer issued the show cause notice and also adjudicated the show cause notice himself. That is SCN and page number 27, and order at page number 30 has been attached, which was done by the proper officer himself. My lord, the principle that no party can be a judge in its own cause is a cornerstone of natural justice, aimed at ensuring impartiality and fairness in legal proceeding. It is essential for maintaining public confidence in the judicial system. Supreme Court of India has constantly upheld this principle in various judgments, reinforcing that no one can be both a party and a judge in their own cause.
We have already decided on it, on this issue. Yeah. So, Mr. Verma, do you have to say something?
My lord, I am afraid I cannot support this order. This order is...
You cannot support this.
No, I cannot support
it.
It's not in accordance with law.
Yeah, because she is very well said. Since in this particular case, they have raised the objections at every stage.
Not really objection, even on the merits.
Even on the
the
merits also.
buyer did not get recipient.
Yeah. So that since they have argued the matter and asked framed the questions also, that whether it is an allowable ITC or not, it has to be disallowed or not, whether there was a violation of time limit, whether there was a lack of jurisdiction or not.
I think that's already decided by on the merits of bill to ship to. I cannot support this order.
And bill to ship to also it is a genuine thing. They can very well supply it to the end user also, which was used for the construction of the material.
Yes, ma'am.
So this appeal is allowed, and I'll request my chairman to please read the order.
Allowed. I fully agree with my brother.
Next time you will not win from me. I'll give you a more difficult case.
One moment, sir. I like to congratulate Renu, because the manner she has submitted her papers are absolutely in agreement. Are absolutely in agreement with.
She's a serious student. She's taking training very seriously.
As per GST, GStat rules, I was not able to find even a single deficiency in her papers. Number one, the way she was arguing the matter, that is also has to be commendable. Why? Because not only she was speaking, she was also referring to the page number so and so. This is attached as page number so. So this type of arguments we normally come across in the high courts only. Yeah. So he has done just a super job, I can say.
सारे बहुत अच्छे हैं, उसका केस थोड़ा सिंपल है. अभी अब जब अगली बार रिफंड में देखेंगे फिर देखेंगे.
Members.
Wait. Now, this Renu's case raises two more lessons for us. Simply because bill पे लिखा है bill to ship to, it has no sense. और सारा बकवास है जो लोग बिल बनाते हैं. You have to keep collateral evidence on record कि you intended to do a bill to ship to transaction before or during the course of movement. It's further qualified by transfer of documents or otherwise. Or otherwise has to be read as justum generis to the transfer of documents. It can be email, it could be letter, it could be WhatsApp, whatever evidence is admissible in law. So simply don't go to authority, मेरे पास bill to ship to का bill है. If you have more evidence, so even if a supplier had some problem with the authorities, you still can have collateral evidence to support your transaction. It was a genuine transaction. And do not claim input tax credit till you have a confirmation report from the end buyer that goods have been delivered. ITC cannot be claimed because section 16(2) uses a past perfect tense. Goods have been received. It's the past perfect tense. So till you have physically received the goods, made a goods receipt note, entered the stock ledger, ITC cannot be claimed. For example, in case of cars, you have to give 20 crore advance, they issue you a tax invoice. Cars come after 2 months. You cannot claim ITC based on tax invoice. There are no goods. So in bill to ship you transaction, be careful, it may take time. Supposing somebody from Calcutta is sending the goods from a village in Rajasthan, it may take 10 days, 20 days. It could be high supply. And all other laws apply. For example, continuous supply of bill to ship to transactions. Law remains same. In there also you will not get the ITC till last bill is raised. It's only a transaction saving some money for somebody, like E1 form. All other laws, rules and regarding ITC in section 16, 17 remain. Thank you very much, Mr. Ahuja. What do you want to say now?
Friends, it's time for a lunch and the court is adjourned for the lunch and will resume its proceedings after 1 hour.
1 घंटे का लंच?
1 घंटा लग जाएगा, बहुत लोग हैं.
सब हमारे लोग इतना ऐसा राजमनी ने खाना बनवा रखा है.
We will resume the proceedings right at 3 p.m.
Okay. ये ले लो यार, यहाँ छुड़ाओ यार.
अब हम ग्रुप के बंदे हैं, आप जल्दी नहीं है 1 घंटे के लिए.
मेरे ख्याल में वोट तो उतार के रखते हैं, वोट तो उतार के रखते दोनों में है.
मैम 2 मिनट जाओ आप वापस आ जाना 2 मिनट
जा रहे हो बस इतनी जल्दी?
ड्राइवर आ रही है ना, उसको सामान दे दूं कुछ।
मुझे लगा आप जा रहे हो।
बिजी स्केड्यूल मैं भी
तनिष्क बाहर जा रहा है तो बोल देना हैं। बाहर सबको बोल देना कि वापस आ जाएंगे।
मैं बात फ्री होकर बात करता हूँ।
Please maintain the silence, please, so that we could start the proceedings. Everyone should take their seats, including judges. Everyone should come there, take their seats. Members are requested to maintain the silence so that we could start the proceedings.
I have a good news for all of you. We have birthday of Mr. Balram Sangal, our senior most advocate. He's turned 95 years today. And he's still in practice. We have our Celtex Bar President, Mr. Sanjay Sharma amongst us, and he's enjoying your company. He says people are doing very well. So let's welcome Mr. Sanjay Sharma also. Let's pray for long life for Mr. Balram Sangal.
I think he has turned 97 today. He is 28 now. 1928. The retreat to reads 28, 1928.
We have members from Mahanagar Tax Bar Association, Ghaziabad. We welcome all of them from the core of our heart. Now, to start the proceedings, item number 5. Ankit trademark and patent services, argued by CA Ankit Mittal and Government Counsel Advocate Shushil Verma. It's a matter of erroneous refund. CA Ankit Mittal.
कोई बात नहीं. कौन सी है? अंकस्या ट्रेडिंग कंपनी इसकी है. नीचे पड़ी ये क्या किसका है? नहीं आप रोटी खा लो.
Well, friends, now you have a case under section 73. An exporter who is not a 100% export unit. This is your case. He has claimed input tax credit for accounting and consultancy services. He was given a refund. The revenue has raised an objection that you are not entitled to refund. Number one, these activities are not directly related to exports. Second, since you are not a 100% AOG, so therefore the proportion of tax versus zero to supply has to be deducted. So it's a legal question. Can revenue raise this question and deny them refund under section 73 or 74? Case of erroneous refund. This case will teach us a lot of things. 73, 74 are conditional jurisdictions.
in the show cause notice, they must write whatever condition they have making a case against you, that condition has to be factually satisfied. So if we are able to prove as a jurisdictional issue that jurisdiction has not been properly assumed, courts will quash this order immediately. It's like reassessment cases of 148. You have to assume jurisdiction based on those facts. Therefore, whenever you have this show cause notices, don't cut paste copy of some expert's reply and start writing. No. First see, read 73, 74. Have they satisfied those conditions? कहीं लिखा है कि आपने short पे कितना टैक्स किया, आपने टैक्स कितना पे नहीं किया, कितना आपका wrongful IT है, how this is wrongful IT? That finding must exist in the show cause notice, which is the foundation of litigation. So if the foundation is weak, case cannot come up. So based on this, Ankit Mittal, he's our young chartered accountant who is going to argue this matter today for the first time in any tribunal. Let's welcome him.
Good afternoon, my lordship and companion members. I would like to take permission before your permission to start the proceedings. Sir, this case is related to a refund order under section 54, where refund was claimed on account of export of goods without payment of tax. However, an adverse order has been passed under section 73, alleging the refund was claimed erroneous. So I would like to take you upon the background of the case. So SSE is in engagement in the trading of a government business. He also do export as well as domestic taxable turnover. He is not into any exempt turnover and not has been claimed any ineligible ITC as well. Refund was initially sanctioned for the financial year 21-22. Later on, a show cause notice was issued citing two main allegations. First, the refund pertain to services that are not related to export, and the second is appellant is not 100% exporter, so hence ineligible for refund of services. The appellant appeared for a personal hearing, and despite this, order was confirmed and the demand was raised. Appellant also filed an appeal, but no relief was granted, and the order was upheld in toto. So now these, as I mentioned, that there is a two allegation. First was ITC not related to export. So in this regard to this, I would like to mention that if you the services which is in question are related to accounting services and consulting services. So first, is it not related to my business? So I would like to share, if your intent, if you would like to read section 16 with me. It is on page number 32. So it says, every registered person shall, subject to such condition and restriction as may be prescribed and in the manner specified in section 49, be entitled to take credit of input tax charge on any supply of goods or services or both to him which are used or intended to be used in the course of furtherance of his business. So my lord, I would like to mention that whether accounting services and the consulting services are not related to export of related to my business. Here in section 16, it is mentioned that any supply of goods or services and to be used in the course of furtherance of business. The business definition as mentioned in section 2, subsection 88, it is mentioned like business include, it's an inclusive definition which says any trade, commerce, for any trade, commerce, manufacture, profession, vacation, adventure, wages or any other similar activity, whether or not it is for pecuniary benefit. Any activity or transaction related to the trade. So that means any services which is related to my furtherance of business must be eligible for the ITC as per section 16. The accounting services which I am receiving from a consultant, the section 35 of CGST talks about keeping books of account, whether it is necessary to keep books of account with the SSE. Section 44AA of Income Tax Act also says that you need to keep your books of account. So whether it is from the from if I hire someone on payroll, or it is from if I'm keeping my books using some consultant, I don't think there is any difference between it. So either I am keeping a salaried person, or I am keeping my books of account with the help of any consultant. So, and the further second, the consulting services which is also in question. So in regard to this, I would like to mention that these services are related to business expansion for decision making, whether we need to do or not. The sample invoice also has been enclosed as an excerpt. So that is also, I would like to mention that it is also linked with my business. The second, I would like to mention, like, is there any nexus is required while claiming? Yes, I am not a 100% exporter. I also do some domestic supply. So is there any nexus required with my export turnover, with all my services or input which I am using in my business? So I would like to take your attention on the section 49. That is on page number 41. The section 49 subsection 2 says the input tax credit as self-assessed in the return of registered person, that is GST 3B, shall be credited to his electronic credit ledger. So any input which I am claiming, it will be part of my electronic credit ledger, and there is no criteria, there is no way to identify which credit has been clubbed in my electronic credit ledger. Electronic credit ledger is a pool where lot of ITC, whether it is related to input or services, it become club in the ECL, and whenever we use it, it's not possible to identify that which ITT has been used or which is remain in ECL. I would also like to read upon subsection 4 of the same section 49. The amount available in ECL may be used for making any payment toward outward tax under this act. That means whatever the ECL available in my electronic credit ledger, that must, yes, that must be an eligible input. So it can be used for any payment towards output tax liability. So further, I would like to mention if you do you have, sir, this Aristo Bolin Private Limited case I have shared with you. Say, I would like to read you the page, that is para 15. It is on page number 6. Sir, appellate find that we find that section 16 subsection 1 nowhere mandates to prove one-to-one correlation of particular input with particular output supply.
He is talking of which case now?
So hence, I believe no strict one-to-one linkage is needed between ITC and export activity. The second allegation, sir, the second allegation was 100% that the appellant is not 100% export-oriented unit. In regard to this, sir, I would like you to please read Rule 89, Sub-Rule 4.
Page number?
So page number is 52.
Page number 50.
In this para, sir, in this sub-rule it is mentioned like, in the case of zero rated supply of goods or services or both without payment of tax under bond or letter of undertaking, which is our case, in accordance with the provision of subsection 3 of section 16 of IGST Act, refund of input tax credit shall be granted as per the following formula. So there is a specific formula is given under the law, that is in Rule 89 sub Rule 4, which is related to SSE. Those are in export business as well as the domestic business. The formula itself says under capital B, the net ITC means input tax credit availed on input and input services during the relevant period. That means we are eligible to claim input credit refund of related to the input and input services. Further, the formula also says that the proportionate ITC will be allowed if you are not an 100% export oriented unit, but you also have a domestic turnover. So whatever the amount which is linked, which is eligible for the export turnover, it will be proportionately allowed. That is also confirmed with by the Supreme Court under the VKC Footstep Private Limited. The interpretation was upheld by the Honorable Supreme Court, where it was held that the refund formula under Rule 18(9) sub Rule 4 is legally valid. The design of the formula is a matter of legislative policy based on economic and social consideration, and court should not intervene unless arbitrary. Therefore, refund cannot be denied on the ground that the applicant is not 100% exporter. This is all from my side, sir.
My lords, this is a question of interpreting section 16 CGST Act, section 16 IGST Act, and there is a finding that on 100% export unit that we are also doing sales in the DTA area. So if the total turnover is 100 rupees and domestic sale is 20 rupees, the export turnover is 80 rupees. That is what adjusted turnover in Rule 89 formula means. When you take the formula of net input tax, Rule 89(4) itself defines what is adjusted turnover, right? Number one. I fully agree with him that GST doesn't require item to item correlation. But since he is not a 100% export unit, the ITC is governed by section 16 only. Section 16 IGST only defines input tax credit, and Rule 89(4) also gives a formula for ITC which is eligible, right? So tomorrow we say that they have not paid 180 days to a customer, so will he be entitled to input tax credit? Answer is no. So section 16 has to be satisfied notwithstanding whatever claim we have, and section 16 when we go through, my friend has read section 49, it goes against him.
Yeah,
it goes against him.
I agree.
Sorry.
Pro rata, he should get it pro rata relationship of export vis-a-vis.
No, sir, we'll come on that also.
Yeah.
Because this question is happening in export states in a big way. Section 16 says, section 16 deals with only eligibility of ITC. It has no connection with availment utilization. So all of you must remember section 16 has no connection what you claim in the return, what you utilize. It satisfies only eligibility conditions. Section 16 says every registered person shall subject to such conditions and restrictions as may be prescribed. Then there is the word and in the manner specified in section 49. Section 49 talks when will you utilize and all that stuff, right? And by way of section 20 of IGST Act, even for interstate supply, the export and industrial supply, the provisions of section 16 apply. Your case is very limited. You made that claim that 2,46,000 input tax credit based on accounting and corporate services, right? I am not saying you have to prove that you have done only for export.
सर आपकी आवाज नहीं जा रही.
Hello, Amare? So therefore, you need not prove that whether they were related or not. But what happens to section 17? Does section 17 gives you a leeway Okay, you make a 10 rupee export, 90 rupees domestic sale, you will get full refund on 10 rupees? Is that possible? That is why the adjusted turnover was defined in Rule 89.4. Vacancy footsteps only confirmed Gujarat High Court ruling. They say this formula does not require any amendment because there is no other way to give refund. Therefore, my lord, I will say, okay, let this case go back with the direction to compute refund in accordance with law. Let the assessing adjudicator do it again. And then on the first case, we can say that the attempt at reconciliation is not required.
I think this is exactly what you have said. You have said you have made a partly export supply and partly domestic supply.
Right, sir.
And you also mentioned that in rule, I think 89, you mentioned that whenever such a situation is there, pro rata refund you are entitled.
Agreed, sir.
But you have got a refund for the entire amount.
Sir, entire amount, that's I agree. But the point, there is another point.
Sorry, let me say it.
Ji.
While you are entitled to the ITC of the entire amount, but are you entitled to the refund of the entire amount? No.
Sir,
you are entitled to refund of the pro rata amount in proportion to the supplies, export supplies. Rest of it, you can use it as your input tax credit for the other domestic supplies.
We are talking of cash refund under 5431, not 5432. We are claiming, you are claiming under 5431. VKC footstep was on
Right.
services.
Yes, sir.
Right?
Right.
So, there's a little misnomer there also.
True.
16, 17, they are interplay between 16
Right,
and
sir. So I would like to
let this case go back. Let the adjudicating authority decide this because tribunal cannot create new facts
It
here.
is also on services. It is
But
an
sir, my
accounting service
interpretation
and-
was little bit different actually. So when the in the order itself, it is mentioned like I have claimed the ITC of some particular invoice. But when the ITC it become a part of the pool, I am claiming a pro rata in ITC only. When I claim the X amount, department is their understanding is the X amount has include the ITC of related to that.
जो आप rule play कर रहे हो, it will transfer the electronic credit ledger. It doesn't mean you are entitled to refund based on that. That is what 61 say as may conditions may be prescribed and rule section 49. Rules cannot override act in any case, but that the rule also, the way we are interpreting, I think is not a correct interpretation. The money has to go to your ECR. You deposit cash, you go to ECL. That's all. So you mean to say that you claim wrong input tax credit?
No.
Wait. It's a legal proposition. This is how you argue a matter. You claim 10 lakh rupees wrong ITC put in electronic credit ledger. Are you entitled to use it?
No, sir.
This is the case here. Let it go back. You prove whatever you want to claim. He'll pass the order. Live for another day. Why do you want to die today? Die tomorrow.
He is entitled to the entire amount of ITC, including for the accounting services, whether linked to export or not, irrelevant.
That's a finding in your favor.
Now, whatever output you generate, partly you export, partly you domestically sell. So your refund should be in proportion to that.
That formula also says so. Adjusted turnover defines that way only.
Yeah.
But
I am telling it
sir,
in a very
this
simple
application
words.
was online, so it is even not possible in the portal to claim the 100% amount. The ITC was claimed proportionately.
That since there is an adjudication order, right or wrong, now you prove before the proper officer.
Right.
You mean to say that you have claimed only proportionate, not
Proportionately,
the full.
right,
So
sir.
the refund which has been granted to you is based on that formula only.
Only, yes, sir.
No, it's not a part of the case.
Then what else do you need? Yeah, this is what is
No,
entitled.
but this is not a part of the case, no? This is not a case made out below.
You have not.
Yeah.
You have not brought this
Prove it
fact.
there. You get the refund.
But sir, is it not even possible to claim the refund,
No, that
the
is something
whole amount?
different.
It is because portal is not allowing.
You have not mentioned this entire thing either before the first appellate authority, not before us also.
How do we know? Mala, are you expecting this tribunal to go on portal working? Anyway, I think up to the tribunal.
We quash this order and remand it back to the
Sure, sir.
department
With the directions.
With the direction that pro rata refund should be
Allowed.
allowed. Only
Thank you,
to the
sir.
extent
Thank you, my
of
lord.
pro rata refund should retain. In case you have claimed more than that, you will pay back with interest and use
Definitely.
it for your input for domestic supplies.
Right.
Am I okay, sir?
formula. फोटो पे डिपेंड आता है क्या आप खुद क्या
IT is allowed, IT से कराएंगे।
नहीं कर सकते अभिजीत नेक्स्ट वन
सर ITC which
well done माइक हो जाएगी कौन सी है well done
Item number 6, Messrs. Rehem Enterprises,
इस पे नाम
argued by
तुमने करना
CA
ही
Mayank Ahuja.
नहीं इसमें यही है
CA Mayank Ahuja and the matter is irregularities found in high C sales. CA Mayank Ahuja.
अभी तो देखी थी मैंने भी सारी राजमनी में बहुत सारे पेपर दे रखे हैं यहाँ मेरे पास ये रहे नहीं ये तो उनकी थे बाइंडिंग वाली है ये स्टार एक्सपोर्टर है टैब भी मिल सकते हैं मैंने भी देखी थी नहीं मैंने भी देखी तो थी यही है ये है Now friend, this is a case of high C sales. Again, a very critical issue in western states where high C sales takes place, including Delhi. There were irregularities in high C sale agreement itself. The custom duty was paid by the high C seller. Bill of entry was also filed by high C seller. And the packing list of goods imported and sold did not match. And they claimed full input tax credit. And the revenue officer rejected high C sales, treated the same as interstate supply and taxed it. So it's very technical, pure question of law. Yes, Mayank.
Sir, may I with your kind permission?
Please start. दोनों माइक सब सर
Sir, first I would like to give the background of the case. My appellant is engaged in trading of mobile handset, including export or import transaction categorized as high C sale and merchant export transaction. Basically, this case is revolved around 4 different issues in high C sale. First is exempt supply issue. Number 2, not contain packing list or item details. Number 4, bill of lading is favor of buyer, but custom duty is paid by my appellant, Rehem Enterprise, and lack of signed document. So I am going one by one each of the issues. Sir, first allegation was high C sale being exempt supply. So why there is no reversal of ITC in terms of section 16(1)? In our humble submission, it is showing that there is a retrospective amendment made by Finance Act 2023, which says that these kind of transaction will not cover under exempt supply. This is covered under schedule number 3, which is saying no supply, no supply. So it is outside the purview of GST. Once it is outside the purview of GST, there is no question of reversal of ITC. Now coming back to second point, allegation by revenue that high C sale invoice does not contain detail of items like packing list, all these are not covered. But sir, in GST there is no such compulsion. We are governed by only custom law. We already filed shipping bill to the custom department, and EGM also filed. EGM can be accessed via DGST website also. So it contains all the relevant document which is required for the export. So my humble submission is that in case of these procedural lapses, we cannot deny that this is not a valid high C sale, because only what is missing detail of items and packing list. But identity of goods is similar to what we have imported and what we dispatch to our buyer, Ahan Enterprise. So there is no, there is no difference in identity of goods. So high C sale cannot be made invalid. And there are some judicial pronouncement also, which saying that if you have a complete document trail, you can establish your transaction with the help of bill of lading, commercial invoice, bill of lading, commercial invoice, and bill of entry, which can substantiate that high C sale is a valid and there is no question of reversal of such ITC. Third point is, while bill of lading was endorsed in favor of buyer, but custom duty was paid by our appellant. So this was due to some working capital issue. So we have paid from our own pocket and taken the reimbursement later on. But what point is this? High C sale is a transfer of ownership before goods cross into India custom frontier. Because as per Custom Circular 33/2017, as per annexure number 9, it's saying that if title, annexure number 9, last page, page number 33. Yeah. Yes. It fulfills. It says that high C sale transaction is valid when these four conditions are fulfilled. Number one, title to goods is transferred after dispatch but before clearance. Number second, proper document exists like bill of lading endorsement, high C sale agreement, and invoice, etc. And last is final importer, who is a buyer, filed the bill of entry. In our case, buyer already filed the bill of entry in his name. The only thing is the custom duty is paid by our appellant. So it will not invalidate. It will not invalidate the transaction of high C sale. There are some conditions which make high C sale a genuine and legal valid. Conditions are timing of sale must occur before custom clearance, which is happened in our case. Execution of high C sale agreement. At the time of audit, we have not submitted our high C sale agreement because our appellant was working in a small town, so he was not aware about the compliances. So we have submitted ratified bill of ratified high C sale agreement, which substantiates the original agreement. Endorsement of bill of lading is there, invoice under high C sale is there, and buyer has to file bill of entry, which is legally satisfied. Now last point is lack of signed agreement by the proprietor, who is the final buyer. And also there is a lack of formal loan agreement between Reham Enterprise, who is our appellant. I am referring to page number 20. Point number D. Page number 20, point number D. While examining the transaction, respondent find that there is a lack of signed agreement by the final buyer, who is the proprietor, and also lack of formal loan agreement between Reham Enterprise, who is our appellant, and Messer Ehsan Enterprise, who is the final buyer. So revenue allegation is why we should not treat this outside the purview of high C sale and treat it as an interstate supply. This is just like a procedure lapse, so we cannot treat it as an interstate supply. There are a case law named Dempo and Company, which says that where substance over form has been emphasized, so due to procedure lapse, we cannot deny the benefit to the appellant. So these are the areas which cover legality of the high C sale. Now coming back to merchant export. In case of merchant export, we have mentioned that merchant exports are not properly defined in the GST Act, whereas rule number 46 of CGST rule 2017 allow supply made for export through third parties or intermediary are valid export, provided
goods are exported from India, which is true in our case. Foreign buyer and foreign remittance can be proved, which can be established through foreign receipt. Number third, shipping bill, bill of lading and export invoice contain buyer details. So these are the sufficient conditions to make my merchant export a valid one. Now question is, why should not we hold refund of unutilized ITC? In case of merchant export, when we are charging only 0.01%, so we are making all the outward supply through the LUT. So our outward supply is exempt. So whatever ITC we have accumulated through our purchase, so we are claiming refund for those ITC. There is some judicial pronouncement which says that if there is a procedure lapse, you cannot deny various substantial benefit, which is true in my case. And further, prayer is that set aside the impugned order dated 30th August 2024, passed under Section 73 of DGST Act and order of First Appellate Authority date 27 Feb 2025. Page number 25. And my second prayer is hold the high sea sale transaction as a valid export transaction under the GST and exempt from the tax under section 16(1) read with section 17(2) and rule number 42 of CGST Act rule. Confirm the claim of refund of unutilized input tax credit under 54 subsection 3 in respect of merchant export transaction. And quash the demand of tax amounting rupees 1,50,150 and interest rupees 86,200. So we are requested for waive interest and penalty on the ground of bona fide nature and technical lapses. This is all about my submission.
Sir, before we seek, solicit your arguments, there are a few things which I have noted in your submission. Yeah, learned counsel, first of all, your power of attorney is missing. You have not enclosed power of attorney.
Sorry, page number 26, I have attached my affidavit. Page number 26.
Affidavit, that is not power of attorney. Now that go through the affidavit. Affidavit is always I. Who am I? My name is so. Then identity, proprietor, director, and I am fully competent to make this declaration, this affidavit. That is also missing. That's also defective. That's a procedural.
Okay.
Second, now you come on page.
But power of attorney, affidavit may be procedural, but you be authorized representative.
No, both are defective. This is what I'm saying. Both are defective. Even affidavit is defective. And then a affidavit can be made by one person. Two persons cannot give one affidavit. They have to give different. So you have been appointed by authorized signatory of Arham Enterprises, authorized CS so and so, which is not a proper language. This is lit.
Okay.
So you have.
Okay.
Now, one thing more. See page number 13 of your submission, learned counsel. You start statement of facts, appeal against order. Then your next is your humble appellant respectfully. Of course, once you are making submissions respectfully, you are humble enough. Now, third word is we would like to hear from you. What is that word?
You are humble appellant respectively to submit
back
statement of fact.
Bag. So it is something which is not expected from an elite club you belong.
Okay.
It's a substandard one. In future, avoid this terminology in your
I will take care.
So this is my suggestion. Although, now, sir, your comment.
This is the question as per law.
Mic.
एक मिनट बैटरी चेंज करेगा. एक मिनट रुक जाए सर, वो बैटरी ला रहा है दूसरा. सर आपने लंच किया ना, माइक ने नहीं किया सर।
वर्मा साहब को बात करने के लिए माइक की जरूरत नहीं होती है, उनकी आवाज पहले ही बहुत बुलंद है।
पीछे आवाज दी जाती है और कोई प्रॉब्लम नहीं है।
ये ले लो तब तक।
हो गया सर, वो तो चेंज होना था बस।
ले लो, हमें सुनना जरूर है। हेलो हेलो, आर यू एबल टू हियर? नो। वो बोल नहीं पाऊंगा। हेलो हेलो, आप ठीक है? यार ये लोग क्या करना है अपने करो, इसको जो करना है, चलो मुसीबत ध्यान छोड़ो। Now, Your Honor, this question of Mr. Mayank Ahuja involves a very serious question. It has three legal issues. It's the interplay between Section 16, 17 and Section 16 IGST Act. Then Schedule 3, Subclause 8. And the basic documents being void ab initio. If I issue a check unsigned, is it an error of procedure? Will the bank ever honor the check? If I give a blank check to somebody, even in discharge of a debt, will you invoke Section 141 NI Act, Negotiable Instrument Act? The answer is no. So if you are giving an agreement which is not signed by anybody, maybe the PN signs or somebody, and which they themselves say this is an error of procedure, I think this goes to the basic root of the transaction. And when you comply this, when you interplay this non-signing with the facts of the case, this also creates problems. Bill of entry they file, custom duty they pay on behalf of the buyer. The custom circular does not ratify these kind of irregularities. Custom circular has been incorporated only because Section 3 of Custom Tariff Act says the imported goods bill shall be valued as per custom law. Section 15 CGST Act does not apply to imported goods. So Custom Tariff Act has to be invoked. In that connection, they invoke Custom Circular and IGST Act to the extent that what will be a high C sale transaction. So if you have a high C sale transaction, then the Schedule 3, Subclause 8 will be applicable to you. But if very genesis of your transaction is being questioned by revenue, you have to come clean on this, right? Now, what is a high C sale? The definition you are quoting, that is Section 5(1) Central Sale Tax Act. Yes. What does Schedule 3 says? Let's read. Supply of goods by the consignee to any other person by endorsement of document of title to the goods after the goods have dispatched from the port of origin located outside India but before clearance for home consumption, right? Now, this does not say it's a high C sale. Does it say it's a high C sale?
No.
This is 5(1)(a) of Central Sales Tax Act.
Okay.
Not 5(1)(2). Right? Now, once you draft this appeal, now this is off the record, you had to read this and satisfy this condition in your appeal. So once you maro tukka and some Google finding and we start writing appeals, then you are questioned. Whenever you seek exemption, first is read that provision. You don't have documents, create them. I mean, don't create you, let your client bother, not you. Right? Now this says if supply of goods by the consignee to any other person by endorsement of documents You have not proved you have endorsed the document. There's nothing on record. Title to the goods, after the goods have been dispatched from the port of origin, there are no dates mentioned.
Buyer.
I'm coming on that also. After the goods have been dispatched from the port of origin.
But that has been filed with the custom department, no? IGM, EGM and...
I appreciate, but where are you claiming exemption? Under GST law? Where are you claiming exemption?
No,
the circular is issued for the purpose of IGST Act only, not for customs. Just read the circular. I know the circular very well. Just read the first para of the circular. Podo.
1 minute.
Last page, second last page of your appeal. Only read first paragraph. पढ़ो जोर से. आपने हाईलाइट किया हुआ है IGST एक्ट. Your Honor, this circular of 2017-33 says, reference has been received in board regarding clarity on leviability of IGST Act on high sea sales of imported goods.
Correct.
So this is only levied for IGST, there's no connection with custom.
IGST.
Now read point 5. Just read.
You're referring to page number?
Last page of your
last page. The above decision of the GST Council is already envisioned in the provisions of Section 3, subsection 12 of Custom Tariff Act, in as much in respect of imported goods, all duties, etc. So it is not giving any validity to your lapses of procedure. It says if you have done this and you satisfy other requirements, you are in high sea sales. I fully agree with you. A technical violation of procedure should not deny substantial benefit. But you have to prove this is a matter of procedure. So you give a check, blank. I file a case against you. You are sent my magistrate for charge sheet. You say, no, sir, I will sign it now. It's violation of procedure.
This is a ratified agreement, no, sir?
Why ratified? Why not the original?
Because due to lack of awareness, because our client is belong to small town, so he was...
Business, any kind of a business, is expected to know the law of that business. Ignorance of law, is it excuse? But there should be some reason that later on you came to know and you got it signed on a back date. What
No, not on a back date. We have just ratified the original agreement. Due to audit team has not demanded for the agreement.
No, audit team has to demand nothing. Why should they demand? It's your claim you have to prove. Why should an audit team demand from you? Once you make a claim in the return, you have to have all evidence in support of it. Why should revenue demand from you? You prove your claim. They say your claim is not valid. Prove it. Learn this lesson. Litigation strategies are not on hearsays. We are in serious business of money. So we need to spend little more time. Very well drafted appeal, but little more time. Now read 17.3, which you have not read. Explanation. It says, for the purpose of subsection 3, the expression value of exempt supply shall not include the value of activities or transactions specified in Schedule 3. Roman 2, the value of goods, activities or transaction as may be prescribed in respect of clause A of section paragraph 8 of the said schedule. आपका कौन सा है, clause A में, clause B में?
Clause B.
आपका clause B में?
जी sir. Para 8, clause B.
Right?
Para 8, clause B.
So value of exempt supply, what transaction will not be taken? Mentioned in 8A?
Yes.
Right? Yes. Now your point is that these are neither supply of goods nor a supply of services.
Because it is outside the purview of GST.
Wait.
Correct.
Right? So that means if you do a transaction of 100 rupees, 90 rupees done like this, on 10 rupees, can you claim the entire input tax credit?
No.
This means they are neither supply nor goods, no tax can be levied on these transactions.
Correct.
You got my point?
Yes, sir.
Similarly, your payment of custom duty. Custom duty, you are right. A custom duty, there can be a financial arrangement between the high C buyer and high C seller. You pay, we'll pay you later. But there also, you have to become a pure agent.
Pure agent.
उसका agreement होना चाहिए. Right? There is a judgment by Steel Authority versus Union of India in the central sale tax where high C's custom duty was paid by LG. Case where the Supreme Court, this case is from that Supreme Court judgment only, which I picked up. Right? Okay. And what do you take on merchant exports? There are a lot of allegations. You have not clarified to the Honorable Tribunal what were the allegations.
Of merchant exports,
don't conceal any facts from Tribunal. That's not a very good lawyer. You have to speak all against you. And only then you gain the sympathy of Tribunal. If you try to, slipshod things, get difficult. Be quick to read now merchant export. What are the problems?
No, in case of sir, merchant export, there is a
item number 7, Tab Jewelers, argued by CA Poonam Jain and Advocate Meenakshi Jain against the Government Counsel Advocate Shushil Verma.
This is on condonation of delay, and I would like all of you to clap for these two women who are working together and doing their first ever appeal itself. You must win. Don't get scared of me. I'm going to grill you properly on this appeal also.
My Lord, I am honored to present the appeal. May I proceed? My Lord, the Tab Jeweler, the appellant, has come before the Honorable Tribunal to challenge the order passed by the First Appellate Authority on May 20th, 2025. The appeal was solely rejected on the grounds of being time barred. My Lord, we contend that the learned First Appellate Authority exercised its discretionary power in an arbitrary manner. The appellant filed their appeal under Section 1071 and simultaneously submitted an application under Section 1074 for condonation of delay of 28 days only. It is crucial to highlight that 28 days delay is within the permissible statutory limit under Section 1074. I would like to read relevant para of Section 1074. 1074 section says that the appellate authority may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be, allowed it to be presented within a further period of 1 month. And my application for condonation is on Annexure G, and I mentioned in paragraph 3 of that that this is for the first time we are filing the appeal, and it's just a procedural lapse.
My Lord, there is no malified intention to filing the appeal late within 28 days. There are only mistakes because of paper mixed up with other documents in file, and it has been supported by documentary evidence along with affidavit and certificate. I would like to submit additional evidence in this regard, my Lord.
My Lord, Supreme Court has said in many cases, not every mistake by a CA could be used as sufficient cause for condonation of delay. The reason given is very flimsy. Papers got mixed up.
Well, papers got mixed up. You are very right, Mr. Verma. And you are rightly quoting that Supreme Court judgment also. But there are other many case laws in support of that appellant should not suffer,
For the-
assessee should not suffer
Yes,
because of laxity of
on
counsels.
the mistake on the part of counsel, appellant should not suffer.
Should not suffer.
But
So
policy,
here
Supreme Court has undergone a change. They say if you start accepting this mistake of counsels and the counsel start filing affidavits, this is a indiscipline in the profession. There are many rulings Supreme Court. But in this case, this being first case, I won't object it to the Honorable Tribunal.
So in this particular case, your delay is condoned, but the matter will be remanded back to the first appellate authority to re-educate the same.
Thank you, my lord. Please, my lord.
Next item is Nidhi Trading Company. Please welcome our youngest advocate, Nidhi Agrawal.
And she is the daughter of our best
She is
friend
daughter
Suresh
of
Agrawal.
Suresh Agrawal.
But you are here on your own.
Yes,
You
sir.
are not here because of Suresh. उसको शायद हम ना भी बुलाते.
Greetings of the day to the honorable bench. May I start?
Please start.
Yeah. So, sir, my primarily objections in this case is that this appeal challenges the order dated 26/4/2025 passed by the first appellate authority. So, the brief facts of the case are that the appellant is a registered taxpayer, honest taxpayer, engaged in the business of trading electronic and audio-visual equipments. There was audit conducted at the appellant's place under section 65 of the DGST Act for the financial year 22-23. Subsequently, the SCN dated 16/10/2024 was issued under section 73, alleging certain 3 or 4 discrepancies, which I am not highlighting here because my primarily objection is on the limitation only. And a personal hearing was also scheduled before 26/10/2024. But due to the internal staff transition and because of that audit that was conducted, the appellant's, the main GST accountant, he abruptly resigned from the office, because of which there was communication lapses, and the company couldn't neither filed any reply or did not attend any of the personal hearing. So on 26/12/2024, the adjudication order was passed ex parte without any hearing, creating a demand of 12,35,000 of tax and 7,31,000 in interest, with further directions of potential penalty proceedings. The main point over here is that the appellant, upon the receipt of the order, immediately made a mandatory pre-deposit of 10% of the disputed tax amount, which comes out to be 1,23,500 on 21st January 2025 itself, and handed over the appeal documentation to me to take up the appeal. But that was my professional oversight, and you can say that March close endings, February, March, I was little occupied with the other workload, work congestion, because of which that I could not file the appeal on time, and the appeal got delayed by 29 days. But it was still within that condonable period of 1 month, which is permissible as per 1074. So here it's my humble prayer is that the filing of appeal was the delay was really procedural and non-malicious, and it should be condoned in the interest of natural justice. The appellant has always acted in a good faith and without any intention to delay the proceedings. The lapse occurred because of me and because of the circumstances which was beyond the appellant's control. What else? I can definitely quote a judicial precedent, Messrs. B.R. Singh and Company versus, sir, it's on page number 6. Sir, on page 6, I have given the judicial present, Messrs. B.R. Singh and Company, which directly relates to my case, that though this ruling was under central excise, but definitely it can be used under GST also. And there the delay of huge amount, I mean 36 days ka delay was condoned, but here it's just of 29 days, which is within the permissible 1 month period as per 1074 itself. So I request and I plead that the litigant should not suffer because of the fault of the advocate. Herein I have attached the application for the condonation of delay of 29 days has been given on page 9 to 10. Affidavit of the director of the company, Shri Prem Prakash Agrawal ji, in support of the appeal, that has been given on page 11. And also my certificate I have attested on page number 12. And I would like to definitely make a prayer, which is there on page number 8. That I request you to set aside the order dated 26/4/2024 passed by the First Appellate Authority and hold that the 29-day delay in filing the appeal was due to sufficient cause and without any malified intent, and the matter should be remanded back to the Appellant Authority to hear the appeal on merits. Because this case is really meritorious.
My lords, you can just see your affidavit. Yeah. Just read your affidavit, what have you written, what you speak.
Sir, my certificate on page 12?
Para 2.
Yeah.
That the appellant furnished all necessary documents, including proof of pre-deposit and a duly prepared affidavit explaining delay in filing on 23/1.
Yes, sir.
What? You filed appeal in April?
No, sir. This is the pre-deposit. I mean to say here.
You're talking affidavit. Affidavit is not a pre-deposit. Lesson is be careful when you sign certificates. Your appeal will be dismissed on this ground. Here also you were negligent.
Sir, affidavit by the director that was handed over to me
But I'm sorry, affidavit director of 26th April, 24th day of April. No hurry when you do litigation.
Okay, I admit my mistake.
Never ever do it.
Yeah.
Then you will be held for negligence.
Yeah.
Vicarious liability can come.
I apologize for
I want you to say sorry. That's what I want you to hear
I
from you.
apologize for the same.
बेटी है मेरी भाई, उसको ऐसी ट्रेनिंग करनी देनी पड़ेगी ना? नहीं तो भाई, they are so he's saying to tribunal only. I'm not addressing me.
I'm apologizing.
Now the judgment you are quoting,
yes, sir,
was illness of the advocate. You were not ill. How is this relevant in your case?
Sir,
you can quote any judgment.
No. It's not about the
550 days is illness of the counsel.
Definitely, sir. The bottom line is that litigant should not.
No.
I mean, the appellant should not suffer.
ये कौन सी किताब में लिखा है? ये सुप्रीम कोर्ट ने बहुत रिवर्स भी आपकी जूरी में जजमेंट दी है. You will lose such cases. When you quote a judgment, it should be relevant to your case.
Sir, I would like to quote another judgment.
When you forget, you quote when you go into real-time case. Your Honor, the appellant has been very negligent. All proceedings prior to this also were ex parte.
But the case is very similar to the one we have decided before this.
Yeah.
And the better part of this case is that
I've made the pre-deposit.
No. When the tribunal is speaking in your favor, don't preempt, don't interrupt. And the better part of this case is that the legal counsel herself has been graceful enough to admit her fault.
Absolutely.
So to that extent, we should give her a credit and allow this appeal, forwarding it back to the desk of the First Appellate Authority.
Lesson, never ever file your affidavit as a counsel. That is a misconduct under Advocates Act. Never. Let client go to hell. Never put your stakes as a counsel in any matter. Unless there are special consideration ways you have to put in your affidavit.
Okay. Thank
Just
you,
for
sir.
seeking delay ke client bach jaye, he can die, we have no issues. But don't put your esteem at stake.
Thank you, sir.
Okay, next. Thank you. Well done, Nidhi. ये केस आपकी जीत रियल ट्रिब्यूनल से बड़ी जीत है.
Next item is Yadav Associates, argued by Advocate Virender Yadav, and the matter is reversal of excess input tax claimed on closing stock. Aye, Yadav ji.
Yes, please, Your Lordship. Please, Your Lordship, with due permission. May
Yeah, please. Sorry.
Yes, please. Highly obliged. My Lordship, first of all, as far as the maintainability of the appeal is concerned, I would like to stress some submissions on this regard, which is given in the page number 7 of my petition. Para 2, that present appeal has been filed within the limitation period and being filed by the proprietor of the appellant. And this appeal involves a question of law which is exercising excess jurisdiction of the first appellate authority. Therefore, there is no requirement of pre-deposit of 10% as the maintainability of this appeal. And this appeal has been filed within the limitation period as order has been received as on the 19th of February 2025. An appeal is being filed on 15th of May, that is the limitation period, Your Lordship. And all the certified copy of original orders has been properly annexed with appeal, and prescribed court fees has been duly deposited and paid. If Your Lordship please permit me to start my argument on the next part, if allowed.
Please do.
Yes, obliged, Your Lordship. As to the brief facts of the case, Your Lordship, year 2023, and reply has been accordingly, my Lordship has said, the appellant vehemently denied all allegation in my reply to the so-called notice, and no such provision or reversal of excess 10% claim of ITC on closing stock due to reduction of the rate from 28% to 18% in the registered regular dealer case. My humble submission to Your Lordship, there is no provision as concerned the input tax credit provision is with the section 16 to 21, which talks about the ITC eligibility condition and some reversal conditions. There is no mechanism in all sections. Now, adjudicating authority proceeding the section 73 submissions, Your Lordship, may have also to put forward before you the so-called issued without any valid supporting relevant provision of law before the appellant. The relevant para that talks about that the dealer in electric relays, my Lordship, para number 1 of the SCN, which is given at the page number 14, that you are dealing in electric relays used for the electric equipment and for railways braking system, and taxable is already given in my statement of facts, Your Lordship. The main point which is an issue, which is given by the learned authority in the bold letters, that this would amount to a wrongful input tax credit at your end, and you would unjustly enrich yourself at the cost of government revenue, which is not legally permissible. And you are required to file a reply to so-called notice, so and so. In this regard, I have already put forward a judgment of Honorable Supreme Court in the case of State versus Gujarat versus Trisla Alois. My Lordship, the facts of this case is just similar, because in this case, the erstwhile law in the VAT in the state of Punjab, there was a provision of reversal of ITC on the stock. That was amended from a specific date. A humble submission, there was a difference between the date of notification and date of enforcement. Thereby, the Revenue Authority was asking for reversal from the date of notification from the appellants. In this case, the Honorable Supreme Court held at the page number para 35 2. My Lordship, your attention is required at the page number 51, para 30.2. Allowing the writ petition, High Court held that in absence of any provision of law in the statute, the state of Punjab to notify Rule 21(8) This rule talks about amendment in respect of levying of tax on the stock items. With effect from 25th of January 2014, this is the date of notification, the said provision would come into effect only from 1st of April 2014. The date of coming into the force amended provision of section 13(1) along with first proviso thereto, High Court further observed that the said provision amended first and was not retrospective held. My lordship, my humble submission is that if it is assumed that there is a notification in respect of reduction of the tax from a date specific, that can not be reverse the stock amount of the ITC on the stock amount from the retrospective amount. It must be prospective from the date of enforceability of the notification. So this was my first issue, whether the stock ITC on the stock was reversed or not. And the second issue, which arose from the appeal, which is come before this honorable tribunal from the appellate orders, which is given in the page number 12, my lordship. Page number 12 is the order of the appellate authority. With due respect, I humble to say that the bold letters given in the appellate order at the last paras, admittedly proper officer should have gone into the law, laid down in the judgments and decided whether these judgments are relevant for the adjudication of the issue before him, but he did not apply his mind. Appellate authority is clearly showing there is ability of the adjudicating authority to decide the matter. This means there was no apply of the wisdom of the adjudicating authority. Now the next line, under the circumstances, it would be difficult for me. This line is very negative way for the appellate authority. Who is the appellate authority against the adjudicating authority? The appellate authority is doing two work, at the observation in one side and deciding the matter on another side. From one side, the appellate authority is saying that it would be difficult for me to adjudicate the matter when the proper officer has not applied his mind to law laid down in these judgments. Hence, in the interest of justice, I accept contention of the council that the grant him an opportunity before the proper officer who shall take these judgments or any other judgments of the council may like to bring on record or pass a reasoned order. And your attention, your lords, will require the bold letters given at the last of the judgment. The order passed by proper officer on dated 19th of September 2024 are hereby set aside, and I am direct to pass fresh order in terms of direction in the order. My humble submission is that the appellate authority is not empowered to pass such an abusive judgment. As far as section 107 subsection 11 is concerned, your lordship, if we go through the section 1 subsection 107 subsection 11, page number 21. The appellate authority shall, after making such further inquiry, whether the appellate authority has discretion to pass any orders. Whatever he wants to do, can do that. My humble submission is that the appellate authority has three limbs of orders. Except those things, the first appellate authority has no power. As the section emphasizes that, the appellate authority shall, after making such further inquiry, whatever he wants, as may be necessary, pass such order as it thinks just and proper, confirming, modifying, annulling the decision or appealed against, but shall not refer back to the adjudicating authority, has passed the said decision in the appellate order from which I am aggrieved. The matter was remanded, even the matter was set aside, the matter which was illegally decided by the adjudicating authority, which was required to be quashed from illimini, the appellate authority giving back to the matter to the adjudicating authority, same authority who has given illegal order against me. So my humble submission is that this is beyond the provision of law. This is strict non-compliance. Yes, sir. Yes, Lord, sir.
Sir, you want to say anything?
You know, first of all, let's go through the power of remand. That's a big question. This tribunal has to consider.
No, in fact, we are convinced. Whatever you want to say. Beyond that, you want to say anything?
Yeah, I want to make a point. You want to hear me? there is no blanket power not to remand the matter. We have read the law very carefully. Blanket, I said, there is a restriction.
Yeah.
But shall not refer case back to the adjudicating court that passed the said decision or order. You can transfer to somebody else. These words were never there in any act. Shall not refer back the adjudicating authority that passed the order. Usko remand nahi karna.
No. He says he can annul.
No, I'm on this.
Or
you want to hear me out? I'm on this only.
Yeah.
We are discussing law. The appellate authority shall, after making such further inquiry as case may be necessary, pass such order as it thinks just and proper, confirming, modifying, or annulling the decision or order appealed against. But this is the imperative language. Shall not refer the case back to the adjudicating authority that passed the said decision or the order. Can we say he can never remand based on this phrase?
Yes, sir.
Yeah.
He can never remand to any other officer?
No. Because the terminology is adjudicating authority. And
No, adjudicating order is further followed. That passed the said decision. There can be 100 adjudicating authorities.
No,
The restriction is...
But for one registered person, there will be one proper officer only.
Could be. What I'm saying is, that in this case, I have no issues. What I'm saying is...
Otherwise, as a law also, we are discussing this thing on academic ground also. That what is terminology known as adjudicating authority, number one.
There's a definition.
Number two,
There's a definition of adjudicating
on a
authority.
registered person, whether there can be several type of adjudicating authorities or different adjudicating
Let us say there's a proper officer who has issued ASMT 1011.
Correct.
Okay? He has accepted, rejected. Let us say those cases are transferred by commissioner under his power to some other officer to decide 73. Can there be one adjudicating authority, two adjudicating authorities?
No, sir. I will read it again for you. Okay. It says, the appellate authority shall, after making such inquiry as he may consider necessary, pass such order as he thinks necessary and proper, confirming, modifying, or annulling. He has already annulled it. And then further it says...
nothing has been annulled.
One second, sir.
He should have done that.
1 second. He has already annulled it. The decision or order appealed against, but now this is your part of the answer. Shall not refer the case back to the adjudicating authority that passed the decision or an order.
Right.
That means in this particular case, his jurisdictional adjudicating authority was that passed the order. उसको भेजना नहीं है. और फिर order में he has not sent it to anybody.
But that's okay. I'm saying I'm not discussing this
या
case.
तो order में वो लिखता ना कि that adjudicating authority might be different. Now I am referring to
that is absolutely okay. Now coming on this, whether this is a abuse of power? No.
It's a negligence.
It's not abuse of power.
It's a negligence.
It is an irregular assumption of jurisdiction. This is not abuse of power. These kind of phraseology should not be used ever in the tribunals. For information, you lose the cases with this aggression. You are being abrasive, not aggressive. You have to take relief. ऐसे मिलता है, ऐसे करके नहीं मिलता है. I can hang on this case for next 10 years. I have judgments to support my point also. Abrasive नहीं होना, aggressive नहीं होना. झुक के मिलता है कुछ, ऐसे नहीं मिलता है, कट जाता है सब कुछ. यहाँ सुन सकते हो. किसी रियल कोर्ट में होगा तो you will be shut down immediately.
इनका सर एक और भी इंटरेस्टिंग पार्ट है.
ना दूसरा आपका इंटरेस्टिंग है कि जो इनपुट टेस्ट क्रेडिट का इशू है, right? There definitely there is no provision in the law to do this, but still has to prove what these goods are. So for this issue, it has to go back to the appellate authority only with direction to decide, no remand, to decide this issue whether he is entitled to input tax credit or not.
But he has taken the certificate from the chartered accountant.
How does it matter, sir? How does it matter? No, but that doesn't matter. But there is no CS certificate requirement then.
That is not in dispute, Your Lordship.
He has paid 28%, reduced to 18%.
Exactly.
Right?
So how can...
The section 13 of Punjab Act scheme is totally different. The judgment of Trishla in Supreme Court in the Punjab Act, the scheme of section 13 is not a GST enactment. Facts are different. So let the adjudicating say and give direction, you will not remand, decide this issue, that's all.
That's all.
That's all, decide this issue.
That's what is done. But interesting part is, when you are vociferously arguing with the appellate authority that the order passed by the adjudicating authority is not as per law, and to such an extent you are vociferously arguing that he got convinced that the order passed by the adjudicating is not right, At that time, did you not tell him that he has no
With
power
due
to
respect,
remand
I
it
would
back?
like to state that there is a judgment of Corona's Solutions India Private Limited versus Union of India. That is was delivered by the Honorable High Allahabad Court.
Now let's come on. Case is remanded, chapter closed, no? There is no further argument on this.
Highly
Well done.
obliged.
Very well.
Adjudicating authority whether can remand back the case?
No.
But the argument of the DR has not been
Not allowed.
so.
Highly obliged.
किसका आगे भाई? वही किसका?
Rahul. Next
Here
item
we have a
is
case
RV Steel.
which is very technical in nature and extremely legalistic. Extremely legalistic. It requires interpretation of many sections before we come to a conclusion whether he can get ITC or not. It's a case of construction of a power plant as per the assessee for captive consumption, which has back-to-back agreements with the gen companies like NDPL or BSES, who take that electricity from him, give it back to him via grid, and bill him. Right? So he says, I spent 10 crore rupees on captive power plant. Why should I not be entitled to ITC? Revenue says you are not entitled to ITC. This is the key issue here. There are other issues, but this is the key issue. Well, our star, Rahul Kakkar.
All the people sitting in the audience, I would request you to please maintain a little more silence. We're going to wind up in another hour or so. So I hope, and selfish. Sir, this is just a request. Secondly, I hope this would still be entertaining, right? So we can all be focused there. Now coming back to the formal sphere. Very good afternoon, the members, Jim and sir. Also my learned friend, very good afternoon. So with all due permission, I would like to present my matter. Lordships, for the easement to understand this matter, I have just presented a copy to each one of you of the synopsis of my matter. And one copy has already been submitted to my learned friend present here. And also, I passed you the full judgment copy. Lordship, to start and to brief you about my matter, it is a technical matter which includes a lot of technicalities.
You have to first argue condonation of delay application.
I'll come to that also. I'll just come.
Merits first condonation.
I will come to that also. Yes. And the reason for condonation was ill health while I was about to file this appeal at the tribunal level. I have also attached my medical certificate, and I hope my friend present here won't have any objections to that, as I had a very high grade fever. On page number in 47, my lordship, you can find my medical certificate. And on 45 and 46, you can have the condonation of delay.
My lord, but for counsel's certificate, I would have very seriously objected to this condonation of delay. If he has a fever, he was down from but for my counsel's affidavit, which I will never disbelieve, 1st March to 20th, 5/25. Right?
Exactly.
So, but for his medical certificate,
No,
I
sir,
would have.
No, sir, no. You mean to say that the high-grade fever cannot last for...
No. What I'm saying is, but for this, because it's a company case, there can others. Filing of appeal is not dependent on one counsel. What did company do? That is, the company allowed it to get time barred?
Again, you see this language.
I'm only concerned that but for my friend's affidavit, I would have vociferously argued this condonation. This cannot be given. It's not a company, it's a company of 400 crores. We cannot say that there was no other person to file appeal.
And go on the words.
He was only with fever. He could have always read it at home.
Go on the words. This is to certify that Rahul Kakkar, aged 41, was under my medical treatment from 1st March 25 to 20th April, 20th May 25. And this certificate is being issued on 18th May 25.
I was about to say that. Be careful in future, that's all.
Much obliged, Lordship.
Otherwise, your appeal can be dismissed straight away on this ground. That this medical certificate is fabricated.
After thought.
And I could have called this doctor, whosoever this, and where is the doctor's name? Dr. K.M. Raju, I would have called him for witness.
Yes.
Come on. Rahul, it happened in my case.
That's okay, sir. I have already
Listen. I'm telling you the real story. I was a Bharat Bhushanji's case. I don't know whether Mr. Bhatia was the Government Counsel or R.K. Gupta. हमने एक मेडिकल सर्टिफिकेट लगाया. Ramesh Jori.
Our chief present here was objecting to my condonation. He was the only one who asked me, your matter has condonation. I said, no, chief, this does not have.
This has
No, he has condonation. So I had to make one.
Next.
I had to make one. All right, coming back to the formal.
This is of LNJP hospital, so that cannot be doubted after. This is
Much obliged, Lordship. Thank you so much.
Don't feel obliged.
Furtherance of business. The next para, which is on the next page, which is para number 2, there is a ITC denial of 2,24,000 on the purchase of 20 water coolers used in the promotional scheme of business. The third, which is on page number 2, my Lordship, in the file. Which is on page number 2, my Lordship, in the file. My client, the appellant, Messrs. RV Steel Limited, is having a principal place of business in Narayana Industrial Area, which is based in New Delhi. And the appellant's audit was conducted between the dates mentioned, which is 2nd of April 2024 to 2nd August 2024 for the assessment year 22 and 23 under the ambit of Section 65 of the CGST Act. And under the ambit of Section 65 of the CGST Act. And consequently, an audit report was also issued, that is right, 8 days after the completion of the audit proceedings, and delineating the following audit paras. So the paras I have already mentioned in the broader aspect, which are the 5 paras. So the copy of the audit notice and the FAR is annexed below. The educating authority, the Assistant Commissioner Zone 4, issued the show cause notice bearing to the DIN number mentioned, dated 6th of September, served upon the appellant, upholding all the queries by the audit team supra, proposing to the file the clarification by 21st of September 2024 along with the PH. It is noteworthy that the adjudication had given only mere of 15 days to respond to the show cause notice, and the show cause notice proposed a tax liability of the amount mentioned, which is 60 lakhs and 35,000 along with the applicable interest. It is to be noted that the show cause notice was issued for the assessment year 22 and 23. A copy of show cause notice is also annexed and annexed in number 6. The appellant submitted that the comprehensive reply in person on the date specified by the adjudicating authority, which was on 21st of September 2024, by giving the proper justification and clarification, demand paras raised by the authority. The adjudicating authority unilaterally issued the demand orders on 16th of October by reinstituting the similar per se demand paras raised by the audit team. There has been no changes in that. Without consideration of the reply submitted in person to the adjudicating authority, and put an inference on the order issued by the reply, issued in the reply, which was not submitted and was devoid to the true circumstances, and directed the appellant to pay the mentioned amount, which is 60.65 lakhs and interest of 25.56 lakhs as an interest, and the adjudicating authority has stated in order that the penalty will be levied separately. Right. So we all are agreed with this, and it is annexed in annexation number 7. Going further, the appellant agreed from the impurged order and demanded to refund upon the appeal of under the ambit of section 107 of the CGST Act to the Honorable First Appellate Authority, presided by the learned respondent within the prescribed time period, stating the detailed grounds on the appeal. However, it went in vain as the appellate got the appeal dismissed. My Lordship, I would like to reiterate the point that the appeal got dismissed. Right? I will have a conjecture to that. By adjudicating authority citing the reason that the order passed by the adjudicating authority was absolutely approved. It is a matter of fact that the learned respondent had not reconciled with the prevailing legal provisions. I would like to highlight this again and reiterate the fact that it was not reconciled with the prevailing legal provisions, which led to the issuance of appeal dismissal order under section 107(11) of the CGST Act, dated 10th January 2025. The copy of the dismiss appeal order is also annexed in point number 8. Being agreed with the impunged order of the appellate, we filed an appeal on the various grounds which are as under. First, the jurisdiction of the authority. We are agreed to mention that the appellant hereby states that the subject matter of the impunged order against the appeal is made within the jurisdiction of this honorable tribunal. Then the limitation, we have already mentioned the condemnation of delay. Then there are the list of events which has been acted upon our matter. My Lordship, I had moved as per the new rules of the GST Tribunal, the GST form number 01, which is the interlocally application, as I have made the Joint Commissioner as the party along with the Commissioner in this appeal in front of your bench. We have been agreed by the Joint Commissioner's appeal dismissal order. As you see, we straight away say that the appellant raises the concern with the substantial questions of law regarding the infirmities, legalities, as well as the power of the Joint Commissioner while passing the impunged order. If I tell you the details of the grounds of appeal, first, if you look at the para on the page number 7, para number A, the non-application of the mind and non-consideration of the appellant's reply. I would like the bench to have a look on this issue, that it has been absolutely a non-application of the mind and non-consideration of the reply which we had submitted while filing our appeal at the first appellate level. It is vehemently contested that the respective authorities have not considered the reply submitted to each level, which raises serious concerns that the appellate has compiled and with each and every provision of law and still finds it difficult to get a favorable order from the authorities. There is a famous proverb which says, justice delays is justice denied. However, in our case, there is no delay while only denying the justice. My Lordship, I would like to again read this line. There is no delay in our case, but only a denying of the justice. Going further, in the point number A, broad A, B, it is a matter of the fact that the impunged order passed by the respective authorities suffers from the vice of non-application of mind. We would like to put it in details, as the authorities failed to consider the documents and submissions made by the appellant, which were duly recorded and available on record. As it is a GSTN system, everything is available on record. Per contra, the respondent has inferred the order that no supporting documents were furnished by the taxpayers. My Lordship, if you see, we are on the age of computerization and a tech-enabled GSTN system wherein everything is available on the portal, and our replies are also uploaded on the portal. Even this appeal has been uploaded on the portal of the GSTAT, and it has been merely said by the first appeal that nothing has been submitted. So we very barely and being highly aggrieved with, we are simply saying that there is a non-application of the mind. Going further, merely asserting the absence of supporting documents, especially the tax, after the taxpayer had submitted all the relevant materials, constitute a gross misuse of the powers vested in the authorities. That is the reason we had to move this Form 01. Going further, my Lordship, in point number B on page number 8, the procedural lacking by the respondent acting as a quasi-judicial body The respondent has failed to verify whether the appellate was afforded equity time to file a response to the show cause notice or not. The adjudicating authority granted mere only 15 days, which is manifestly insufficient for a taxpayer embroiled in a dispute of such substantial magnitude. Still, accepting, be that it may be, the appellant has duly furnished all the requisite documents and within the stipulated time frame. There has been no delay at all. Neither we requested for it. The respondent had failed to verify whether the audit conducted by the audit team aligns with the factual circumstances or not. Given that the audit pertains to the assessment year only for 22 and 23, on what basis has the audit team raised demands particularly or to the assessment year which is 24 and 25? I will also touch upon if you look at the synopsis, which I'll come in next few minutes. Does there adhere to any prescribed procedural compliance or the legal norms? We are really surprised to it. Where the authority can issue a separate notice for the separate financial years without even conducting an audit of it. Why there is a haste in cremating demand of the appellant who is compliant with the regulatory norms. So Lordship, now I would like to take you para-wise to the appeal. If I would request you to please look into the synopsis, it would be very easy and also time saving for all the members present here. Thank you. Lordship, the first point, which is denial of ITC of the subjected amount for the purchase of 4 tempo travelers, which has been dismissed by the adjudicating authority as well as the appellate authority, we would like to broadly say that ITC denial basis is that ITC has been denied on the account of ineligible ITC under section 17(5) for purchase of 4 tempo travelers, which is of a brand called Force. Our argument is that the audit team wrongly denied the ITC on purchase of this which is firstly falling under the assessment year, which is 24 and 25. So Lordship, I would like to bring into your notice.
We can ignore technically, yes, but yes, don't bother about the law. Yes, can be mistakes. We have told technically we are not disputing things here.
So that
here,
is
here you forget. Here forget just question of law.
Yes. So
not a real-time case.
Yes. So Lordship, the question lies here is that when you are auditing for a financial year which is not pertaining to the transactions to the years which is mentioned, I would request you to kindly quash this para. We pray to quash this para. Further details for this has already been mentioned in my synopsis referring to the page numbers for your easy reading and references. Because our conclusion is that demand is jurisdictionally flawed and illegally unsustainable as the ITC is rightfully claimed. But as our first prayer on this point where we are agreed with is that it does not even pertains to the assessment year where we have been audited.
Shall I? You like to test?
No, let him complete.
All right.
No, but at this stage we have to answer his question.
No, sir, we have said here we have to ignore. We are discussing law question. We are not doing technicalities.
No, but whatever he has purchased, that vehicle has a capacity of more than 13 people.
That we will see, sir. On that we'll argue. On that we'll argue, sir.
All right.
On that we'll come and argue.
My Lordship, going further, I would request you to please turn the pages of the synopsis on the page number 2, which is talking about the para number 2, which says the ITC is denied of 2,24,000 on the purchase of 20 water coolers. So broadly, the ITC was denied on the water coolers. The audit objection which was raised on the assessee was that it has been denied and it has been given to the distributors, treating them as gifts under section 17(5)(h). Our argument is as follows, that these are not free gifts, but are part of a conditional sales incentive. Distributors were required to meet a certain sales target for the financial year 24-25, after which they could choose either a water cooler or a credit note of 40,000 rupees. So whichever distributor chose to take the option A for the water coolers, it was given as a promotional scheme and not as a free gift. So what we say in our legal argument is that the section 17(5)(h) blocks ITC only for unconditional gifts or free samples. I would like you to refer to the page number 14, para number 9 of our appeal, wherein I would just like to tell you that the incentive was conditional and tied directly to the sales performance. So my lordship, if you could just refer to the page number 14 in the file. Point number 9.
Yes, yes. Apportionment of credit.
Yes. So I would like to tell you, the point says, firstly, the appellant would like to shed the light on the provisions of 17(5)(h) of the CGST Act 2017, wherein section 70 is the apportionment of the credit and block credits. If you look into the details of 17(5), it says, notwithstanding anything contained in subsection 1 of the section 16 and subsection 1 of section 18, the ITC shall not be available in respect of the following, namely, goods lost, stolen, destroyed, written off or disposed of by the way of gift or free samples. So my lordship, I would like to humbly submit my argument here that it has been denied, stating that it is a free gift, wherein we have very clearly mentioned and subsidized that it was a sales promotion scheme.
So was there any agreement between you and the beneficiaries?
Yes, yes.
So, and what was the condition? Okay, they have to achieve certain target.
Yes.
So did they achieve it?
Yes. So whosoever achieved it, we gave them as a sales incentive, and there was also two options available. Either he can take a credit note of the same amount or can take the water coolers instead.
But they exercised the second option.
They exercised the first option, which was not to take the credit notes but to take the water coolers. Yes. So if I go from the plain reading of the provision, it can be stated that the ITC on the goods lost, stolen, destroyed, written off by the way of gift or free samples will be restricted under this said provision. But here in our case is different. However, in our present case, the water coolers so purchased were given to the distributors on the condition, as you rightly asked, it has been very clearly mentioned, that they would achieve a certain target by the turnover depending on the dealer's profile for the financial year 24-25, and only then the distributors were given the choice of either to take a water cooler or to obtain a 40,000 rupees credit note from the appellant.
Okay.
It is to be noted that the statute lucidly restricted the ITC on the goods disposed by the way of free samples and gifts, which was not the modus operandi in our sales promotion scheme, which is a part of promotional activity of the business and generally devoid any preconditions. Going further, in the present circumstances, that there is a direct nexus between the water coolers and the target achieved. So there is a marriage between the target achievement and the water coolers or the credit note, which was supposed to be taken as a option number 2. As a sales condition, the inherent conditional factor in the present transaction itself precludes that it is coming from the ambit of 17(5)(h). In addition, the said expense incurred by the appellant is directly in relation to the furtherance of business, which is under the provisions of 17(5)(h) and making it eligible under the ambit of provisions enumerated in 16(1) of the CGST Act. Last but not the least, concludingly, it can be satisfied with the said transaction is totally based in the furtherance of business, and denying the ITC on the same would be gross prejudice of the appellant. So we humbly pray to please quash this matter. Going further to the grounds for the para number 3, my lordship, with all due permission. Now there has been a technical issue wherein I would like to bring you a little more elaborative details, that the para number 3 denied for the ITC of amounting to rupees 40 lakhs and 4,000 on the construction of solar power plant in the business premises. I would like to reiterate the fact that it was a construction of the solar power plant within the business premises. So the audit team has raised the demand which was upheld by the adjudicating authority as well as the esteemed first appellate authority. The rationale put in the respective authorities while denying the ITC is that the authority is unable to verify the electricity is consumed by the appellate only or not. So, my lordship, the point which we understand as a plain reading is that are we supplying any kind of a service from the place of business of our client, are we steel, or we are just using it for the self-consumption? So, I would like to elaborate where it has been actually used only for the self-consumption. And then the appellant is in the back with a tie-up with the NDPL, to whom the company shall transfer by way of wheeling and banking. These are the two terms which have been used, and I would like to elaborate on that.
So for wheeling and balancing, that agreement,
banking, yes,
that you have filed
yes,
during your
My lordship, if you go by my file on the index, I will just refer to you.
Yes, sir, agreement is there.
Yes.
Okay.
There has been an agreement which has been there to have a very clarity with the NDPL and the RV Steel, and it clearly mentions how the wheeling and banking process has been moving for these two.
Exists. That always exists.
Thank you. Going further to point number, para number, sorry. To para number 4, my lordship, there has been a reversal on the ITC on the account of non-payment to the suppliers within 180 days amounting to rupees 5 lakhs and 4,506, wherein the ITC has been again denied, auditing and adjudicating authority denied, imposed the demand basis on the payment of the certain invoices only, wherein it has not been made within 180 days, therefore the ITC should have been reversed under Rule 42 of the CGST Act, CGST rules. So the first appellate authority blindly upheld the same without any independent verification. As I said, we are in a systematic equation wherein the GSTN supports to understand and check all our data. So what we argue is that no actual supply occurred at all. There was no supply from our end wherein this Rule 42 comes enable on us. The goods have been received. No ITC has been claimed on these invoices at all. Supported by GSTR 2A and 3B reconciliation, which was already submitted at the adjudication level and also at the appellate level. For the inward supply register, wherein the excess ITC available compared to GSTR 3B, as they do the reconciliation exercise, which shows the ITC has been alleged invoices have not been claimed at all. For this also, I could take you to the page number 21, para number mentioned on page number 21. My lordship, if you could just open my file and move to the page number 21.
So now one thing arises here.
Yes, lordship.
Because you say that you have not considered it as your supply or your purchases.
Inwards purchases,
No.
and we have not claimed an ITC.
Nor you have entered in your books of account.
True.
Then how come the audit team have sensed that there is a creditor in your accounts who has not been paid for more than 180 days?
My lordship, what happens is, to the best of my technical knowledge, when we open the GSTN system, it is common for either the adjudicating authority as well as for the assessee.
But shows what is lying in your credit ledger and what you are utilizing.
Correct.
That shows only.
That
doesn't show the name of the supplier, name of your creditors. So it is only known when they go through your balance sheet. So there should appear.
My lordship, that is what I was just trying to highlight, that while the audit was on, not the normal adjudication of any ASMT 12, audit has been a fine line audit mentioned with the guidelines under section 65, wherein they check all our data, purchase register, sales register, balance sheet, P&L, GL account, trial balance, state-wise trial balance, everything has been fine linely submitted to them, because we understand there are apprehensions on the GSTN network.
My question is,
and we had very clearly segregated, let me just finish with that. We were very clearly segregated that this ITC we have not claimed at all, right? So there is no provision, there is no equation of, doing the reversal, right?
But how come they have sensed the name of the
Your Honor,
creditor?
I'll answer that. It's a part of his reply only. Okay. We'll answer that. Let him complete.
Okay, so
Now
just to summarize this, since the Rule 42 mandates the reversal of ITC which has been availed, but the payment to the supplier is not made within 1 month, however, no reversal needed since the credit was never taken.
Exactly.
This is what my answer is. Going to the last para, Lordship, para number 5, wherein the denial of ITC amounting to rupees 3,33,000 due to the taxes payable on the forward charge basis and the reverse charge mechanism, our ITC was denied, wherein the issue was that the tax paid under the forward charge mechanism instead of the reverse charge mechanism. As a result, ITC was denied by the authorities of this particular amount mentioned. So we would just like to submit our arguments that tax was paid to the government, only the mechanism was incorrect. So the machinery mechanism was incorrect, citing to the doctrine of revenue neutrality. I heard my counsel in the other matters talking about the revenue neutrality existence in the GST era. Since the government has suffered no loss, ITC should not be disallowed. Again, for this, we have given a full explanation on para number 1 on page number 21. We are also willing to rectify the legal error and make the current payment But we urge that the ITC should not be denied due to a procedural lapse. Again, on para number 2, mentioned on page number 2, we have elaborated our submissions. Just to give you my legal support of the theory which we are talking about, we have relied on the Jharkhand High Court ruling in Messrs. Shri Nanak Ferro Alloys Private Limited, wherein the court allowed the correction of the wrong tax head and protected the taxpayer from the interest liability. Again mentioned on para number 3 on page number 22. So just to give you a conclusion for the last agreed point, my lordship, the mistake is procedural, not substantive. Since the tax has not been, this has been paid and no loss has occurred to the government, to the exchequer, the appellant seeks the right to rectify the error without losing the legitimate ITC. Thank you so much. I rest my matter here.
Thank you. Yes, sir.
Your Lordship, this whole argument is so flimsy, which bear no reality to the facts that it follows. Let's take out the first case. Let us spend some time so that people learn. Let's go to the show cause notice. Show cause notice on page 26. I will not read the entire show cause notice, we'll take up the issues. The company alleged to have purchased 4 commercial vehicles of 4 stand called tempo travelers with a seating above 13 passengers on so and so and claimed input tax credit of 10 lakh or whatever. The company purchased 20 water coolers, were given to the distributor without consideration. This is the show cause notice for uses by their staff, and this was shows uses by their staff and made subject to condition that during 24 they would achieve a certain turnover of stock of the company, TMT bar and sold. The distributors were given a choice either to make and so. Credit note. The company took input tax credit on purchase which was availed and utilized. When can you take input tax credit?
Section 16.
How did they know that they will satisfy the condition in Romania?
No.
Sorry? This has no legs to stand at all. We need to understand law. That is, today I claim 20 crore I'll give after 10 years target achievement. Can I claim ITC today?
No.
Only not in this ground. Other ground this must fail.
First,
I object, my lordship here.
Yeah.
About first ground only. Then we will proceed.
Okay. Yes. No, you know, I'm reading show cause notice first. Then we are on the captive power consumption plant. Then 180 days, and then RCL. Right? Yeah. Now, what is the reply of? They did not file any reply. That is the conduct of the appellant. To such a serious show cause notice confirming demand worth crores, the company didn't bother at all to file show cause notice to reply. Now, then came on 16/10/24. Dr. Rahul Kakkar, along with director of the company, the taxpayer did not file any formal reply nor any document in support of the submissions made before the undersigned. So you can't have afterthought theories and you keep creating a chaos
I
in the
object,
tribunal.
my lordship.
Wait, let's wait. You answer, you take more time. We are learning.
We'll do that.
Me too, from you. The taxpayer manufacturer and traders of TMT bar. Taxpayer works through a network of distributors, has all India presence. The taxpayer installed solar power captive plant consumption with a back-to-back arrangement. This is a legal issue, totally legal issue we'll discuss. Then 4 tempo travelers. The council, when they tax, the council has vehemently argued that he is not covered by blocked paragraph 17(5). What documents?
No, but on the surface of the order, or their order.
Yes. The documents he has to prove. No, it's a show cause notice. Pretty show cause notice.
Yes.
We'll come and reply also. Then came water coolers. Then 180 days issue. In the show cause notice, just see para 7. We are here to assist the tribunal. A lawyer should know his job. We are not taking sides of anybody. On the issue of suppliers having not paid within 180 days, the council advocated that there are certain disputes about suppliers. Now we say we have not taken input tax credit.
He says he didn't receive even supply even.
Allow me to speak. There's a lot of learning for the entire class here. On the issue of suppliers having not paid within 180 days, the counsel advocated that there are certain disputes about suppliers where the supplier says material have been supplied and the taxpayer says no material was supplied, and hence all these bills belong to this category. Further, the counsel stated that at bar that the taxpayer has not taken any input tax credit on the bills referred to in an extra given to him. He has further stated that these bills were mistakenly entered into the books based on to be report. I mean, what the hell are we talking here?
I object, my lordship.
Yeah, please, your objection is sustained.
To be report, but this is the grilling you require, all of us. If I were in your place, I will also accept the same thing. Never ever misguide this court. Whether we win or lose a case, we are not here to win. We are here to assist the court. That's our job under Advocate Act. I have never done in my life. He was further stated that these were mistakenly entered into the books of accounts. They said, your question? Yeah. How did it come? It's already entered in the books of accounts.
Exactly.
And later on removed from the books on the ground that no material was supplied. That means you are entering bills for claiming ITC without receipt of material. No. There is no mechanism. When further questioned as to how e-way bills were prepared by the supplier in the name of taxpayer and did the transporter bring the material to the business premises of taxpayer, the counsel regretted his inability to answer this question and repeated that the materials covered by these bills were never delivered or received by the taxpayer nor entered in the books of accounts. They were removed from books of accounts. Nor the taxpayer is aware of any such supply, nor the supplier has ever asked for any payments. First we talk of disputes, we talk of books entered, then removed. That means you, for crores of material, you simply take in your bills. So when you get caught, you remove them.
My lordship, my friend, my learned friend here is trying to derail the matter as section 65 is an audit proceeding. Why do we do audit as a question of law?
Wait, we will come on 65 also.
Okay.
Allow, I'll answer all your questions, whatever you have raised.
Sure.
I've never heard anybody so carefully. Sure. Hence, the counsel stated that this does not call for any reversal of ITC. The taxpayer has not brought on record any confirmation from suppliers on this fact, nor before this tribunal. What are you talking? It's a tax law, it's a document-driven law, nor has been able to substantiate his argument with any other collateral evidence. So total ITC of 5 lakh, whatever the amount. Now, let's come to findings and the order. What is the adjudicating authority has done? Regarding 4 tempo travelers.
Page number 32.
Page 32. Regarding 4 tempo travelers, the counsel's argument that it is not covered by any clause of subclause, I disagree. This is straightaway covered in subclause 117.5, and the counsel has failed to bring his case within the exceptions given by Parliament. That is, you can buy tempo travelers for carrying goods or used as a transport. There is no averment on this issue at all, even in the argument or in the appeal. The onus would lie on his to prove his claim for input tax credit, hence the taxpayer has miserably failed to substantiate his claim. Rejected.
Sir, thoda sa factually galat hai. The purpose for carrying the passenger applies to a vehicle of a capacity 13 and less. But for
it is 13 and more.
13 and less.
Yes, I'm coming on that.
But for a vehicle with a capacity of more than 13, there is no requirement that it should be used only for carrying of passenger.
No, sir, in that case, it's not allowed. It is not allowed.
Only requirement is that should be used for the purpose and
for the furtherance of business, my lordship. That has been our matter.
No, but
you may refer to the synopsis.
Now, we all know what tempo traveler is. We can say this is used for supply of goods.
No.
It is not being used for the supply of goods, my learned friend.
Pick and drop to their employees.
Wait, sir. This is the argument here. What is below? That's what I'm saying. You cannot make out a new case. It's not permissible. This tribunal will have no jurisdiction to hear out a new case here. That's why I'm trying to take the pain of reading it through. Yeah. Power plant, 180 days, RCM. We will discuss the law. Then we come to the appellate order. He says he was not heard. It's an abusive power, misuse of power. Well, these are very big words we use in Supreme Court, not before tribunals. He was heard very patiently. The council has reiterated the grounds taken before the proper officer and has vehemently argued that the proper officer has not appreciated the law on the various issues and has passed this improvement order in a tearing hurry that smacks functional bias. At the input tax credits on the issue, even this argument was written by the appellate authority. Functional bias, which nobody writes. I don't think if I say he is abusive, I don't think Tribunal will write this in this order. All the input tax credits on the issue of motor vehicles, chilling coolers given to the distributor captive power plant 180 days, RCM issue was strictly in accordance with law. This is his argument. On the issue of 180 days, the council has taken me through Rule 42 and forcibly argued that when the input tax credit has not been taken, where is the question of reversal? No payment was due. So here he doesn't say whether goods were taken out or removed from books of accounts. So he changed his theory. He realized that there's a wrong factual given. So let me correct the fact. There's no harm. Anybody can do it.
Yes.
But the story should not be mischievous. Exactly. It should not lead to an impression.
I object, my lordship, because if my learned friend says that it can be done, that was actually the factual circumstances.
I'll answer that question fairly.
It is not a fictitious business which we are running
I have no agenda. I will answer this fairly, whether you can do this in law or not.
All right.
Yes. On the issue of solar power plant, this we will discuss. We are not coming. Chilling coolers are given to distributors of the company as gifts. Nothing more has been argued on the council except repeating his arguments. Is there any agreement 15.3b2 required here?
Yes, yes. Agreement.
Any document given? Any confirmation required? When were the coolers given? There is no question of this story being played in this honorable tribunal here. On the issue of law firm services, this was discussed. If 9.3 says this is RCM, a supplier is deemed to be a recipient, there is no question of equity. Jharkhand judgment was on totally different footing, I know. There was IGST versus CGST. This is not IGST with CGST. You have not discharged your liability. Yes. That means, if we'll discuss this law, sir, we will not keep it here. On the various issues discussed above, in my view, the appellant has not been able to make out any case to justify claiming of input tax credit for coolers so and so. On the issue of 180, the appellant may have had a case had he brought on record to confirmation from the supplier. Yes. In spite of that, there is no confirmation with the appeal for tribunal. He could have brought it here. No, there's nothing. When the supplier had debited him with the sale price, it was on him to issue a credit note. That's a question. Now let's come to one question of law. What is the appeal of my friend? Let's discuss. We will first take power plant. That's a bigger question for the audience to hear. We all know electricity is exempt. A pattern legislation code says its exemption. So what is the factual matrix of this particular case of Rahul? Is that they are a steel company, they manufacture steel, they make taxable supplies, they have constructed an in-house captive power consumption plant. But power under Power Act, you cannot supply to yourself except through gensets. You have to construct a power plant, Ministry of Power has to give you a license. Based on this licensing, these wheeling and banking agreements are entered into. So what is this agreement? Agreement is Rahul constructs a power plant, right? The entire power has to be supplied to me first. So there's the outward supply. This supply, whatever units he has transferred to me on day-to-day basis, this I put in his bank, NDPL or BSES. From there, whatever he generates, I charge them. You got my point? So there are two supplies, not one. Had he not supplied to NDPL, it was a different issue.
Sir, I beg to differ.
Yes.
In the wheeling and banking agreement is a specific term used under the Electricity Act, which provides for that you have an excess electricity, you deposit it there.
Correct.
It doesn't amount to supply. You need electricity, you draw from there. Like my bank account, I have 5,000 rupees, don't need it today, deposit it. That doesn't mean that I'm lending it to bank.
No, Your Honor, in this case, the agreement is different.
What wheeling and
Your Honor, I have done Reliance Energy cases, wheeling banking, even in the electricity tribunals. So I have the complete knowledge on this issue.
My lordship, but here our agreement is different, and that is why we are stretching on wheeling and banking.
Wait. Now, let us say we agree with your point. For an argument's sake, though I'm not agreeing at all with this issue. The agreement there is, as recorded in the documents, electricity is first given to NDPL. They take back from NDPL, right? So when they supply, there is no tax. It's free. When they take back, that is also exempt supply. ITC is ruled out.
No, sir, it's not a supply at all. It is just putting it as if in my this pocket. This is my
No,
bank
no, no,
account.
no,
This
sir.
is
No,
my
sir.
electricity
No, sir.
supply.
No, sir. No,
My lordship, I would just like to put
Wait,
something-
Rahul, let me finish it.
No, sir. On the serious ground, I would just like to put
No,
you
no,
my view.
I'm giving you a judgment.
I read that
Did you-
judgment, sir.
Wait. Which judgment you have read? Tell me.
Sir, please go ahead. I'll tell you.
me
I
judgment,
remember
no?
when you had specifically mentioned me that please read the judgment.
This is Kanishk Steel Industries Limited, Tamil Nadu. This Appellate Advanced Ruling Authority has passed a 40-page order. Exactly, the case is from that ruling. That's why we wanted to test, do we know 16.1, 17.1 to interplay? It's exactly the same case, same facts in this order. You can read this, you can pass the judgment later, next tribunal, we have no issues.
Sir, can you please read the gist of it? I'll tell you where we are having a difference of opinion here.
No, I don't have to read. You can take this on record.
Can you just read a gist for the...
No. Okay. I'm going to read their ruling only, not
please
the gist.
Please do, sir.
Their ruling only.
Yes.
Second issue, when you construct a plant, it is barred under section 17.5. It is immovable property.
Except plant. Everything is immovable property except plant.
No,
that
no.
you have to bear in mind. And here it is a electricity generating plant. When it says plant and machinery, so this is a part of the plant. It's not an immovable
Yes, sir, we're coming on that. We'll answer that question. That is an exception, plant and machinery. We'll answer that question to you. We'll definitely answer. Let's take up this legal issue on this particular issue. Electricity they produce is transferred to an agency contractually. This is a contract. And this is a statutory contract, not a private contract. The Electricity Act 2001 requires it to be done. Jan company shall receive electricity produced, which is a fact in the mentioned in the order, and give credit to the appellant based on what electricity is consumed and charge for the rest. This is what your argument is. Capital goods, they need to be capitalized. If they are capital goods, there is no assertion anywhere to what they have done with it. And we say these are capital goods. If there are capital goods, they are out of definition of goods. Inputs do not include capital goods. You can go through definition of inputs. If they are capital goods, no, sir, no doubt, sir.
Inputs include capital goods.
It doesn't include. Read definition of input. Input means any goods other than capital goods.
Then there must be credit for capital. Okay, 16.1
Sir, there can be credit wherever. We are talking of this case. We are not making out a new case here. What do you want now?
16.1, just 1 second.
Those are definitions, sir. We're talking of definition. We talk of inputs. Input is defined to exclude capital goods.
Okay, capital goods, I got it.
Input.
Capital goods means goods.
No, sir, first input, sir. Capital goods को छोड़ दीजिए आप input की definition देखिए ना. Input 259, surplus 59.
Got it.
Input means any goods other than capital goods.
Used or intended, yeah.
Right?
Yeah.
So 16.1 will not give them ITC if these are capital goods.
It will give. It will give.
How? How will it give,
I will
sir?
take you to 16.1.
हाँ, पहले sir. 16.1
Says
million.
every registered person shall, subject to the conditions and restrictions as may be prescribed in a manner specified, be entitled to take credit for input tax charged on the supply of goods or services or both to him, which may be used or...
has kept it out. No.
It's kept it out, sir. Capital goods are not there.
He
Anyway,
gets-
sir, you can take a view. Let's finish this case first. Otherwise, we'll be...
But he gets a credit for capital items purchased and used for the furtherance of...
No, sir, we are talking of capital goods. We are not talking capital items. There can be air conditioner, there can be cars, there can be trucks. We are talking of capital goods. And this is a plant here, not capital, it's a full-fledged plant. We'll come on this further, sir. Then we say whether this is immovable property, the answer is yes. Power plant is not immovable.
Yes. Plant is not a immovable.
You are not talking of power plant, sir. I'm not talking of plant. I'm talking of a power plant.
Even power
It has to remain fixed.
Even a power plant, so long as it is a plant used for a dedicated
You know what is a power plant? It's not a plant.
It is not a.
So then tomorrow we'll say if we install a furnace that will not be immovable.
It will not be blocked under section 17(5) because that it says building immovable property is disallowed, but plant.
But sir, उसमें भी आएंगे. Just wait. I have all these questions which Honorable Tribunal can answer. Can raise on us. Then 16(1). Whether it's in the course of furtherance of business, this particular captive consumption. Then only for taxable supplies it must be read with section 17. 17(5) C and D. This I am reading from the judgment only. Further, the primary condition of mailing ITC stated under 16(1), where the taxpayer is entitled to credit of input tax charge on any supply of goods and or services made to them in furtherance of business, subject to conditions and restrictions as specified in 16(2) and 17. Quoting 17(5)(c), section 17(5) of the Act, the appellant stated that solar power plant is an equipment machinery fixed on earth by foundations. Your plant, case plant and machinery. Wait, sir. This is the argument of the appellant in that case also. Let's hear me out. Foundation are directly used for making supplied of steel. Accordingly, the solar power plant does not fall under the category of immovable property.
Yeah.
The question,
that's
no,
what
sir.
I wanted.
Sir, it's an argument. There's no finding. Wait for the finding. But the explanation of section 17 to avail credit on capital goods, cost must be capitalized in books of accounts, which I'm sure they would have done, so I will not raise that question, without considering the GST, and further it should not be an immovable property as explained in 17(5) of the Act. Therefore, in the instant case, solar power plant that has been planned to be installed, capitalized in books of accounts and the category of plant machinery in fixed as a register. उन्होंने एक plant machinery दिखाया GST का claim करने के लिए. When we go further, the electricity is consumed in the factory by way of transfer of electricity generated from solar power plant to that particular agency shall provide the credits for energy generated which shall be adjusted against the actual energy consumed in the factory. Accordingly, electricity bills shall be generated by the company, wherein the actual consumption of electricity in factory shall be stated and shall be reduced by the electricity produced by a solar power plant installed in the applicant. Further, there is no banking agreement. The applicant is informed that the cost incurred for installing solar plant to make the present condition and use shall be capitalized in their books of accounts and included in the fixed assets register of the applicant. The applicant have entered into an agreement with so-and-so for usage of the energy generated from the solar power plant, wherein the electricity consumed in the factory by way of transfer of electricity generated from solar plant and further shall provide the credits of energy generated which shall be adjusted against the actual energy consumed in the factory. Accordingly, electricity bill shall be generated by the company, wherein the actual consumption of electricity in the factory shall be stated and it shall be reduced by the electricity produced by the solar power plant, which is solar power policy of the Ministry of Power, installed by the applicant. Further, there is nothing to store when surplus of deficit, if any. Thus, the credits were given to the applicant for the exact energy generated by the plant. As per section 219, 219 deals with works contract. Let's go through the definition. इतना simple सा ना केस बनाना है सर.
219 तो कैपिटल goods का 219
Yeah,
119.
My Lordship, my learned friend here is trying to mislead the court here. The case is very simple and he is trying to put Einstein's theory, which I am not able to understand.
No, I don't think you can really understand. I fully agree with you. The kind of story you have cooked up, even I can't understand. So, Your Honor, 219 is capital goods, right? 219 we have done capital goods. Capital goods means etc. We can skip it. Further, the primary condition of claiming ITC 16(1) with the taxpayer entitled to credit input tax charge on any supply of goods and so and so, serving made to be in further of business subject to conditional restrictions so and so. Quoting section 75D of the Act, the applicant stated solar power plant is an equipment machinery fixed to earth by foundation and are directly used for making taxable supply of steel. Accordingly, the solar power does not fall under the category of immovable property. This was the appellant's argument, but my lord is raising the question.
I fully agree.
No, this is for tribunal to agree, but let's make our submissions. Whether at the end you will agree or not, that's a very different question. Because if the judgment is preempted, then we stop arguing. Then the honorable tribunal should be slow to make this comment when I'm on my legs arguing.
If argument from the one side is so clear that it does not require any counter argument, then I think
then you are not left, then it's allowed. You don't want to hear us. But that means you have already given decisions, so no fun arguing before the honorable tribunal. Because the tribunal should be slow to preempt decision making, Your Honor. Okay, we'll go through, Your Honor. Thank you so much. We will not take your further time. By the explanation to section 17, to avail credit on capital goods, cost must be capitalized in the books of. This is the judgment I'm reading. I'm not saying absurd. The appellant contend that ITC on installation of solar plant, being a plant and machinery and maintenance of such solar plant from which electricity is generated, consumed fully for capital consumption, is an eligible ITC so and so. These are the arguments of the appellant counsel. Now, what does the court say?
The court says that these arguments are emerging from the SCN. And in the SCN, there is no such question that this particular power plant is a immovable property.
Your Honor, is covered 17.5C, is written there in Shokan notice.
Simply by writing the 17.5C doesn't mean that it is a building. Whereas the foundation, as you are mentioning, is a part of the plant, and it's a very decided case.
Your Honor, first I'm allowed to speak. We will take you back to Shokan notice, it's written there.
But now,
it is the argument of them, this is not immovable property.
If you speak something,
शुक्लां ब्रह्म विचार सार परमा माध्यम जगत व्यापनिं वीणा पुस्तक धारणिं अभयदां जाड्यान्तिकारपः अस्ते स्फाटिक मालिकं विदददे पद्मासने संस्थिता वन्दे तां परमेश्वरीं भगवतीं बुद्धिं प्रथम शारदम। अपने इष्ट देवता खाटू नरेश का ध्यान करो। ओम कस्तूरी तिलकम ललाट पटले वक्षस्थुले कौस्तुभम नासाग्रे वरमुक्ति कंकरतले वेणु करे कंकणम सर्वांगे हरिचंदनम सुललितम कंठे च मुक्तावलिम गोपास्त्रीं परवेष्टतो विजयते गोपाल चूड़ामणिम। बोले खाटू नरेश की जय। अपने इष्ट देवता का ध्यान करो। शशिना च निशा निशिया च शशि शशिना निशिया च विभाति कर पैसा कमलम कमलेन पया पैसा कमलेन विभाति कर मणिना बलयम बलयेन मणि मणिना बलहेन विभाति कर भवता च सबा सबया च भवा भवता सबया च विभावो वयम। बोले खाटू नरेश की जय। बालाजी महाराज का ध्यान करो। ओम मनोजवम मारुततुल्य वेगम जितेन्द्रियं बुद्धिमतां वरिष्ठं वातात्मजं वानरयोथमुख्यं श्रीरामदूतं शरणं प्रपद्ये। बोले बालाजी महाराज की जय। मंगल तिलकम गुरियादम हरियम ओम भद्रम कर्णे विष्णुयाम देवा भद्रम वज्रमाक्षवीरजत्रा इतरैरंग इतदृष्टवागं संतनो वीरयसे महि देवहितं यदायो शतमन्युसर्दो अन्त्रदेवाय त्राण सक्राजर संतनो नाम्य वत्रासो यत पितरो भवन्ति मानो मध्यानिधि कर्तार्युगन्त अदितिदौरदितिरन्तरिक्षमर्दितिर्माता सपिता शपुत्र विश्वेर्देवान् अर्दितिर्पञ्चजनार् अर्दितिर्जातमर्दितिर्जनित्वम् हम जाऊ हौ शांति अंतरिक्ष गं शांति पृथ्वी शांतिराप शांतिरोखदय है शांतिर्वन वनस्पतयः शान्तिर्विश्वेर्देवाः शान्ति ब्रह्म शान्ति सर्वगं शान्ति शान्तिरेव शान्ति सामा शान्तिरेधि सुख शान्तिर्भवतु वर्यं ओम कस्तूरितिलकमललाटपटले वक्षस्थूले कौस्तुभं नाशाग्रे वरभक्ति कंकरतले वेणुः करे कंकणं सर्वांगे हरिचन्दनं सुललितं कंठे च मुक्तावलिं गोपास्त्रीं परमेष्ठतो विजयते गोपालचूडामणिं हरिं तिलकं कुर्यातं भद्रं कर्णे विष्णुयामदेव भद्रं वत्समाक्षभिरजित्रा देवहितं यदायु स्वस्ति साम्राज्यं हरिं स्वस्ति वादनं पडेदं हरिं अनुभद्राः कृतवो यन्तु धृतो दब्धाशो अपरिताशो दुविदः देवानो यथा शतमिदव्रते असन्न प्रायो रक्षितारोर्दिवेर्दिवेर्देवानां भद्रासुमतिरुचितां देवानां गङ्ग्रातिरभिनो निवर्ततां देवानां गङ्शकमुपसेति मा वयं देवान् आयुप्रतिरन्तो जीवसे हरिमणुं सुना सरस्वती नासवघं स्करत तन्नो वार्तार्मयो भुवातु वेगजन्तन् माता प्रतवी तद्विदा दौहव तद्रगामाण दिष्टयायुं मैं तमिसानं जिन्मं वसेहुमये वयं मैं पूखानो यदवक्षितार्वायुरतब्धः स्वस्ति न इंद्र वृद्धश्रवाः स्वस्ति न पूषा विश्ववेदाः स्वस्ति न तारक्षो अरिष्टनेमि स्वस्ति नो बृहस्पतिर्ददातु प्रकटश्राम मरुतः पुष्णिमात्रः स्वं यार्वर्णो विदर्थेर्घो जग्मया अग्निजिह्वः मनवः सूर्यचक्षुषो विश्वनोर्देवा अवसागमन्यभद्रं कर्णे विशृणुयाम देवा भद्रं पास्तमाक्षभिरजत्राः स्तरैरङ्गैस्तृष्टवागुं सस्तनो वीरयसे महि देवहितं यदायो शतमन्युसर्दो अन्त्रदेवा यत्रान्न सक्रा जरसन्तनो नाम मे पुत्रासो यत पितर भवन्ति मानो मर्ध्यादिति कर्तार्युगन्तो अदितिदोरदितिरन्तरिक्षमर्दितिर् माता स पिता स पुत्रे विश्वेर्देवार् अर्दितिर्पञ्चजनार्धार्थमर्दिति जनित्वं मे दौहौ शान्ति अन्तरिक्षगं शान्ति पृथिवी शान्तिराप शान्तिरोगदयः शान्ति वनस्पतयः शान्तिर्विश्वेर्देवाः शान्ति ब्रह्म शान्ति सर्वगुं शान्ति शान्तिरेव शान्ति क्षमा शान्तिरेधि यतो यथा समीहसे ततोर्नो अभयन्न कुरु सन्न कुरु प्रजाभ्यो भयन्न पशुभ्य सुख शांति श्रीमन्महागणाधिपते नमः। हाथ जोड़ के गणेश जी महाराज का ध्यान करो। ओम समकस्य कदन्तस्य कपिलो गजकर्णकः लंबोदरस्य विकटो विघ्ननाशो विनायकः धूम्रकेतुर्गणाध्यक्षो बालचन्द्रो गजानन द्वादशैतानि नामानि ये पठे शृणुयादपि विद्यारम्भे विवाहे च प्रवेशे निर्गमे तथा संग्रामे संकटस्य विघ्नन्तस्य न जायते शुक्लाम्बरं धरं देवं शशिवर्णं चतुर्भुजं प्रसन्नं वदनं ध्यायेत् सर्वविघ्नोपशान्तये अभिसिद्धार्थसिद्धार्थं पूज्यतो ये सुरासुरैः सर्वं तस्मै श्रीगणाधिपते नमः। ओम श्री लक्ष्मी नारायणाभ्यां नमः उमा महेश्वराभ्यां नमः वाणी गर्भाभ्यां नमः सची पुंद्राभ्यां नमः मातृपितृषण कमलेभ्यो नमः इष्ट देवताभ्यो नमः कुल देवताभ्यो नमः ग्राम देवताभ्यो नमः स्थान देवताभ्यो नमः सर्वेभ्यो देवेभ्यो नमः सर्वेभ्यो ब्राह्मणेभ्यो नमः शैकुल पुत्र देवताभ्यो नमः एतक्रम धारिता श्री खाटू नरेशाय नमो नमः। संकल्पम कुर्यातम दक्षिणा रख लो हाथ में और संकल्प सीधे हाथ में अक्षत पुष्प ले लीजिए दक्षिणा रख लीजिए खाली हाथ संकल्प ना ले लो जी जल ले जल ऊपर नाम से जागरण नाम कुछ शाम शाम ओम बोलो ओम विष्णु 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 ओम तत्सत विष्णु 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 परमात्मने श्वेतवारा कल्पे जम्बूदीपे वरदखंडे आर्यावंतर्गत देशी यमुना चेवो पश्चिमोत्तर दिल्ली महानगरे नजफगढ़ क्षेत्र मरियमर धर्म प्राग्नाम संवत 2082 सालिवान सागे 1946 मासा मास उत्तमे मासे प्रवर्तक मासे हरिओम ज्येष्ठ मासे शुभे शुक्ल पक्षे शुभ चतुर्युम द्वादश्याम वारादिपन्यक वासरहन विदरियम में शनि वासरम क्रियम अमक गोत्र अपना अपना गोत्र बोल लीजिए उच्चारण कर लीजिए अपना अपना नाम बोल लीजिए शय कुटुंब से शय परिवार से शय कॉलोनीवासी इष्ट मित्राणाम हरिओम में श्री सावरिया श्याम सावरिया मंडल तृतीय जागरण निमित्त आवा विद्यमान ज्योत प्रचंड निमित्त पूजनम स संकल्पम जय अहम करी से ओम जजाग्रत दौरम दैति देवम ततो सप्तस तथैवैति दुरंगम ज्योति खान ज्योति रे तन्मे मन शिव संकल्पमस्तु वाम स्तरे में बाएं हाथ में ले लीजिए सीधे हाथ से दो छाड़ छोड़ने थाली में थाली नहीं हो दोना ले लीजिए दोना ले लो दोनों में छोड़ते रहना, दो छावनी छोड़ना, ज़्यादा भर के मत डालना। लो जी, हरियम आप थाली में छोड़ना, आप भी नजदीक हो, थाली में छोड़ देना। ओम गणानंद गणपति गंगवामहे प्रियानंद प्रियपति गंगवामहे निधिनंदा निधिपति गंगवामहे वसम अहम जानिकृतमातमजासिकृतम में अम्बि अंबिके अंबालिके नमान्यति कसनस्पति गंगाम्बीलवासनमं श्रीमन्महागणाधिपते नमः। ओम पारस्वाणी नमस्तभ्यं पद्मिनी जीवनायक यावत् कर्म समाप्ति तावत् त्वं सुश्रुम कलश देवताभ्यो नमो नमः। ओम ब्रह्मा मुरारी त्रिपुरा